Good morning. Thank you all for coming. I'm so excited that so many people were able to make it to this wonderful symposium. The construction industry has had a profound impact on the economy, on how we interact with each other, and on the environment. It affects every member of society, influencing productivity and well-being at home, at work, and at school. And it has largely been overlooked by the legal academy. We hope that this symposium will begin to change that. This symposium would not have been possible without the tremendous efforts of a number of people that I'd like to thank. Professor Carl Serco and Justin Gunderman did a lot of the heavy lifting. This was their brainchild, and it has finally come to fruition, and it's so exciting to watch. IT has been tremendous. Bob Wheeler, Randy Thompson, absolutely rose to the occasion and made it happen under tough circumstances. And finally, development has been instrumental in making this all happen. Tori Gaddy and Aaron Feller really helped to put this together, and we are tremendously thankful and grateful to all of them. And I'd also like to acknowledge our two keynote speakers, Sir Vivian Ramsey and Mr. Philip Brunner. We are extraordinarily delighted to welcome you to the Arkansas School of Law. Thank you so much for allowing me to do this introduction, and I will now pass it along to the editor-in-chief of our law review, Taylor Spillers. Welcome, Taylor.
Okay, thank you, Dean Allen. My name is Taylor Spillers. I'm the editor-in-chief of the Arkansas Law Review. And first of all, I just wanted to thank everyone for coming, both in person and online, and all of our speakers who drove in from other places and flew in. It is great to have everyone together. As you know, the Law Review attempts to hold a symposium every year. And I say attempt because we know the last 2 years have been a bit unprecedented, but we are here today. And I just wanted to take a minute and provide a brief update of the Law Review for everyone, because symposium simply wouldn't be possible without the success of the journal. And I'm happy to report the journal has had a very successful year. We currently have 50 members on the Law Review, and last month we selected the editorial board that will take over in June, and they're very excited, and some of them will be joining us throughout the day. Next month marks the 75th anniversary of the Arkansas Law Review, which is something worth celebrating. 7 of the speakers you'll hear from today will be published within that 75th edition as well. Secondly, we got a new space in the law school, which is very exciting, and it'll be great for the Law Review to get together and come up with some great works to publish. Lastly, we've revamped Arkansas Law Notes. For those of you who don't know, Law Notes is the online companion to the Arkansas Law Review and features short essays and responses by law professors, judges, practicing attorneys, and current law students. Essentially, the goal of Law Notes is to publish works from attorneys in the field. It's to publish works that are relevant to everyone in their daily practice. Madison Miller is our current Law Notes editor and has gone above and beyond this year. In the 6 months before Maddie took over, Law Notes had only 47 downloads. But after Maddie's leadership and networking with Arkansas attorneys, Law Notes has increased from 47 to 2,726 downloads in just 6 months, which is very impressive. All that to say, the journal is thriving and we appreciate the community's involvement in its success. Without it, events like Symposium would not be possible. With that, I'd like to hand it over to Justin Gunderman to talk about our symposium. Thank you.
Good morning. My name is Justin Gunnerman. I am the symposium editor of the Arkansas Law Review. It's great to see you all here. Thank you for braving the weather yesterday and making it here. I know some of you had to travel. Thank you to all of our speakers who were able to make it here despite all the inclement weather. As Taylor said, it's been kind of a rocky 2 years to get symposium back. My last symposium, or our last symposium, was my first semester of law school. This is my last semester of law school. So just to give you a time frame of how long it's been since we've had the symposium, but it is an important institution to engage in academic ideas, engage in legal ideas, and to provide substantive articles to the Arkansas Law Review, like Taylor said, some of which will be published this summer in our 75th edition. I'm not going to take up too much of your time because I'm going to let Professor Serco talk a little bit more about what he expects of this symposium and a few housekeeping items. But thank you all so much for being here, and thank you all who are on Zoom as well for being here. Thank you.
Thanks, Justin, and thanks to our marvelous Dean for coming in on in a difficult circumstance by Zoom. I don't know how many of you know that we have a brand new Dean, and we thank you very much, Elena, for your efforts in support of the symposium. Now, I want to, of course, echo all the thanks from the Dean, from Taylor, and from Justin, and to everybody else who worked so hard. Grateful to all of our speakers for traveling in, taking the time to share their expertise. I also want to just take a moment to recognize that we are all living in a troubling time with the situation in Europe. And for lawyers who might be interested in pro bono assistance, there's a sheet about a clinic for Ukrainians in the United States who may need some immigration support. But there are also, if you check with our legal clinic, there are other ways that lawyers in particular can make a contribution. So there's some information in the front here, some books that have to do with construction law and flyers that have to do with construction law, but also one about a special pro bono service. Now, pulling this off has been a little bit like a construction contract, a project in itself with multiple participants undertaking distinct roles in interrelated scopes of work, operating in a context of high uncertainty and constant change. They're all committed to delivering a quality project in accordance with some detailed plans, but subject to a tight budget and a demanding completion schedule. So thanks to the collaboration of everyone involved and the coordination, I think we are on track for delivering a quality project on time and within budget, although, Dean, I do not promise the within budget part. We do have a few housekeeping matters to keep things running smoothly. First, of course, everyone will be interested in lunch. If you're in the auditorium here, you'll find lunch out at the tables, and you should have received a ticket. I don't think we'll run out of lunches because so many people did switch to the Zoom alternative. But if you didn't get a ticket, get a ticket out in the lobby so that you are sure to have a lunch dedicated to you. If you didn't pre-register, you won't have a ticket, but I think we'll be fine. Speakers, we have our lunch upstairs, one floor in the faculty center, third floor, top of the staircase here. So if you're seeking continuing legal education, if you're here in the auditorium, the forms are out at the registration desk. You just fill it out. There's an evaluation form. For those of you on Zoom, we explored a number of metaverse alternatives, but we couldn't get lunch to you, so you're on your own for lunch if you're on Zoom. But you do have a special form for CLE credit. There will be a code word. This is Arkansas CLE credit for purposes of distance education. At every segment, we need to give you a secret word. And so you don't need it if you're here in the audience, but if you're on Zoom and you seek credit, near the end of each segment, there will be an announcement of a very highly secret word that you will need to enter on your evaluation form. So please pay attention to that. For those on Zoom, this is a live stream, not an interactive broadcast. And so you can't chat and you can't submit questions in the Q&A feature, but please, if you have questions, direct them to C-Circo, C-C-I-R-C-O @uark.edu. Again, it's C-Circo @uark.edu. I will be monitoring it on my computer, and we'll try to get as many questions answered. Of course, in the audience, we'll have some opportunities, but some of the panels are tight on time. So it may be necessary for speakers to address questions during breaks, or for me to ask a speaker, would you mind responding to this by email afterward? We'll figure that out. So it's my honor and pleasure now to get us started with our first panel. Each panel today, there are 3 panels and 2 keynote speakers. Each panel involves a relatively broad theme relating to construction law. And then we'll have speakers in that panel talking primarily about that theme from a legal practice perspective or an industry perspective. And then we'll have others in the panel talking about it from an academic or scholarly perspective. The whole theme of this program is construction law in the legal academy. When I started, I thought the real problem, and I still think it's a serious problem, is that the legal academy and legal education needs to give greater attention to the construction industry and construction law. Having read the marvelous scholarly papers that we have today, I now believe it works in the other direction, and it wouldn't hurt the construction bar to pay attention a little bit to what the academics have to say. I know we're impractical, but we may be forward thinking in some regard. The students are laughing about being impractical. Yes, it's true. So the theme for this first program is design professional liability from a practitioner's perspective and legal perspective for sure, but also the design professional's responsibility and opportunity for serving the public and social justice. So I'm going to introduce our panelists in the order in which they speak, and then they will just proceed one to the other. Mark Schneier has served, Mark Schneier is our first speaker, has served since 1983 as the attorney editor of Construction Litigation Reporter, published by West. Prior to that, he practiced in San Francisco, and he's authored or co-authored several books, a couple of them are here at the display table, and numerous articles on construction law. He previously served as an adjunct professor of construction law at the University of San Francisco School of Law. He earned his BA in philosophy. I also have a degree in philosophy. We'll have to chat about that. From the University of California, Berkeley, and his JD from the University of California, Davis. Mark's presentation explores aspects of design responsibility liability with an emphasis on how standard design agreements respond to liability risks. Our second speaker, who coordinates, connects nicely with Mark's presentation, but on a public policy basis, is Professor Shelby Green. Professor Green is the Susan Taxon Bayer 85 faculty scholar at Pace University, Elizabeth Cobb School of Law. She's a graduate of the Georgetown University's Law Center, previously practiced with the firm that was then known as Nixon, Hargrave, Devins, and Doyle, now Nixon Peabody, in Rochester, New York, and Washington, D.C. She has a long history of serving the community through her pro bono work. She's a member of the American College of Real Estate Lawyers, and in her work for the American Bar Association, she edits the Keeping Current property column for the Probate and Property magazine. She's been instrumental in programming for the ABA, the Professor's Corner webinar. At the Hobbs School, she teaches property, historic preservation, real estate transactions, and finance, and is counsel to the Land Use Center. Her paper for the symposium proposes that communities should be designed with reference to the threats of climate change and evolving notions of equity and fairness. Now, Professor John Folan has not joined us. He perhaps had trouble getting here. Professor John Folan is head of our school Department of Architecture and would have made a nice compliment to Shelley's presentation. We'll see if he gets here in time. I'll save his introduction just in the interest of time. And then finally, for purposes of reaction, and I believe, Mike, for purposes of creating a little trouble, right? We have with us Mike Johnson, Associate Vice Chancellor for Facilities Emeritus and Professor Emeritus here at the University of Arkansas. He previously served as Rear Admiral in the U.S. Navy and was Commander, Naval Facilities, Engineering Command, and Chief of Civil Engineers. Prior to his retirement in 2004, after 34 years service, he's been awarded the Distinguished Service Medal, the Legion of Merit Medal, and the Meritorious Service Medal, among others. At the university, he oversaw a design and construction and renovation campaign, the largest in the school's history, that had more than $1.75 billion in value over more than 17 years. And under his early leadership, the sustainability program at the university and later the resiliency program were embedded within the entire campus environment. Professor Johnson will offer reactions to our panelists' presentations that draw from his unique background in engineering, in federal projects, and in state construction projects. So with that, Mark, we're ready to begin.
Thank you, Carl. So before I begin, I'm going to devote 1 minute to the wonderful University of Arkansas Law School students who shepherd us around, and for their benefit, if they have not had the benefit of Dr. Circo's class, 1 minute on construction law. A project has traditionally 3 parties: the owner, the architect or designer, the contractor. The owner owns the land, has the financing, conceives the building that he or she wants built, turns to the architect creates the design, gives the design to the owner turns around, gives it to the contractor to build the project in conformity with the design. So you have two separate contracts, the design agreement and the agreement with the contractor, which is called the general conditions of the contract for construction, or general conditions in short. So if I speak of general conditions, I'm referring to that contract. Second, characteristic of the construction industry is that different trade organizations have created standard form documents or standard form contracts. I'm going to talk about the American Institute of Architects, AIA, and how liability claims have forced the AIA to change, to modify, to change its standard form documents. I can't see the PowerPoint, so we can switch.
No,
No, that's not me.
oh, this is Mark Schneider, sorry.
You're correct.
Well, I'm just going to start. And the second slide, which is the last slide, here I am. So we can just go to the next one. Is as I refer to cases or times, you can just look up there. It'll help you. All right. So the broad contours of professional design liability are well known. Liability can be to the client or to a third party. Claims can be for personal injury or death or for economic losses. And a variety of defenses exist, including in the design agreement itself. So what I want to address today is the role of the standard form design agreement in response to liability claims. Again, I assume general awareness that the design agreement may be a source of liability limitations and disclaimers. How these documents came to be is shrouded in mystery for many. I'm very briefly going to try to shed some light on the origin story of how the standard form owner-architect agreement came to be a source of refuge from possible liability. That origin story, in which the Arkansas Supreme Court loomed large, traces changes by the AIA to their standard form documents in response to construction worksite accidents. I will wrap up by tying that development to the apparently unrelated issue of owner claims against an architect for construction defects. I will finish with a discussion of intentional tort claims brought by contractors against the project architect. But first, a disclaimer. This will be a brief outline of design professional liability. Exceptions exist to most everything I say. The fact that I don't constantly point them out does not mean I think they are unimportant. Construction accident claims in the AIA's response. Why should an architect, by which I include engineers, who has no direct control over the actions of a construction worker, owe a duty of care to injured workers or their estates? This was never an issue until the fall of the privity doctrine in the first third of the 20th century. The replacement of a no-duty rule under the auspices of the privity doctrine with a test for foreseeability to establish the existence of a duty of care was the nexus between the architect's role on the construction project and possible liability to construction lawyers. A baseline understanding of the architect's site services role prior to this fundamental change in tort law can be discerned through an examination of the AIA's 1951 standard form documents. That's the first thing up there. For our purposes, these documents have two key features. Under this standard form of agreement between owner and architect, the owner provided, quote, general supervision to guard the owner against defects and deficiencies in the work of the contractors. Under the general conditions, again, this is the contract between the owner and the contractor, a section titled Architect Status. Do people hear me?
Now.
Now.
People at home are having a little trouble too.
Apparently, people
That's
at
on me.
home on Zoom were having trouble, so hopefully this will help. Okay, hopefully this will help. But we're not as tight on time as I thought we would be because John Foley didn't make it in, so.
I'll slow down.
No, and by the way, this is a good time to mention, we certainly encourage your questions. Yes, we know that time could get tight on some of the panels, but this is intended to be an interactive discussion. And particularly those of you who are speaking in our other panels, we're depending on you to stimulate some discussion, all right?
What's the case that you talked about?
I haven't gotten to any cases yet. I'm at the very top, see where it says on 1951 in the year. Zoom over, so there's no court decision, zoom over to the far side. AIA, that's going to be the changes. So the 1951 is our baseline, and it has two features of relevance here. The architect has a duty of supervision, and the architect has the ability to stop the work, which I haven't gotten to yet, but I'm getting to right now. Okay, so the design agreement, duty of supervision. Under the general conditions, there's a section titled architect status. That combined the duty of supervision with the architect's authority to stop the work. The architect, quote, the architect shall have general supervision and direction of the work. He has authority to stop the work whenever such stoppage may be necessary to inure to the proper execution of the work. In short, in addition to being the project designer, the architect's administrative duties involve supervision of the contractor's performance, backed up by the authority to stop the work. How did the fall of privity affect this industry understanding of the architect's role? Construction accident cases spanning a little more than a decade, from 1959 to 1970, fundamentally altered the architect's role as envisioned in the 1951 AIA documents, resulting in creation of what I'm calling the first AIA modern contract in 1970. I say modern because, notwithstanding maybe half a dozen new versions of since then, the AIA standard form documents of today are in substance, at least for our purposes, unchanged. We get to our first case, a 1959 Louisiana Court of Appeals decision, Day versus National U.S. Radiator Corporation, was the first to reject the privity defense and hold that an architect's supervision responsibility meant it owed a duty of care to the estate of the subcontractor's employee. On a project to renovate a public hospital, the architect had promised the owner to provide, quote, adequate supervision of the execution of the work, expressly including, quote, frequent visits to the work site. This was not AIA language. A subcontractor's employee was killed when a hot water boiler exploded. The explosion happened because, in violation of the specifications, the boiler did not include a pressure relief valve. Professor Justin Sweet, who passed away a couple of years ago, I've been asked about that, unfortunately, wrote that the Louisiana Appellate Court decision, quote, shocked the AIA. He wrote that the court's decision, quote, seemed to require that the architect be present, if not continuously, at least at every crucial point in the construction process, judged from a worker safety perspective. This, the AIA felt, went beyond the proper role of the architect in his contract commitment. While the date decision was on appeal, the attention shifted to the Arkansas Supreme Court. Second case. The 1960 decision, Earhart versus Cummins, involved an excavation cave-in, which killed or injured several subcontractor employees. Here, unlike in the Louisiana case, the architect knew of the danger and acted on that knowledge. He demanded that the contractor replace the job superintendent and threatened to order the work stopped, as he had the contractual power to do. The trench collapsed before any remediation of the safety violations occurred, and the Arkansas Supreme Court deferred to the jury's finding of negligence by the architect. So, as of 1960, two appellate court decisions had rejected the privity defense and found an architect owed construction workers a duty of care. In one case, liability was based on a should have known standard. In the other, the architect had actual knowledge of the hazardous condition. In 1961, the Louisiana Supreme Court reversed the Court of Appeals and held the architect's contractual duty of supervision did not impose upon the architect the duty of care owed to construction workers. In contrast to the Court of Appeals, the Supreme Court interpreted the design agreement supervision requirement as creating a duty owed only to the owner, that the work would comply with the design. The Supreme Court also recognized that how the project was built was the contractor's responsibility. Well, we do not think that under the contract in the instant case, the architects were charged with the duty or obligation to inspect the methods employed by the contractor or subcontractor in fulfilling the contract with the subcontractor. Apparently, even the possibility of increased liability stirred the AIA into action. While the Louisiana Court of Appeals Day decision was not released until 1959, in its 1958 design agreement, The AIA deleted supervision from the standard agreement and replaced it with language emphasizing observation through periodic visits. The AIA also made clear in the 1958 documents that the duty to inspect was not a guarantee or warranty that the work was free of defects. Just 3 years later, in 1961, the AIA again revised its owner-architect agreement. It removed the architect's duty of inspection, instead providing that the architect was to make, quote, periodic visits to the site to familiarize himself generally with the progress and quality of the work and to determine in general whether if work is proceeding in accordance with the contract documents. We'll encounter this same language for the end of this talk. These changes notwithstanding, the 1961 general conditions architect status, this is the owner contractor contract section, continued to grant the architect quote authority to stop the work whenever such stoppage may be necessary in his reasonable opinion to ensure the proper execution of the contract. Yet, the AIA soon had cause to re-examine that language. In a 1967 decision, Miller versus DeWitt, the Illinois Supreme Court stated that the architect's power to stop the work was relevant in determining whether an architect had acted reasonably under the Illinois Structural Work Act. In failing to prevent a contractor from removing supporting columns in such a way that the roof collapsed. The AIA's response was the 1970 edition of the General Conditions, which I'm calling the first modern AIA document. First, this 1970 General Conditions for the contract for construction eliminated the architect's power to stop the work and gave that authority solely to the owner. Second, it created a new article exclusively devoted to imposing site safety responsibility on the contractor. Third, it disclaimed the architect's responsibility for performance of the construction work and for safety measures. Both the architect will not be responsible for construction means, methods, techniques, sequences, or procedures, or for safety precautions and programs in connection with the work, or for and he will not be responsible for the contractor's failure to carry out the work in accordance with the contract documents, close quotes. These changes have remained nearly verbatim with each new edition of the AIA documents, and the risk limiting strategies they adopt for architects has been embraced by other industry organizations' standard form documents. Before leaving the topic of construction site safety, I want to mention two Arkansas Supreme Court decisions issued in 1967 and 1970, which cemented evolution of the judicial approach to worksite accident claims based upon the design professional's duty to be present at the construction site during performance by the contractor. In both cases, the court ruled in favor of the design professional by taking the issue away from the jury, although the Supreme Court in the first case reached that conclusion only after a rehearing. Walker versus Wittenberg, Delaney and Davidson, Walker number 1, involved a commercial project in which the architect was hired by an oral agreement. However, importantly, the City of Little Rock Building Code Section 204 mandated the owner employ an architect to perform specific inspections of the work. The parties also used the AIA General Conditions, AIA A201, 1958, which in Article 38 stated that the architect, quote, shall have general supervision and direction of the work. A contractor's employee was injured when the wall he was standing on collapsed under him when braces were removed. Plaintiff sued the architect for negligent supervision, and the trial court entered a directed verdict in favor of the architect, took it away from the jury. Citing its earlier decision in Earhart, the Supreme Court reversed, finding that the contractual duty of supervision under the general conditions created a jury question as to whether the architect breached a duty of care owed to the plaintiff. The court rejected the architect's argument that his duty of supervision was owed only to the owner and was for the limited purpose of ensuring a completed building was built in compliance with the design. Yet, after granting a rehearing, the court in Walker number 2 reversed and so upheld the directed verdict in favor of the architect. The court refused to impose a duty of safety owed to construction workers absent an express agreement. A duty of supervision did not require the architect to be, quote, present continuously during construction, nor did the architect have the authority or a duty to prescribe safety measures. 3 years later, Heslip versus Forrest and Cotton, the Arkansas Supreme Court issued its final supervision case. In that case, a contractor's employee used a front-end loader with a mobile crane to move a piece of equipment near a high voltage power line, which created an electrical arc. He sued the engineer hired to inspect the work for compliance with the architect's design. Plaintiff argued the engineer was negligent for permitting the use of the crane without requiring the general contractor to insulate the crane or order the overhead line be energized. In affirming a judgment notwithstanding the verdict in favor of the engineer, so again, the jury held for the employee, court reversed that. In affirming the JNOV for the engineer, the Supreme Court did two things. First, it decoupled a design professional's authority to oversee the work from a duty to ensure project safety. In the court's words, and quote, engineers' rights and powers are not to be confused with their obligations and duties under their contracts, close quotes. Second, the court placed responsibility for project safety squarely on the general contractor. It is fair to say that the Louisiana Supreme Court's Day decision and the Arkansas Supreme Court's Walker No. 2 and Heslip decisions, all ruling in favor of the architect or engineer as a matter of law, were exactly the goals sought by the AIA when it created the modern AIA standard form documents starting in 1970. Yet there is also the Earhart opinion, in which a jury verdict against an architect was left undisturbed, where the architect knew of the hazardous condition before the accident happened. Next topic, liability to owner for construction defects. Now I want to give just one example of how the changes to the AIA standard form documents in response to construction accident claims spilled over to other areas of the law of professional liability. Suppose an architect discovers construction defects in its newly completed building. One of its architect's administrative duties under the AIA contract included inspecting the work before authorizing progress payments to the contractor. The owner may claim that the owner performed the inspections negligently, and had it done so non-negligently, it would have discovered the construction defect and ordered the contractor to fix it while work was still ongoing. In other words, the owner is seeking to pin blame on the architect for construction defects caused by the contractor's method of performance, and not for an error or ambiguity in the design. What contract language might the architect turn to as a defense to such a claim? Recall that the AIA had replaced language giving the architect a duty of supervision with language providing the architect would provide, quote, periodic visits to the site to familiarize himself generally with the progress and quality of the work and to determine in general if the work is proceeding in accordance with the contract documents. How would this language created in response to worker injury claims apply to the owner's assertion in our example? In the 1990 decision, Watson, Rutland Architects versus Montgomery County Board of Education, this is up there. The Alabama Supreme Court faced this issue where the underlying contract was apparently derived from the AIA 1987 standard form of agreement between the owner and architect. The issue for the court was, did this language absolve the architect from liability so long as an inspection was actually undertaken, however cursory, or may the owner seek to establish that the inspection did not meet the standard of care? The Alabama Supreme Court refused to view the language as an absolute disclaimer. But it established two rules. First, unless the defect would be obvious to a layperson, the owner was required to present expert testimony as to the quality of the inspection. Second, the architect had the duty to inform the owner of a known defect. I want to make two comparisons. The first, a contrast, the second, a similarity. As to the effect of the modern AIA contract in both workplace accident and construction defects claims brought against an architect. First, the contrast. The architect has no safety-specific affirmative duties. Responsibility for safety is placed squarely on the contractor, and the architect is denied the power to stop the work. By contrast, an architect has the affirmative duty to inspect the contractor's work for compliance with the design. And such an obligation necessarily requires an assessment as to the quality of the work. The similarity lies in the court's willingness to impose liability where the architect knew of the hazardous condition or construction defect. With respect to workplace accidents, the fact that an architect or engineer while on the site actually perceived a dangerous condition is sufficient for most courts to invoke the safety promotion rationale underlying tort law. Again, this traces back to the Arkansas Supreme Court's 1960 Earhart decision. Interestingly, there is one standard form document that recognizes this concern and seeks to codify it in the design agreement. I'm referring here to Consensus Docs 240, which is the quote standard form of agreement between owner and design professional. It imposes upon a design professional, quote, who has actual knowledge of safety violations, an affirmative duty to notify the owner. To my knowledge, no court has interpreted this language, and if anyone knows of a court which has done so, I'd appreciate it if you told me. With respect to defective construction, the quote known construction defects basis of architect liability has been incorporated into the AIA documents. The 2017 design agreement provides, quote, on the basis of site visits, the architect shall promptly report to the owner known deviations from the contract documents and defects and deficiencies observed in the work. Finally, last section, liability for intentional torts. Finally, I want to touch briefly on one theory of design professional liability for which no contractor disclaimer can work. The AIA general conditions list several reasons an architect and owner may terminate the general contractor for cause, but require that before the owner does so, it obtain, quote, certification by the architect that sufficient cause exists to justify such action. The terminated contractor may then sue the architect for intentional interference with contract, claiming the architect had acted in bad faith when signing off on the owner's request. No contractor may disclaim a right to act in bad faith, nor will the economic loss rule, which we haven't talked about, apply to intentional torts. However, tort law of intentional interference claims provides the architect with ample defenses, in particular, the advisor's privilege and the lack of causation. For this reason, no other such claims are rare. Thank you.
Professor Green, we're just moving directly to you. And I do have some information about John Folan, who I can fill in, but please present your paper and then we'll have opportunity for discussion.
Yeah, and the slides.
We'll get the slides going. I think I can do that. If I can't, I'll. Okay.
I see two.
That color look all right? It's,
Yes, it's good.
okay, well then I think we're all right. Tell me just when I should advance.
Okay, well, thank you. I'm so happy to be here to be a part of this dialogue on the on issues that impact so many aspects of the legal regime and society. There's so much to say, and my focus is going to be on housing construction. So much to say about housing construction, legacies, and even climate change. I could just mention a few of the big points. But since I'm on the first panel, I could just delve in depth on everything and talk to like turn blue in the face and keep you here for the rest of the day and for the weekend. So everybody settle back. Just kidding. Next slide. So in case you haven't looked up recently, there's so much going on in the world. We got war, hurricanes, drought, pandemic, protests, even Congress. And they all raise all kinds of issues that require, I think, rethinking about how we navigate our path forward in this world. Next slide. So,
Carl, next slide.
my focus in the symposium is on land use law and policy and housing patterns. They've been precariously out of sync with evolving notions of social equity and fairness, as well as the ecological trend to the natural world. And the two are very much interrelated. We're seeing that safe and inviting communities is the claim of all, that land use policy should not by intention or in fact operate to exclude on account of race, ethnicity, or social economic status. Wisely, we are reassessing the effects of historic discriminatory land use policy, embracing a new urban design concept, one that, if not climate determinist, is climate cognizant. We're seeing that impacts from the built environment and the natural environment can be reconciled in a way that shows regard for climate and social equity. Next slide. So to put these issues in perspective, I'll tell you about a recent grand experiment that went wrong. Brad Pitt's Make It Right project in New Orleans. So it was designed in the lower Ninth Ward after Hurricane Katrina, where thousands of homes and lives were lost. It was a poor community in the bottoms. It was a place that was below sea level and right in the path of the breach of the lake. But the path of redevelopment was slow. Brad Pitt stepped up and he teamed with this renowned green design expert and an investment firm that specializes in sustainable development. Brad Pitt declared, if you have a blank slate and this great technology out there, what better test than low-income housing? So he pledged that $5 million of his own money and others donated monies and firms donated services. They proposed 109 homes for first-time home builders to bring back the community devastated by the hurricane and to revitalize and connect the community. They built a community garden and held regular meetings for new homeowners. So what brought after, next slide. So these plans were based on, I think, lessons learned. So before Hurricanes Katrina and Sandy and Harvey and Florence and Rita, we didn't heed the omens so much, but after their strike, we were able to identify some of the culprits of the disastrous impacts from these events. Poorly constructed and poorly maintained homes built in the path of flooding with no escapes. And most of those affected were renters and the poor. As much as 80% of those claiming federal assistance after the hurricanes had incomes below $30,000. And affordable housing is like the last to be rebuilt in the event of severe weather events. So New Orleans, as so many other cities in the country, adopted new building codes, International Residential Code and the National Energy Conservation Code. So let's next slide. Make It Right's spent about $26.8 billion on the housing and sold them below cost. This is a statement by one of the Make It Right principles. We've cracked something here. These houses redefine affordable housing. This is a proving ground for a bigger idea that could work globally. The project is not mine anymore. It's so beyond me. So there were some constraints on the designers and the project. No house could cost more than $150,000, of which they expected 85% to come from federal government disaster funds. All houses had to be raised at 8 feet off the ground. And because lots were narrow, just 40 feet wide, houses had to also be long and narrow. And they're all required to have hatches in the roof. You recall the images with the floods coming in, people couldn't get out of the attics and someone on top of the roofs is hoping for help to come and rescue them. But Make It Right also had incorporated a number of sustainability features on their design, geothermal systems for heat, solar panels for at least 75% of electricity. And they also hope to return some of that to the grid on sunny days. And materials and equipment were required to meet the strictest environmental standards. Next slide. So here's some images of some of the designs. Here's Brad Pitt. See the solar panels on one house. The interior looks very interesting. House is elevated and very advanced and interesting architecture. The house on the bottom right side. So alas, Brad Pitt's dream became a nightmare, and I'll show you how in a moment. Next slide. So what brought Brad Pitt to the rescue of the bottoms? A long history of exclusion from housing. So before telling the end of Brad Pitt's experiment, I'll make a brief trip back to some dark times, then to enlightenment, and then to hope. It's important to know that housing, in my view, is not just a physical thing, but significantly socio-economic, and political construct. Good and ample housing are places for individual thriving and enrichment, family cohesion, autonomy, economic security. But poor and inaccessible housing means demoralization, bad health, wealth barriers, and family dysfunction. So for most of our history, societies poorly housed have been relegated physically and metaphorically to the bottom strata of the socioeconomic status. There are disparate rates of home ownership, by as much as 30% between whites and people of color in this country. There's a much higher rate of housing cost burden among poor households. Lower income and minority populations are more likely to live in deteriorating and unhealthy tumble-down housing with lead paints, asbestos, and mold. Poor communities are disproportionately located near highways, noxious and industrial facilities. They suffer because they live in older housing without modern systems of heating and cooling. They suffer disproportionately from the urban heat island effect. They pay a higher cost for their mortgages. They tend to live in more segregated communities. They have less access to parks and green spaces. They have fewer trees in wealthier communities. So, next slide. So much of the disparities in housing opportunities in cost, supply, quality, and location can be traced to property, land use laws, and policies, and some in private discriminatory conduct as well. So starting with racial zoning enacted after the Civil War amendments that provided that certain people, namely Blacks, could not live in white neighborhoods. In Buchanan versus Worley in 1917, the Supreme Court did find that such laws impaired the rights of the white owner to sell to whomever they chose, but tangentially, Blacks acquired the right to live wherever they chose. But this seemed a mere pure victory, as individual property owners determined either to refuse to sell to Blacks or agreed between white seller and white buyer not to resell or allow non-white persons, Jews, Asians, and Blacks, to acquire an interest in the property. It was not until 1968 with the Jones versus Alfred Maya Company case, the court ruled that even private discrimination was wrongful as a badge of slavery prohibited by the 13th Amendment. And then Shelley versus Kramer in 1948, the court ruled that private racial covenants could not be enforced in courts as a violation of the due process clause of the 14th Amendment. Next. So it seems that in many instances, private, because of the discrimination between private owners, the public housing was the housing of last resort for so many poor and minorities. But provision of public housing was begrudged and administered in ways that were supportive, not supportive of community and thriving. So as not to compete with private developers, public housing could not be elaborate, just a basic structure. Some said that they were designed to look like prisons. And I think that's the take I would have from the community greens now demolished in Chicago. And the HUD after the long saga of the Gautreaux litigation was held liable for acquiescing in Chicago housing authorities' deliberate segregation of housing in the housing projects. But it took decades for the court to get to that point. Next slide. And then there was urban renewal, which promised to renew urban communities by clearing blighted areas and building new housing. But those erstwhile slums became luxury apartment houses, government buildings, and office towers. In all, the poor lost about 700,000 families were primarily low income and minority were displaced from urban renewal. And then under highway policies, multi-lane highways cut right through neighborhoods, uprooting thousands of individuals, obliterating entire communities, destroying much scenic beauty in the way. It wasn't until the Transportation Act of 1968 that the steamrollers were slowed, but not halted. Under that act, no funds could be appropriated for highway construction until their impacts on the natural and historic areas had been evaluated. But despite this directive, government still tried to build highways in the most inconceivable places, like right through the middle of urban parks. So we do see in recent times some cities moving to block more highway construction, even dismantle highways going through their communities. Syracuse, communities in Wisconsin as well. Next slide. So, and then early federal mortgage policies helped to set up housing and economic inequity by denying loans and mortgage insurance to persons based on where they live. The New Deal program, homeowners loan corporations set up to rescue distressed homeowners, determine eligibility based on color maps. It made loans only to those homeowners who lived in green areas, but not those in red areas said to be infiltrated by Blacks. And the Federal Housing Administration followed suit and determined whether or not to provide mortgage insurance in accordance with the HOLC maps, and also to ensure that communities retain their purity and enhanced value. It required racial covenants in the deeds. Private lenders followed suit with redlining, deciding not to make loans to communities outside the red lines. Those communities were typically communities of color. And even after redlining was found to be a violation of the Fair Housing Act of 1968, lenders went outside the red lines to prey on borrowers' risky and costly lending practices. In the 2008 housing crisis, we saw that most of the defaults were by borrowers with adjustable rate mortgages, and a disproportionate number of these homeowners were people of color.
Can you just say again, this map was an administration's map?
Yeah, the homeowners loan corporation, they developed it for various cities, and if a community had any degree of integration, it was more in the red zones, and HLC wouldn't offer loans to homeowners who live in these communities. And then even as, next slide. Even as racial zoning was struck down, it reappeared in the guise of land use planning with the blessing of the Supreme Court and Village of Euclid versus Ambler Realty in 1926. Local governments were allowed to exclude this is what Justice Sutherland used, parasites, that is apartment buildings and those who occupy them from areas where single family zones were built. So yes, you can build affordable housing in this community, but it has to be a single family structure, and only if the lot is 10 acres or larger. So next slide. Euclidean zoning took on a seemingly iron grip over land use, applying all kinds of tools that kept out certain populations, large lot requirements, minimum setbacks, limits on housing forms, no tiny homes, no manufactured houses, no multi-unit dwellings, to name a few. Sometimes courts were able to see past ostensibly neutrally worded ordinances for what they were, tool for separating citizens by status and race. But the first major challenge to Euclidean zoning is that the Mountain Laurel saga took like 40 years to loosen the grip on communities, determining to keep out certain people based on what they could afford to live. And the reference to the Mahoney versus County of Nassau case of 2016, but of course look past again these fairly neutral statutes, finding that the comments that were code words for racial animus, that we wanted multifamily housing would change the flavor and character of the community, and found that there was a violation of the law. So a few jurisdictions now are responding to the impacts of Euclidean zoning. Like California, Oregon, and the city of Minneapolis have already made giants have outlined single family zoning. Many have adopted zoning measures, both in incentive-based for giving density bonuses and variances and reductions in waivers, and others mandatory exclusionary zoning like set-asides, allowing more greater range of housing styles for households of all income levels and mobility constraints. and allowing greater density by allowing accessory dwelling units along the minimum area involved in infill development. And there's even a growing discussion of state preemption of local zoning altogether. So as with all measures adopted in response to perceived crises, there may be some unintended consequences. And some that immediately come to mind are unhealthy density levels. Maybe too many tall buildings might block out the sun and air. Say a 10% set aside for affordable housing may be overwhelmed by the other 90% sold as market rates. And then it may even spark more gentrification. So how are we responding to the environmental concerns brought by zoning? So housing construction now is not so much about, it's not more than just nails and studs. You know, housing has to be smart, oriented to the sun, away from flooding, designed to resist fierce winds and fire, safe to inhabitants and environment. It needs to be resilient, and in my words, it needs to be robust. So to get to this robust home, there are all kinds of conventions in place, new building and planning codes for going green, new style homes. We have high performance homes involving energy efficient design for health and safety, and also suggests affordability. A passive home involving airtight ceilings and compact designs and sophisticated insulation. There's all green infrastructure, fewer roads, and wider one-way sidewalks, more trees, urban forests, water conservation measures, and pervious surfaces. All measure of things. Yes. So what about the Marshall Fire in Colorado? You see the top image of Superior, Colorado before the fire that took place in December last year, and the image of destruction that was caused. So before the Marshall Fire, the City Council adopted the 2021 International Energy Conservation Code. It required new buildings to be built with certain energy efficiency standards, to have a vehicle charging station, the ability to support solar panels, and it was applicable to rebuilding. So some of the homeowners whose homes were destroyed were just worried about the cost of having to incorporate these new measures as they needed to rebuild, thinking that the insurers will not provide the replacement costs. But other measures being incorporated in other cities in response to recent events include elevating critical systems and elevating the structures themselves, like we saw in the Make It Right project, and incorporating fire-resistant materials and fortifications. After the 1989 Big Tire Fire in the city of Boulder adopted the fire-resistant construction standards for certain areas in the wildland urban interface. And this is an image of a house with a metal roof and flame-resistant siding. And here's an image next of a house in Oklahoma City with a fortified roof to resist earthquakes and severe storms. So, but there may be some myopia involved in these measures, particularly the issue of, next slide, of physical accessibility to the elevated structures. People who are mobility challenged would not be able to have difficulty residing in those structures. And also there may be some lack of citizen participation in community design. So here's some comparison of costs. It's well established that zoning regulations increase the cost of housing. It costs more to buy a large lot than it does a smaller lot. It costs more to build a single family house than it costs to buy an attached house. At the same time, there are significant higher costs of building this robust home. And estimates say that a high performance home may cost from 3 to 20% more than a regular code built home. And a passive home significantly as well. And then there are all kinds of indirect costs. You know, some states even set up surcharges on reporting and to defray the cost of public green infrastructure. Next slide. So the upfront costs are so much greater building this, can be considerably greater building this robust home between It's estimated between $20,000 and $77,000 for a 22 square foot home to build in accordance with the standards adopted in Superior, Colorado. But the savings come at the back end, as much as 75% on energy with the high performance and passive. But other savings include lower insurance premiums and cost of rebuilding, maybe less because the house may not be destroyed in the case of a fire, and some flooding may be averted as well. So, so the nightmare Brad Pitt's Make It Right project, it got LEED Platinum certification. And that's the highest certificate that one can obtain under the LEED standards. It was granted because of the wood cabinetry, use of non-toxic paints, Energy Star appliances, insulation, made it 5 times more airtight than typical homes, and use photovoltaic systems and groundwater heat pumps and other conservation measures. But 10 years, next slide, 10 years later, less than 10 years later, the homes had decayed beyond the point of being almost unlivable. Water intrusion, black mold, rotting porches, collapsing rails, causing fires, electrical problems, plumbing problems, poor ventilation. And some of the design and construction flaws identified including using timber self-construction as opposed to pressure-treated wood, not having rain gutters or overhangs, waterproof painting or covered beams, and all necessary given the New Orleans subtropical climate, using flat roofs that could not hold on to water, causing water intrusion, improper ventilation, excessive plumbing problems. So the result is the homeowner sued Brad Pitt and Make It Right, and Brad Pitt sued the architects, and the insurers are suing the insured, saying we're not, your claims won't be covered. Next slide. Here's some images of what happened to the Make It Right development. See on the bottom right hand side, the porch just collapsed. This is less than 10 years later, and the broken support beam for that really innovative roof. So some takeaways is that we think that homeowners, home builders create structures for living, and city administrators and planners create communities for living. But not all types of structures are suitable for all areas, and not all building inventions are essential for sustainability. Accessible and affordable communities can be built to be green, aesthetically catching, and have low carbon impact and be productive. This requires, I think, an integrative design process with construction and not only the structural components, consideration not only the structural components, but as much about the social impacts as well. Builders of structures and builders of communities must embrace a shared vision about common ends. Builders must not only understand the mechanics of construction, but as builders of communities, construction developments must be preceded by community health and well-being assessments. What can the residents afford? What financial assistance is available? What kinds of spaces are required? Building affordably, resiliently, and green should not mean substandard. That's apparently what happened with Make It Right, this chronically named project. Means that construction housing must have regard for social and economic inequity and environment. So I think we need a new paradigm. Next slide. Building affordably and robustly with citizen involvement, building resilient homes, livable communities, and no Euclidean single family zoning. And we need public and financial support for acquisition.
Thank you very much, Professor Green. Now, I'm not quite sure how to make the analogy between this symposium and a construction project, but I guess I'm either the owner or the design builder. In my classes, I sometimes play multiple roles, so I don't mind being schizophrenic. I am in the process of negotiating a change order. And John Fulham, thankfully, is here. And so we have the opportunity. I'll introduce John. Bob Wheeler is at the controls to get the PowerPoint slide up, and so we'll sort of continue as planned. I will be filing a claim for an extension of time, a brief extension of time. Now, let me introduce to you Professor Foley. Now, he is the head of our Department of Architecture and professor at the Fay Jones School of Architecture and Design. And he's also the director of the Urban Design Build Studio. And through that initiative and some other collaborative ventures, Professor Foley has made a commitment to work with underrepresented communities on the development and implementation of catalytic projects through participatory design processes. His work prioritizes public interest, social justice, and equity as a productive end. His work has been published widely and exhibited internationally and has been recognized with numerous American Institute of Architects awards. And his work, as I think you probably have figured out by now, has much in common with Professor Green's presentation. And in sharing his current initiatives with us, Professor Foley will provide an architect's perspective on public policy and social aspects of design and construction. And I think, Mike, your job will then be to tie the practical lawyer's perspective on design professional liability with the discussion that Professor Green and Professor Foley bring to us. So get prepared for that, all right? So John, whenever we're ready with the slide presentation, we will
While he's transitioning, I've just previewed two questions that I'd like for you to consider. Number one, I mean, have we ever lived in a time where people trade a third or a half of their professional lives for a house? I mean, is a 30-year mortgage too much? I mean, you're talking about affordable housing, and I'm not criticizing it. I'm just saying, you know, my maternal grandparents who lived in this town in 1949 bought their house right around the corner from where Mike lives. Now we're trading off 30 or 40 years of our professional lives to buy a house, and it just seems that it's disproportionate. So that would be one issue, and then another issue relating to the code words you were talking about in the case. So let's just presume someone is living in a university town, and there's a very smart neighborhood with an active listserv and uses code words like, you know, the flavor. We don't want to change the flavor of the neighborhood, but let's presume they're not talking about Black people or Hispanic or Latino, but they're talking about students. I mean, isn't it? I guess the question is, does it matter whom you're, you know, maintaining the flavor against?
Well, if the object is to exclude people based on race or ethnicity, then that's something to be concerned about. But historic and cultural character and amenities, I think, is something that most communities would want to preserve. So it's just a matter of how you read the language. And in that case, there was an old building used for social services that the town decided to go to affordable housing, but the community just up in arms. So there was no other community flavor, architectural flavor, historic character to preserve. It was just an objection to bring in people who would need to live in multi-unit dwellings.
All right, thanks, Vince, and Professor Green. We are taking questions. We're delighted to make this interactive, so I want to encourage that, but we also want to try to stay on the schedule that I've committed to. And I do apologize for my own interrupting behavior, but it is quite thin to manage this when we've got a lot of people on Zoom and then folks that here. Do you want to give me the code word now, or do we take it later? For those, you don't care in the audience here, but as I said, for purposes of CLE credit for virtual attendance, our people need to know the code word Razorback. Isn't that clever? So the code word for this session is Razorback, and I will try, with the help of our student moderator here, to repeat this a little later. Thank you.
Spell it, razor.
Oh, they know how to spell it. All right, John.
Thank you very much, Carl. I apologize to everybody for arriving late. I've been tending to a family medical emergency this week. Anyway, I appreciate you accommodating my schedule this morning. For those of you in the audience, I think probably gives you another good anecdotal observation to make about architects. As we know, professions oftentimes have jokes about one another. And I was on a selection committee for law school expansion in addition at the University of Arizona. And when we broke for lunch, I was the only architect who was on the panel. The subject of lunch was making fun of architects, sharing bad architect stories. So I got a bit of a lens into that. So hopefully this doesn't contribute to that today. As Carl mentioned, I am the head of the Department of Architecture at the Fay Jones School. We are located kitty corner from the law school, and I arrived here in 2019 and have been speaking with Carl and others across campus about an initiative for the University of Arkansas to expand its role and its ability in the development of a housing innovation center, which has been titled the Arkansas Home Lab, which that name was officially approved in January and will be moving forward. So I'll talk a little bit about the formation of that and what's informed that, and some of the considerations, and I think those tie in well with things that Dr. Green was speaking about just a moment ago. The imperative question that's up here: what does it mean to be the Fay Jones School of Architecture and Design in 2020? What should be, must be the work of the school in 2020. That slide has been used since that date, obviously 2020, we're in 2022, and I think the imperatives and the questions keep expanding. The one that we're specifically speaking to today is the housing crisis that exists not only in this region, but throughout the state, across the nation, and globally. So what does it mean to be a school of architecture and design in the middle of one of the nation's leading high growth, high population, low density regions? And that's the question that we're raising as part of this Arkansas Home Lab. The idea in forming this is that we bring together the strengths and the capabilities of a Research One university across the different academic units, from law to engineering to business, and all three allied disciplines of design in the Fay Jones School, and address the entire constellation of considerations that inform affordable housing. I think oftentimes the discussion focuses explicitly on the house itself, explicitly on the object, explicitly on the design. And to be quite clear, anybody who's been involved with affordable housing knows that that's probably about 2 to 5% of the game. And I think the question that was just asked about the term that somebody is assigned to in terms of true ownership of a home becomes part of that issue. So there's a lot of advocacy and a lot of education that needs to occur in terms of engaging the sectors of the community who can be impacted. So the focus of the Arkansas Home Lab is for us to create an internal network that deals with an array of affordable housing issues, leveraging the capacities of a Research One university, and then forming a series of another constellation that resides outside the university and the capacities that the university represents, to bring that expertise to bear and bring and involve everybody in a human-centered design process. And the reason for involving people in the design process is not to relieve the burden or the responsibility of a designer, but it's to include the considerations and expertise of everybody who needs to be involved in having impact in transforming the lives of individuals who are involved in the project. Universities have a distinct privilege of operating on different timelines than the market does, and the commercial market obviously offers certain expediencies that are of benefit to the university. So My reason in coming here was to address a significant challenge in this region, in this state, for this university and its land grant mission to have an impact in serving the community. And so I'll talk a little bit about how this scales up some efforts that have been done in previous parts of the country using affordable housing in a model similar to this. In fundamental concept, the idea is that that network of entities that's identified abstractly is involved in the development of a prototype design. The Fay Jones School, along with partners, would then be involved in constructing that prototype involving job skill training for a labor force, and that labor force then is absorbed into the operations of general contractors and other entities. And then once the prototype has been validated or verified by a HUD qualified family living in that for a period of 3 years so that it can be monitored, those plans are released so that the project can be replicated at scale. So it's just simply that's kind of the basic model. Ultimately, what we are hoping to do is serve the entirety of the state. The regions of the state which are identified there are characterized in grossly different ways by region. And of course, there's the legal boundaries that are established or understood, the commercial boundaries. But then those are mapped over what are geographic and geomorphic regions. So one of the things that we'll be doing is taking a look at how those two relate to one another sympathetically. The past 2 years in doing the work to prepare for the prototype work that will be executed in the coming years. We've been doing research to try and understand capacities of partners that might be involved in different parts of the region, reaching out to those partners and seeing what their involvement might be, gaining an understanding of what the housing needs, county by county, municipality by municipality, trying to understand the relationship of transit costs and other costs related to the specific cost of the home, and then trying to understand what the populations in those counties, what their how they might be characterized, and beyond demographics, trying to understand through outreach what the belief systems are in those communities. So these are examples, and of course, then there's cataloging the existing housing and understanding what that housing is like, and understanding what those residents value. In our region, as everybody knows, Northwest Arkansas, we anticipate having 1 million people in this region by 2045. Most recently, that statistic has been boosted, and that we're now talking about 2038 based on current projections. So the question is, who lives here? And a big part of understanding how affordable housing might be dealt with and how one addresses it comes again with understanding the physical landscape, but it also comes with understanding populations. This is a topic of great visibility in this region, clearly by these articles. I think in this region, the public is aware of the rising costs of land, the rising costs of housing, and limited resources in terms of labor forces. And of course, we're in a region that's not characterized by dealing with a single municipality. We're talking about a network of municipalities. So the question is, are there distinct characteristics to each one of the municipalities, or are we really talking about a regional objective? So that's something, again, that a constituent group or a constellation of entities, as suggested in that diagram, can have an impact on and with in partnering to address issues. These are just simply regional, this is data that was collected and that we use graphically to reach out. And the graphics that are developed to communicate with specific stakeholders and groups that are involved in the process, and to try and raise awareness of what the significant challenges are. Because to be quite honest, if you're a designer and you walk into a room and you're an architect, People want to talk immediately about the aesthetics. They don't really want to talk about the issues. And to have an impact in affordable housing, and again, to Dr. Green's case with the Make It Right Foundation, what's happened there was very little community engagement. And there was very little understanding of what needed to happen to sustain that community over time. And so that's why these constellations become incredibly important. So the idea here is that there's a community and an individual, they have a relationship with one another. The construction of that relationship legally becomes incredibly important. And then in understanding the work, I think the first piece, particularly in developing an initiative like this, is identifying what the first project should be. So this was raised in the question just before I started speaking. You know, what is the practicality of somebody having a 30-year mortgage? That may in fact be a reality. We may actually be talking about people having to pay for longer durations than 30 years. The other way is to look at the problem a different way. So the first project that we're developing is design to income. As many of you in the room are aware, there are first-time home buyer buy-down mechanisms. There are other subsidies that can come to homeowners and first-time homeowners in the buying process. Those subsidies are very fragile, and they're subject to the whim of political dimensions and sea changes that come with elections. Funds that have been populated, it's not uncommon for a municipality to have a fund that was populated 40 years ago and it's never been repopulated funding. So in the design to income model, we take a look at what the cost of the land is, we take a look at what the cost of the labor is, and we back into the square footage that can be completed once the construction and a contractor is mobilized on site. And so this is a very crude, very granular look at development of a 500 square foot prototype for workforce housing. Basically somebody who's earning between $15 and $18 an hour and what they might be able to afford. So that is the first pilot project that we're going to be looking at here. This project was funded. We have funding from the Walton Family Foundation, Bank OZK, and the U.S. Forest Service to advance this project, and we're currently evaluating sites and working through the design with a number of stakeholders. The idea behind this initial project is that there is a prototype that's designed. That prototype will have variants. This is being designed as a scatter site, single family unit. What that means is that anywhere you have a vacant lot, you might be able to insert one of these units. Scatter site means that they're going throughout the community. But the idea is that the first prototype is developed in conjunction with the groups that are being put together, considering all the dimensions of bringing somebody through a design process, through the construction, home ownership, financial literacy training, understanding what it means to own a home, cultural education, and that prototype is constructed as outlined with a general contractor and a group of people who are being trained to join that workforce. Once that's completed, again, working with the students and the faculty at the Fay Jones School in the construction, the general contractor and that workforce roll off and they replicate units 2 and 3. Now that's a very simplified version, and there are many different ways that this would probably be executed in reality, but the pilot project is about making 3 units. The first one to work out all the bugs, the second 2 to determine market viability. Okay, those might take a form when we talk about 500 square feet. One of the strategies that we've used previously, not at the Fay Jones School, but that's been used in projects that I'll share with you in a moment, is build a core that serves the primary functional needs of the family, and then provide a roof structure, which is at a fairly low cost that can be expanded into over time. And there are multiple mortgage programs that will support this. And one of the reasons for using this strategy is that beyond the financing being available, this works very well in terms of working with the comparables that need to be addressed in terms of the process. So what form these will take, that's being determined at present. These are just diagrams to explain the process. I'll talk about this project just briefly as a model to demonstrate what happens with a development like this. I founded my first nonprofit after being a principal with a very large practice. I grew up on the west side of Chicago in a neighborhood called Garfield Park, and it's a disinvested community. My parents were immigrants. We never owned a home. And to be honest, if I'm honest with people, the reason I became an architect in the first place was because it was out of selfish motivations. I wanted to be able to build a home, and I wanted to own a home at one point. I was fortunate and had a lot of success in my professional career, worked with a number of leading architects globally, and ended up as a principal with a major practice, and was there for roughly 10 years. Working on significant projects, and I realized that I was really not happy and not finding that a satisfying enterprise. So I shifted into academic pursuits, specifically to start a nonprofit that would work with students on initiatives just like I've outlined for you. So I formed a nonprofit called the Drachman Design Build Coalition in Tucson, Arizona. I put my personal assets against the construction loans that needed to be utilized to kick this project off and kick this nonprofit off, and obtained some loans from the Tucson Industrial Development Authority to access the land, develop the construction financing, and move forward with the project. I and the DDBC acted as the architect, the developer, and the general contractor for this project. Took over a piece of parcel in one of the barrios, that is to the north of Aviation Highway there, which links the international airport to the Air Force Base, but essentially bisected the city and segregated the city in a very unfortunate way. So this piece of land became important in terms, this underutilized land, important in terms of tying that zone together. What you're seeing in the foreground there is a lot that has 5 housing prototypes on it. They are really innovatively named DDBC 1, DDBC 2, DDBC 3, 4, and 5. They're designed to passive standards. They are designed for people at 40, 60, 80, and 100% of the median income. The intent is to model mixed income development on the lot and be able to monitor it. All four of the 5 homes have been replicated. Those 4 have been replicated. The total sum number of homes have been produced from these prototypes is 382 at this point. There's one that we did not release for replication, and we didn't release it for replication because the energy bills, we did not get the performance out of the structure that we anticipated. And since those costs are significant to a homeowner who's in a very vulnerable position, it does matter. So if it's not performing the way that it's anticipated, we won't allow it to be replicated. So I still sit on the board of this. I will show you some work that I've been doing in Pittsburgh. These are the 4 prototypes that have been replicated. The 3 on the left, won consecutively AIA Home of the Year in the state of Arizona, which is an incredibly competitive competition. And typically people do not, operating in this income sector, do not compete well in that. So the homes are well designed, considered well designed by the design community, and they've worked well within the context. They are predicated on vernacular building sensibilities. So when you look at these homes, they fit to norms that will qualify for subsidy buy downs and for down payment assistance. But to Dr. Green's point, this model, we've done projects that are thermally enclosed, and we've done others that breathe. This is one of the ones that breathes. It's made from rammed earth, which that thermal mass allows for the exchange. Basically, the energy costs on this house in terms of operating it comfortably have never exceeded $20 a month. Right? We work with the students, again, with the research on university. We can experiment with things that are not viable. I have a private practice that I maintain. One of the threads that I use in terms of private practice is if it's something that I can put a number to and that I could quantify and run through my private practice, I don't touch it as a public interest pursuit. The advantage of a Research One university is bringing to bear all of the faculty and the assets that we have to think about issues, construction techniques, technologies, modes of implementing that might not be able to be explored in a market economy. We monitor the construction, and I see the note. I'm going to shoot right through this very quick. I'll just show some examples. We monitor the construction. This is an example of job skill training workshop on DDBC 1. The construction and the construction documents are calibrated so that they focus on crews being able to be trained in cycles of 3. This is an example of thermal monitoring on DDBC 3. We require people who are in the homes to provide us with their energy bills for 3 years. We also do our own radiant testing, and we modify. We track. This is a very crude example. There's a critical schedule that I could show you is a lot more elaborate than this. This is probably not all that legible either, but we do track things where there are mistakes in terms of strategic thinking that either cost the labor or time, or make the project vulnerable by consideration of material, and then we make those modifications to the construction documents. And then this is an example of this being in a scatter site infill where you have these vacant parcels. One of the things that has been critical to these is we want the residents to take the neighborhood over. This is their home. It's not about our design. Our design is there as a framework for them to inhabit. The Savano demonstration project that I illustrated or showed you the aerial photo of, this is a street view. This home, as you can see, the residents have modified the facade. They modified the facade based on, again, increased in terms of their familial wealth, and they expanded into the covered space. And those pristine architectural photos that I showed you, this is what that streetscape looks like now. And you can see the residents have come together like Celia Perez, and they have brought together things that they value to create boundaries around those homes to make them specific. And I think that's really the point. It is about people. So somebody like Celia Perez allows us to understand how the house should be calibrated and how it remains culturally significant and how it's something that will be valued. And that really, all the talk about sustainability, my personal belief is if we're not addressing social sustainability, it does not matter. And I think that's one of the great failings of the Make It Right project is there was no social sustainability. So this model has been replicated in Pittsburgh. There currently is a 14-unit project that was Carnegie Mellon University for 12 years before arriving here. These homes were developed during utilizing the same process. These are some of the drawings that talk about the formats and strategies that are used in those. Just giving you some of the drawings. This is a 20,000 square foot facility that I still run. It's a nonprofit up in Pittsburgh, where I provide job skill training for second strike felon offenders reemerging into society. So this is one of those training sessions. That's the facility that we use for the job skill training, just some of the meeting facilities. We prototype in that facility, get a rough idea of what needs to be done. And then these are 2 of the 14 units going up. So single family, scatter site, duplex. And then this whole notion of scaling up. So thank you. I'm sorry for running long. Thank you.
Well, thank you, John, and I'm going to have us run just a touch longer, but we do have back where Justin is sitting a dispute resolution board that will work out any problems that we have with the schedule. We will not break exactly on time, and Mike, we're going to take reactions and invite reactions and discussion. I want to say that John and I have had very preliminary discussions about how perhaps the School of Law could be a partner in this. And I believe that what John is saying and what Shelley talked about, we're going to draw the background that Mark provided in as well, suggests that there are opportunities for collaboration that we haven't explored. And what I'm urging everyone involved in this program, and especially those who traveled in to be with us, is to work hard to continue a dialogue for collaboration between the design professions, the legal profession, scholars who are interested in the design and construction industry and kind of contract law, construction law, and those of you who are construction lawyers and the practicing bar. So I think gradually as this program moves on, I think some of you will have some lights go on. Oh, there are some possible collaborations there. And what they're doing in the academy is not just nonsense. And what you're doing in the field is very important for us to understand. So with that, Mike, pause that trouble you promised.
No, not at all. I think it's very interesting this morning that Mark and Dr. Green have laid out some things, and John has actually responded to those things in what he was presenting. It does all go back to basic design and construction and how you support that. I turned 75 last week. I'm about 9 years away from finally owning my first house. The Navy provided part of that as I moved around. But my father bought a house on a 30-year mortgage in 1960. And I think coming out of World War II, a lot of veterans bought on 30-year mortgages. He paid it off. Actually, burned his mortgage in 1990. He lived that long. But I think there's areas to work with there and do that. Up until about 9 or 10 months ago, I had about 350 people here in facilities management. Probably 250 of them were in that lower income level. At the time, entry was about $10 an hour. It's now 15. And we still are catching up because what was 15 in McDonald's is now 18, 19, and 20. But what's happened here in the last couple of weeks is impacting those people even more, because in order to afford housing, they're not living in Fayetteville or the immediate area. They're driving back and forth from Madison County, Southern Washington County, and it's now headed for $4 a gallon. A huge expense on transportation that impacts their ability to even afford the house they're in right now. I think getting back to neighborhoods, getting back to multi-use development, getting back to infill, not zoning, so you're zoning things in different places, getting people closer to where they live, work, play, and go to school, neighborhood schools. I think those are all good directions in looking at density. Maybe enough density to do other transportation initiatives, getting us beyond putting another lane of concrete down and taking up more land for transportation for people to have the inalienable right to be in their car by themselves driving somewhere. Now, having said that, back to the contract areas that we were looking at. Coming out of the Navy, we had transitioned from design bid build, which is where the reputation of litigation, claims, all of those types of things came from. And it's richly deserved, fortunately, because there's a lot of people living in that world, whether they're contractors, subcontractors, designers, owners, users, all contributed to that reputation. We had shifted to pretty much design build. And we had about a $2 to $3 billion a year budget. My last 3 years in Naval Facilities Engineering Command. Design build was working better for us, but we were able to pre-select, pre-qualify contractors and also do larger packages with multi-year elements. Coming to Arkansas, going from federal acquisition regulations, where you want to see standards, specifications, documents, truckloads of documents to try to keep everybody risk-free, which is mission impossible. Federal acquisition regulations will lead you in that direction. But coming to the state, a different bureaucracy, a different set of acronyms, but still trying to deal with a good set of foundational documents that are fair, equitable, share risk, and protect all. Well, to do that, you have choices. AIA being one choice, but it leans a little bit to the design world. What is it?
JCDC.
CDC is a group of ASCE, civil engineers, professional engineers, and those groups. Consensus docs are another group that are around, and there are AGC and a lot of subcontracting type organizations. So as you can sense, they're all flavored a little bit in each one of those directions for the groups that support it. What we really need to be getting towards, and it's happening, is an integrated project team where you have one contract. Design, construction, everything for the owner. Over the last 16, 17 years, we've developed something that we cannot do design build in higher education in Arkansas by statute. Interesting. AIA is pretty powerful in Arkansas. But what we have been, what's been made available to us is construction management at risk, guaranteed maximum price. That happened in the late 1990s because of some Reynolds Foundation grants. They wanted some flexibility. And it went over out of grants into even state funding. I call it our five-legged stool. We have an owner, a user, a commissioning agent, a separate contract that comes from sustainability and resiliency, a design team, and a construction team. Those five elements. The owner and user are a little bit of a combination, but representing the state, the taxpayers of Arkansas, was our organization of facilities management as the owner of. The users are those faculty members, whether it's academic, whether it's athletic, whether it's housing, that come together to build that. Commissioning agent is a separate contract that we had several online, and we assign them to the contracts, and that's to do sustainability ratings, sustainability design, and work through that. A design contract and a construction contract, construction management contract, and we have been using AIA documents but modified to accommodate us and try to share the risk as best we can. We bring everybody aboard in the beginning, facilitated partnering to develop a separate specific project charter for that project, and a commitment from all the people working on that, from all five of those groups, signing that charter to deliver that project in that period of time. For us to deliver a project is about 3 years. Well, on the federal side, it could be out into 5, 8, 10 years because of Congress funding and that type of thing. So a lot of things change, and periodically you recheck your partnering charter and work through that. But it's to share risk, safety. Safety is every person's job on that job. Different people have different responsibilities as you move down the time. So safety is a great conversation. It's another conversation that's going on right now in higher education, specifically in the civil engineering curriculum, trying to get into the accreditation groups that safety should be a major element of the accreditation and what's being taught in the basic bachelor's program. That is another laborious process that takes probably 3 to 4 years to get through all of that. Biggest thing is to have a foundation. If you have to resort to the legal world, you've got a basic foundation that has some structure. Cannot use arbitration in the higher, at least in the University of Arkansas system, so we have mediation. I've never gone to mediation in 17 years. The point is not to do that. The point is to build a project under budget, shorter schedule, as quality as it can be, not having some of the issues that make it right, and that type of thing, where things fall apart and they're not built right. But deliver the project, realizing that everyone has different equities. A reasonable profit is not a bad thing for all the parties, from the design and the construction side. Nothing wrong with it. Quality project for the user. A project that's on budget or below for the owner, working for the taxpayer. So I came in today, this is probably more attorneys, lawyers that I've been in for a long time, with gun hives. I've worked with them for a long time. We had about 25 of them at one command I was at in Southern California, and they were mainly environmental lawyers dealing with California, Oregon, and Washington. The job is to share risk. The job is to avoid having to go into litigation. The job is to deliver for the owner and the user, ultimate users, whether that's a house or an academic facility or a football stadium, whatever. Great conversations. I'm really impressed with Dr. Green and John and where they're headed and what they're trying to lay out. I think Arkansas, Northwest Arkansas, badly needs this to not take a long time to happen as we grow and as we develop. And I think it's exciting to see where you're headed, John, and to address some of the things that Dr. Green brought up.
So thanks, Mike. And I realize that we are a couple of minutes into the break, but I am working on some adjustments to the critical path method schedule. We will make up some time. We need to have a little exchange, a little discussion among our panelists, reaction to all of this. So I think Mike's comments were lead into that. So use a little bit of our break time and we'll figure out the adjustment.
So your statement that in 17 years you have not gone even to mediation. Is the following proposition true? That the key is we have 5 different partners, all of whom have an affirmative obligation to bring up issues as early as possible so that they get resolved as early as possible. Is that sort of the
Absolutely,
rationale?
right on track. That's why we bring everybody aboard
Right.
day one.
And keep them there.
And before we even start on the planning and programming, just to sit down and spend a half day to a full day in a facilitated partnering session to develop a charter on how we're going to operate and establish the communication methods that work and the responsibilities of everybody to participate. In pre-construction, we want our soon-to-be general contractor actively engaged on those means and methods and how can they work with the design team to perhaps save us money and get us a better project before we even get very far into design.
Constructability.
Yeah, and I certainly, in my view, with the Make It Right project, just wonder what kind of communication might have been missing between the contractors and the architects.
Where do we begin?
Not, well, I guess not really appreciating the environment, designing a structure suitable for the environment. It's inexcusable, forgivable lapse.
So, can I ask a question? I mean, it seems to me in that project, there's 2 kinds of defects, internal and external to the purpose, the rationale. Internal is to build houses with 8-foot elevations where people in wheelchairs have no access.
Right.
Yes. That's like inherent within the logic, and external are just poor construction, poor design for that location, which I think it's unfair to point to that to try to undermine what this project was trying to do. So
I have a great,
it's like
great,
pot shots.
yeah, great purpose, great experiment. But
Yeah.
poorly executed. And I wonder whether or not the status of those for the design has influences the quality of the planning and execution. And it's philanthropic largely.
But can you build a house in a flood zone that the handicap can access?
John, go ahead.
Yeah, I think that there was a fundamental flaw in the thinking. And I think everybody's aware of the fact that best intentions can do most damage. And the fundamental flaw was that there were no local practitioners involved in anything. It was all about bringing star names and star talent that had no connection to New Orleans to make homes that had no relevance to the region. And so the construction defects, I think you can trace everything back to that. It was fundamentally about helicoptering in and kind of a savior mentality and not really understanding the place before acting. And, you know, the point Mike brought up, there's an urgency, right? And after Katrina, there was an urgency to do something, particularly with the population being lost there. And I think that people, with Make It Right, they lost sight of the fact that they really needed to have a long view on it. They looked for short-term gains, and they looked for, I think it was a huge exercise in public relations. And I think that there were very, again, the intentions were laudable. It was not executed, and that shared responsibility that we're talking about, it just didn't exist. The practices, I don't think were held accountable for what was done there at all. And that was apparent from the get-go. And I think it is unfortunate. You know, how many people from the Ninth Ward live there? 0. Those all became absentee. The people were buying those as vacation homes. I mean, it was there's so many lessons to be learned from that project about the process that, you know, this whole notion of shared responsibility is fundamental to everything.
So any response on your part, Shelby? We do need to break.
No,
We're good. So thanks very much to this panel. Please join me in. We're going to cut our break a little bit short, but we do have a break. A 5-minute break. If you are in the audience here, of course, and didn't get your lunch ticket, I think we have plenty, but go check at the registration table for a lunch ticket. And in 5 minutes, we'll be back. Looking forward to hearing more from all of you. We'll have opportunities for discussion.
Brian will explain how the consensus docs approach to critical contract terms aims to optimize project results by increasing collaboration and reducing wasteful transaction costs. We also have Professor Dale Whitman, who is the James E. Campbell, Missouri Endowed Professor Emeritus of Law, University of Missouri. He is a former dean and a former president of the Association of American Law Schools. He has served as a professor of law and a visiting professor of law at numerous law schools across the country, most recently serving as an adjunct professor of law at Arizona State University. His many publication credits include co-authoring 2 popular textbooks on real estate transactions and real estate finance. He serves as moderator of DIRT, a listserv for real estate lawyers, aptly named. Dale's paper highlights what he calls the secret lien problem that many construction lien statutes create. Our other panelists will provide reactions and facilitate a discussion of Brian and Dale's presentations and proposals. Those other panelists include Ashley Brown, who I do not believe is with us currently, but I will give her bio if she joins us. Then we have Professor Micah Hale, who is the professor and head College of Engineering, Department of Civil Engineering at the University of Arkansas. He holds the 21st Century Endowed Leadership Chair in Civil Engineering. He earned his BS Civil Engineering, MS Civil Engineering, and PhD Civil Engineering from the University of Oklahoma. Professor Hale's teaching and research focus on, among other topics, high-performance concrete and self-consolidating concrete. We also have Professor Mike Johnson, Associate Vice Chancellor for Facilities, Emeritus, and Professor Emeritus for the University, and retired Rear Admiral in the U.S. Navy, who has already been introduced to you as a participant in our first panel. And then finally, we have Mr. J.B. Cross, who practices law in Little Rock. He is a current member and officer of the construction law section of the Arkansas Bar Association and a frequent speaker on construction topics. JB has written numerous articles on all aspects of state, federal, commercial, and residential construction, and he has had extensive experience in both prosecuting and defending construction claims. So with that, that's our panel. Brian, take it away.
Thank you very much. And it was good to see you on stage at the forum meeting and get that award. That was great. So I don't know if my clicker's empowered. If you could get it back, he may have unhighlighted it.
Clicker doesn't work,
Yeah, if you could help me with that. So,
Go from here, what do you want to do, go back?
no, I just want to be able to use the slide advancer. It stopped working. It was working.
Use the keyboard, right?
No, it's for that.
Guess I'll have to do.
Okay, it was working just before. I think you may have, anyway. So could you go, let's see. So, okay, so look, I like to stand up. If you have something to say, I'd love the interaction. We've got about 20 minutes of formal presentation time. But hopefully we can get through the slides. And like I said, if you have a comment or a question, I'd love to take it. I would say that I'm on a mission in my career is consensus stocks have been around for 14 years, but it's sort of, this is the problem. Let me set the stage, is construction contracts are incredibly important and people don't spend enough time thinking about them and utilizing them as part of their business practices, right? And it's a problem. And let me demonstrate how it is a problem. And this chart, I think, is talked about a lot, and this issue about lack of productivity in the construction industry. We have one of the smallest profit margins, and we have one of the most contentious and litigious sectors of our society. And I propose to you, it's how we do our contracts, what we sign, and the process of coming to fruition is not just a part of the problem, it's a foundational problem, right? You can't say general contractor without saying one word, contract. You can't say subcontractor without saying one word, contract. It matters, but it gets far few attention from the participants. It's almost like something we just sign and put in a drawer, and that's not good. And here are the results. This says, the United States, the good news is we are improving our quality of life because we are becoming more efficient in our economy. We are, with certain man hours, person hours, we're producing more. And that's true of our manufacturing, and it's true of our non-manufacturing or agricultural sectors. McKinsey did a recent study, but this is from the US Bureau of Labor Statistics. 3.6% on average, our manufacturing sector is improving on an annual basis. 2.8% for the total economy. And actually, I don't have the agriculture out there. I've seen different, whether it's better or worse than manufacturing. But the point is, every year we're getting better and smarter. If you look at this chart, there's one sector that lags last. Guess what sector that is? That's our sector, the design and construction industry. If you look at this chart in the late 90s, early 2000s, we were actually getting less efficient, not more. So good news, we're getting more efficient, but we struggle. And it's something that compounds. The difference, the delta between the blue line and the black line is huge. So if we can so I propose to you, if we can improve what's in our contracts and the process of how we come to agreement, it makes a big difference. Let me demonstrate this more. I wish there were more studies, but all the studies evaluating the impact of contracts all say the same things. Best contracts, fairest contracts, best project results, right? Worst contracts, most unfair contracts, worst project results. The Construction Industry Institute has done studies on this since the early 80s. There's one that they have from the 2000s. And it doesn't quantify it, but another Canadian study back in 2011 quantified a range of just 5 clauses. And those 5 clauses had a range of increasing project prices for owners who at the end of the day have the most to gain or lose on a project's success, in my opinion, because they own the capital asset throughout its life cycle, is that increases prices 20%. Just 5 provisions. And those are the site conditions, schedule, like no damages for delay, consequential liquidated damages, use of indemnification, and then sufficiency of contract documents or scope of the work. Those are all the provisions that I would highlight in my top 10 for sure. Okay, and most people, they're embarrassed what they sign. The owners often have, or usually have the provision of, well, I can shove the risk down someone's throat. I can always find someone to sign something. And this is leverage that I plan not to use, but if I ever have a situation, I can pull the contract out and use it as leverage. Well, I say that's using like the Albert Einstein's definition of insanity, doing the same thing over and over again and expecting different results, okay? So we can do better. Most of our contracts start with or are influenced by standard construction contract documents. They play a very big role in our industry. Even if you're not using a standard construction contract document, they often influence what's in the original or bespoke contract that people are using. I think there's a lot of benefits, and this isn't the scope of the presentation, but there's a lot of benefits of using standard documents. They provide predictability, they provide a common understanding, and they get away from the gotcha clauses. But let me ask you, so how many people here are familiar with the American Institute of Architects, AIA, standard contract documents? Okay. How about consensus docs, what I work on? Decent amount. Now, here's the thing. Not a lot of people, how many people are intimately aware of consensus docs? Less so, right? Some. Let me just go forward a little bit. I think consensus docs was talked about before. Even if you don't use consensus docs, here's what I think is really valuable. It's not just, I get my paycheck from AGC, but I run this coalition and everybody has an equal seat at the drafting table. I would highlight the top 3 organizations. NASFA, the National Association of State Facilities Administrators, CURT, Construction Users Roundtable, which is the top 100 owners across the country, those type of owners. And then actually the largest group and probably the one most active in the contracts area is Construction Owners Association of America. That organization was founded out of dissatisfaction with contracts. They felt like their voice was not heard in AIA contracts. And so they created their own. They folded that effort into consensus docs. AGC used to have standard contract documents. They folded that into consensus docs. And I will tell you, consensus docs have been around for 14 years. We have made more changes based upon design professionals' input, even though we have some Construction Specifications Institute. But the point is we need a better foundation to come up with agreements so we can be more efficient. But I would say the owners really are very active and have a big voice. And I'll tell you, as an in-house counsel for AGC, I tell those contractors, you shouldn't just necessarily sign blank. There's a lot of things that you should consider changing because it is not unbalanced. It's not biased towards general contractors. Here's what it is we're so used in our industry to have an outside role of honestly the design professional telling the owners and the contractors what to do, that the stage is unbalanced, right? A party that usually has an outsized authority but very little responsibility or liability exposure has an outsized role. And I think that has created sort of an unbalance of what we're used to. But usually it's the golden rule is what we're using. The one who has all the gold, makes all the rules, and shoves all the risk down to who? The weakest party, not the party. We all should agree on one principle. The party who's in the best position to manage and mitigate risk should be allocated that risk. Instead, we usually allocate risks to the weakest party, right? And then integrated project delivery has a better approach to risk allocation. The project teams as a whole should be allocated the risks, and they should collectively manage and mitigate those risks. Most of our contracts, how many people here see a 40-page document with 80 pages of modifications, right? That's what we typically see. No predictability, no certainty, lots of gotcha phrases. But when I go to all my conferences, everybody's always talking about, I want the A teams, not the C teams. I want to work on a collaboration. Everybody agrees that communication is good. We all agree that we should have the risk in the best party at the position, the best challenge position to mitigate it. But our contracts usually don't reflect what our principles tell us to do. Okay. I'm going to ask you, what do you think the most important provision is? We made you do this at the form meeting. I'm going to ask you, what do you think is the most important construction provision? there. I've got payment, indemnification, scope of the work, or who the parties are.
I'm gonna say payment.
That's what most people say. And specifically contractors always say payment is. I'm going to tell you my position here. It's a trick question. Is the most important provision, and this is from a litigation construction attorney in Atlanta with Smith Curry Hancock, Phil Beck told me this, and I couldn't agree more, it's the blanks in the contracts for my standard contracts. Who the parties are. Who the parties are at the end of the day is going to make or break a project. I'd rather have the best teams working with the worst contract than the best contract with the worst teams. Okay. My point here is, there's going to be some sticky wickets that arise on a project, and you're going to have to figure that out. You're going to get your turtle shells. If you can figure out a way to structure your contracts where your business relationships are memorialized in your contract rather than your contract dictate what's your relationship, is a much better position to be in when those difficult issues arise. All right, so what do we want to do? What's the number one rule for our contracts? We want to create a foundation to be able to communicate. Most contracts tell you everything you shouldn't do and you mustn't do. Very little things of what you should do, right? And what we want to do is create a foundation to share information. We don't want to create contractual silos that segment information. Often our contracts do that. Sometimes they used to be in the standard AIA documents that you endeavor not to communicate with an owner and a contractor, but they should only do it through an architect. Thankfully, they've improved that provision. But again, most people have this mentality of creating contractual silos. What you want to do is actually encourage communication. And you want that communication to be positive. And think about this, your contract is your first act on a project. It's your honeymoon period. If you start in the battlefield with a mean contract that you just read it, that doesn't bode well for project success. So you want to create positive interactions. Let me give you an example. So most dispute resolution provisions talk about like how we're going to go through a dispute. What I think it should talk about is how we can mitigate the dispute before it arises. So in consensus docs, and you can plug and play this, is require the parties to talk to one another in a tiered fashion early on the project before people become intractable with their conflicts. Mediation in construction is very well established. It doesn't work as well when it's people are doing it grudgingly, but that is mediation. Construction's been a leader in that area. And then yes, arbitration or litigation. Think about this, if you have a provision in your contract, which, and I've seen it, the losing party, we had the losing party has to pay attorney's fees. And I think that's an important way to not have people, a disincentive for putting forth uncolorable litigation claims. I've seen provisions where the owner says, well, you have to pay my attorney's fees even if I lose, right? Like, that's just not fair. It doesn't make sense. Scope of the work is probably one of the most important provisions. It's not one that the lawyers necessarily draft because it's really evaluated from the contract documents and how the parties are evaluating those. But what I see a lot of times in provisions is that it turns a builder into a mind reader because it'll say things, not just what the documents say that are reasonably inferable, which I think is fair, but a little ambiguous, but also what the intended results are. What are intended results? Are you supposed to distill the mind of the design professional who put forth the documents? I think that's hard to price out. It's hard to know. I don't think that's a fair provision. Here's something that in our contract documents that are not an AIA is an order of precedence clause. I can't tell you how much money is lost litigating over determination of this document has a higher precedence than that document. In consensus docs, we say that, well, the ones in general, the agreement has the highest, but like the things that like a change order that is done when the parties have had more time and then there's more evolution of the project, the latest documents tend to have a higher precedential value. But I don't care what the order is. I don't want people spending millions of dollars of claims and litigation on fighting over contract documents when they could have maybe determined some higher order of precedence in the beginning of the project. So I think you should have an order of precedence. Differing site conditions, we could all agree is one of those provisions that you're going to look at. I see this all the time where people say that you're responsible for, well, the common law basically has that the owner usually is in the best position to know what their site conditions are. But contractually, people are reallocating that risk to the other parties. And they're saying that you should anticipate unforeseeable conditions, which is ridiculous. So I would say, look to the standard documents, look to the FAR. All of those provisions are fairer than what a lot of misallocations going on in contracts these days in regard to differing site conditions. Here's the number one issue that I see. Post-COVID was by far, all of a sudden the contract attorneys were stars within the construction industry because people are like, what's force majeure mean? And what am I supposed to do here with COVID? And so all of a sudden people really wanted to hear about construction attorneys. Now at my website, we have the number one hit for price escalation. Consensus Docs is the only producer of a price escalation clause that's standard. It's the Consensus Docs 200.1. This is, and it was with what's going on with Ukraine and the price of oil. This issue is not relenting. It's the number one issue, and it's going to continue. And the price spikes are even more unpredictable now. What we have is the prices go up. You set a baseline. You have to. The hardest part is to figure out what index to use. And here's why it's fair: the prices go up or they go down, and that's why it's good for owners, rather than an owner having to pay a contingency of someone pricing in the unknown escalation, because you can't do that on a, say, a 3-year project. If the prices go down on materials that you agree are indexed, then the owner actually could benefit, and I think might be more benefit by doing a price escalation clause if all of their bidders and negotiators are increasing the prices by a lot. But there's just a lot of unknowns. But anyway, by far, this is the question and interest that we had a webinar on this, over 1,000 people listened on price escalation. So this is a website I've created. It has a number of indices where, including the price of producer index. The St. Louis Water District in Missouri, not that far from here, they used an influence of our price escalation clause, but they put a price escalation clause in a project that they just bid out. They tied it to certain materials. My ask would be to just tie it across to all materials, because we don't know what's the next steel or lumber or whatever. But most owners want to tie it to an index, and they probably will not give 100% of the increase to the builder. They probably will want to do a shared increase. Ours is, there's a ceiling, but it's not shared. You'd have to modify the document. Indemnification, I'm hearing this time and time again. People are really asking more than ever. Indemnification clauses are shifting risks. They're usually covering holding harmless of upstream parties for things that aren't even in the scope of the parties. Usually it should be tied to insurance or intentional acts. Now they're saying even things that you might not have any responsibility in your work scope for, you're now indemnifying upstream parties. Even if the upstream party or the owner is 100% at fault, you might have to make them harmless. Some states have anti-indemnification laws that make that unenforceable, but usually there's always some gray area where even if the party is 1% at fault, they might get 100% remuneration and hold harmless. Again, it's a risk-shifting risk, it's inefficient, and we should tie it, like the standard documents do, to a comparative negligence standard. So with that, I'm going to, I'll talk about consequential and liquidated damages. You can't bet the farm on a project for consequential damages. They're unlimited. There's case law and arbitrations about this too with the Perini case. Liquidated damages are more favored, but a lot of times liquidated damages depends on what they are, and they can be egregious too. So what I always advocate for, and we have this in our guidebook, which is something you can get on the website, is pair liquidated damages with incentives. If it costs $100,000 a day to be late on a project, well, should you get $100,000 a day if you're early? Maybe not. Maybe you should get 50, maybe you should get 25. But if the answer is 0, even if I'm like 100 days early, but I have to pay $100,000 if I'm late, you start seeing that the liquidated damages might be more of a punishment, but therefore maybe not enforceable. Again, if you're looking at your top line issues, consequential damages and making sure the liquidated damages are fair are going to be one of your more critical provisions. And with that, I'll just say one more thing. One thing I'm really proud about consensus docs, and I'll make a pitch for this. Good legal writing is just good writing. It helps with contract administration and memorializing the business relationship and the parties to understand the contract when they sign it and when they administrate it, which is important for people in the field as well. And that's the philosophy that we take in writing our standard documents. Rather than to obscure or to cover every kind of contingency, I think that that is poor writing, and I think that's generally disfavored. But a lot of times you read contracts and some of the standard language, and you're like, I don't understand what this means. And that's why a lot of contractors don't want to read their contracts. They just want to sign it and stick it to the drawer. And with that, I will yield the rest of my time.
Great, thank you very much, Brian. Fantastic presentation. Professor Whitman, I believe you are up.
Brian, would you have any clicker?
I would love to. Hopefully it works good.
Is the mic working here? Can you folks hear me all right? Actually, was that turning it on or off? It's on, okay. And if Bob will, there we go. She'll run that to slideshow, Bob. We'll get going. Now, this is a sort of a zoom down for a micro look at a little problem that's bugged me for 30 or 40 years. And it really isn't the sort of broad thing that the rest of the panelists have been talking about, but I hope you'll indulge me in it. Maybe we'll make a difference in the long run, maybe we won't, but at least we'll maybe gain a little understanding of the problem. When the first colonists arrived at the Massachusetts Bay Colony, they decided to solve a problem that they'd had in England called the secret lien problem. I was talking with Sir Vivian last night, and he pointed out that there are no construction liens in England, and I thought that was commendable. We certainly have them in the United States. They've been with us for a long time, and they're a real problem. If we want to examine the problem for a moment, we can think of that arrow as representing the passage of time, and we'll put some points on the line to represent important events. The first one is the commencement of construction on a project. That turns out to be legally significant in almost all states. A second point is the completion of construction on a project. That's significant in most states. It doesn't happen to be in Arkansas, but it is in many states. And then there's a lien filing deadline. That means that that's the point at which, if you're a contractor or a subcontractor or a materials supplier, you must have filed your lien in the public records by that date. In many states, that's computed as so many days after the completion of construction on the project. In Arkansas, it doesn't depend on the completion of the project. It depends on the completion of the particular contractor or subcontractor or supplier's contribution to the project. So if you're, for example, the excavator, then you have 120 days after completion of excavation. So it's a fairly early date. If you're the landscaper, you probably complete almost the very end of the project, and you have 120 days after that. So probably you'll be well after the project is over before you have to file your lien. But in any event, it's 120 days after you complete your own work in Arkansas. Now, suppose somebody is either going to loan money on the project, take a mortgage on the project, make a loan, or somebody is going to buy the project. We call them a BFP, a bona fide purchaser. And they're going to do that after the project is completed. And then suppose some of the contractors or subs file liens on the project, and they do it after the bona fide purchaser or the lender has taken a mortgage or taken a deed on the project. That's entirely possible on the timeline that we're looking at there. Normally, we would say, well, the ordinary operation of the Reporting Act means that the bona fide purchaser or the lender will take priority over the liens that get filed after the purchaser or the lender takes their interest in the project, right? We'd say, well, first in time is first in right. The purchaser or the lender got there first, and the lien holders will be subordinate. And in the case of the purchaser, they'll simply not have an interest in the project. In the case of the lender, they'll be subordinate in priority to the lender. But the mechanics lien statutes have a surprise for us. It's called relation back. And what it says is that the priority of the liens that are filed, if they're filed before the lien filing deadline, the priority relates back to the date of commencement of construction of the project. Now, if you think about that, it's a really shocking idea that somebody can file a lien as long as they do it before the lien filing deadline, and their priority will relate back many, many months in many cases to a date much earlier than the purchaser or the lender's date of priority, and will take priority over them. That's an appalling idea. And so that's where the secret lien concept comes from. In effect, what it means is that you can be a purchaser or a lender on this property, and those liens can take priority over you, even though when you did your title examination before you took your deed or your mortgage, you had no possibility of finding them in the title examination because they simply were not recorded in the public records. So your title examination will not disclose it. That's a perfectly ridiculous idea, and yet it's built into the mechanics lien statutes. So we have secret liens, something that the original Massachusetts Bay colonists were determined to avoid. Now, how can a buyer or a lender get notice of these unfiled liens? Well, there are some possible ways that they might get notice of them. The construction work may be well known or obvious to them. They may know that they're buying property on which construction was recently completed. Many times, of course, they know they're buying a recently built building. So the buyer or the lender, or if they're working with a title insurance company, they may or may not be, that depends whether title insurance is willing to cover them. But they will normally ask the owner for final lien waivers for the subs and the suppliers to determine that those subs and suppliers have been paid. Will they be able to get them? Well, if they're working with an owner and a general contractor who are competent and professional and ethical, then the owner and the general contractor will have collected final lien waivers from all of the subs and suppliers who worked on the project. And they'll be in good order. And they'll be happy to present them from all of those subs and suppliers to the buyer or the lender who is taking a mortgage or taking a deed on the project. If the project has recently been completed, there may be some subs and suppliers who haven't yet been paid. And so the owner and general contractor will say, well, we'll have to provide those later, but we'll have to provide them by the time of closing. And at the closing, we'll give you final lien waivers from the subs and suppliers who will have been paid by that time, at the time of closing. So we'll be able to assure you that everybody has been paid by that time. In effect, the lien waivers act as receipts from all of the subs and suppliers showing that they have been fully paid by the time of closing of that sale of the property or the closing of the mortgage that's being made on the property, mortgage loan. Now that all sounds fine if you're working with a highly competent, well-organized owner and general contractor. Well, what can go wrong? The answer is a lot can go wrong. The first possibility is that the owner may inadvertently omit some of the subs and suppliers from getting those lien waivers. After all, the keeping track of the lien waivers, especially on a large job, is a complex business. There may be dozens and dozens of subs and suppliers on a big project. Some owners and some general contractors are not highly competent, well organized. They're sloppy and disorganized. Sometimes you're working with somebody who is not even a competent owner at all. They are doing this themselves. They're working with their own subs, and they don't even understand what the purpose of the lien waiver is. They don't understand the concept. Making an error and omitting a sub or a supplier is very easy to do. And if you're the buyer or the lender or the title company representing a buyer or a lender, you may or you may not be able to catch those errors. You can ask them for a list of all of the subs and suppliers who worked on the job, but you don't know, and you have no way of being absolutely sure that they've given you a complete list. So it's very easy for them to make a mistake. The second thing that may go wrong is that the owner or the general contractor may intentionally omit a subcontractor or a supplier. Which ones might they omit? Well, the sad answer is they may omit the ones that didn't get paid, the ones they didn't pay. And if the owner or the general contractor is trying to hide a subcontractor or a supplier, it's very difficult for a buyer or a lender to identify that omission. How will they know that everybody has been paid? The title insurance company may or may not be willing to enter this thicket. I saw a long time ago a list of all of the sources of lawsuits in the title insurance industry. And the number one kind of losses that title insurance companies incur are losses due to unpaid mechanics lien claimants. And so the title companies are sometimes simply unwilling to insure against losses due to mechanics liens, or they may insure them only in certain very limited circumstances. So title companies may or may not be willing to incur that loss at all. The third thing that may go wrong is that the particular type of construction that has occurred may not be obvious to anybody who is buying the property or making a mortgage loan on it. For example, there may be replacement of the HVAC system, or there may be a new roof on the property, or there may be repavement of the parking lot. And if you look at the property, it may not be obvious that that construction work has been done. And so a purchaser of the property or somebody who is making a mortgage loan on the property may not realize that it's necessary to get lien waivers from the contractor who did that work. And nobody may ask for any lien waivers at all. If the title company is asked to provide mechanics lien coverage, they may ask for an affidavit from the seller or the borrower that avers that there has been no recent construction, but the seller or the borrower may lie about it, or they may simply forget. Oh yes, well, in fact, I did have that work done, but I forgot about it, and I will simply sign the affidavit saying no work has been done, and therefore nobody will ever provide any lien waivers at all. So it's very possible that there will be a later filed mechanics lien, and there will be no lien waivers to protect against it, and the result will be that there will be a mechanics lien claim. It will relate back to the beginning of the construction on that project, and it will take priority over the person who purchased the property and obtained a deed or who got a mortgage loan on the property. Now, what is the solution to the secret lien problem? Well, the solution has to lie in changes in the legislation. In my paper, I did a survey of all of the states that abut the state of Arkansas, as well as Arkansas itself. And nearly all of them have this secret lien problem. There are a few that do not. The first solution I would propose is to eliminate the concept of relation back. To in effect say that we'll treat mechanics liens like any other sort of lien filing under the Recording Acts, and to simply say that each lien is given priority only from the date that it's actually recorded in the public records. That doesn't seem like a very shocking idea, If in effect we eliminate relation back and simply take it out of the picture, then if someone purchases the property or takes a mortgage loan on the property, it will take priority from the date that it is recorded. And if liens are filed afterward, they'll take their priority from the date that they're recorded. And under the normal operation of the recording acts, they will be wiped out by the recording of the deed or the mortgage, the big arrow that's pointing upward in my diagram there. So if we do that, then the normal operation of the recording acts will give the BFP or the lender priority over the liens. Is that a politically feasible solution? Well, of all the states that abut Arkansas, one of them actually has that solution. It happens to be Mississippi. Mississippi adopted that in 2014. However, it does have one disadvantage. The great benefit of relation back is that it gives all of the mechanics claimants equal priority. They all take their priority from the same date, the date that construction began on the project. And that means that whether you're a lien claimant who did early work on the project or later work on the project, provided materials at the beginning of the project or the end of the project, it doesn't matter. Your lien is equal in priority to all of the other lien claimants, which has a sort of fairness to it. And lien claimants like that fairness because it doesn't depend on when you did the work. So that's a nice benefit, if you will, among the lien claimants. Mississippi was able to go in the other direction for a simple reason. It is because in Mississippi, until 2014, subcontractors and material suppliers had no right to liens at all. The only people who could file liens in Mississippi prior to 2014 were general contractors. And so subcontractors didn't mind the unequal treatment that they got in 2014 because they had no liens at all previous to that time. So it's not likely that a state like Arkansas, where subcontractors and material suppliers currently have the right to file liens, whether they would be willing to accept the unequal treatment that they get by being treated under the normal operation of the Recording Acts, whether that would be feasible for them. I better not stop or I'll lose my time, I'm afraid. I'll be happy to check with you afterward, or if we have some time later, I'll be happy to address your question. A second possible way to address this question is to require every lien claimant to record what we might call a notice of work as a condition of getting relation back. These notices would have to be recorded prior to the deeds or mortgages of subsequent purchasers or lenders. In effect, they'd have to be recorded early in the project's life. And what that means is that purchasers and lenders who bought the project or took mortgages on it would know who they needed to go to get lien waivers. There's only one of the states abutting Arkansas that has a statute like that, and happens to be Kentucky. And it seems to work fine in Kentucky. And it's a good solution, actually. What that means is that if final lien waivers were required to be obtained from everybody who had recorded those notices, a purchaser or a lender of the property would be absolutely safe from secret liens. Now, it is some burden on lien claimants to make them record those notices of work. But it's a fairly modest burden. It doesn't take much to do that recording. And that's a pretty good solution, I think. It's a bit of a compromise. It does take some effort on lien claimants to make them do that. But what it means is that if you are going to buy the project, you know who you need to get lien waivers from. It's still some administrative burden on you to get those lien waivers, but it's not a terrible burden. And what it does do is preserve that equality of priority among lien claimants so that they're all going to be equal in priority if they've recorded those notices of work. So it's a fairly simple way to take care of the problem of the secret lien, and I like that. There is a third proposal. It's not well known. It's called the Uniform Construction Lien Act. Actually, it was adopted by the Uniform Laws Commission back in 1987. It's never been adopted by any state. It was based on an earlier Uniform Act, Article 5 of the Uniform Simplification of Land Transfers Act, which was adopted by the Uniform Laws Commission back in 1997. It also received no enactment. It's not easy to get states to adopt uniform acts about real estate topics, and the Uniform Laws Commission was totally unsuccessful with these. Nevertheless, it is an interesting act. It's inactive now. It's not even on their website anymore, but you can get a copy of it if you ask for it, and I did get one and read through it. It's very complex. It is so complex that I'm going to give you only a very simplified description of its operation in a way that's really kind of appealing, I think. It uses the concept of a recorded notice of commencement. Now, that's different than the notice of work concept I talked about a moment ago that they have in Kentucky. An owner can file a notice of commencement, and it's valid for up to 3 years or a lesser period, if it states a lesser period. And if this notice is filed, then all of the liens relate back to the date this notice of commencement is recorded. It's expected that owners will file a notice of commencement. If you don't file a notice of commencement, the liens will relate back to the date that there's a visible commencement of work. If the owner doesn't file a notice, any lien claimant can file a notice of commencement, and then all the liens will relate back to that date. In nearly all cases, it's safe to assume that a notice of commencement will be filed. Here's what happens. If an owner is going to sell a unit, the property, or finance the property, the buyer or the lender will insist that the owner terminate the notice of commencement. They'll do that for their own protection. And if the owner does that, the owner's got to notify all of the potential lien claimants who've requested that they be notified. It is expected that they will request that notice. There's also a notice of publication. And then a claimant's priority date cannot be earlier than 30 days after the termination date of this termination of the notice of commencement. Or, this is complicated, but it actually does make sense, cannot be earlier than the date their lien is recorded. So in effect, what this means is that a BFP that does a title search 30 days after the termination of the notice of commencement can be sure that no liens will take priority over the BFP. There can't be any relation back earlier than 30 days after the termination of the notice of commencement. So in effect, everybody who buys or takes a mortgage on the property is perfectly protected against relation back any earlier than 30 days after the termination of the notice of commencement. Now, I've said it, and I know it takes a while for it to click, but if you think about it, you realize that it does make sense. It's extremely complex to think it through, but it does work, and it has some benefits. It means that all liens will relate back to a common priority date and have equality of priority. All the BFPs are assured of having priority over the construction liens if they wait until 30 days after the termination of the notice of priority. And the priority of the BFPs doesn't depend on the administrative burdens of obtaining lien waivers. So it's an ingenious but a very complex system. That's the Uniform Construction Lien Act. I hesitated even to mention it because it's so complex to explain. But trust me, I have thought it through and it does work. Well, in any event, there are solutions. Whether anybody can convince the Arkansas legislature or any other legislature to adopt them, I have to admit, is dubious. That's my story.
Thank you very much, Professor Whitman. Briefly, before we open it up to the panel, I have a couple of announcements. So for those listening on Zoom, we have a new code word, and it is diamonds. I don't know if it matters, but there's a capital D in there. Make sure you get that. Diamonds, again, is the code word. Okay, so I have been told that Miss Ashley Brown, our final panelist, is also with us, and she is with us on Zoom. So I'll provide a brief introduction of her. Ashley Brown is the corporate counsel for Navajo Construction Company, a multidisciplinary employee-owned firm that provides a wide range of construction industry services in several states. She earned her JD from the University of Arkansas at Little Rock, William H. Bowen School of Law, and her BA from Henderson State University, and she is the chair of the Arkansas Bar Association Construction Law Section and an active member of the American Bar Association's Forum on Construction Law. And then one final announcement, I think Brian has to leave early, and might have to leave a little bit earlier to catch a flight. So just in advance, Brian, we want to thank you very much for being here. Thank you for your fantastic presentation. And with that all being said, I'll open it up to the rest of the panel.
Yeah, let me make a comment because we just spent so much time on the material and lien thing, and that's one of the topics I wanted to talk about. First, I think I would like to say I read the paper, and if you have the opportunity, I would do so. It's very informative. Oh, usually my voice is loud enough that you can hear it in the next county, but nevertheless, yeah, to read through it, and I don't necessarily disagree with anything in there, but I do want to talk a bit about perspective and a balance that comes with this. The paper starts with a discussion about the old English way of doing things, recording liens, and I guess all of our law relates back to British law. The lien laws that we have in most states in the United States and in Arkansas have to do with a specific issue in construction and contracts that does not exist in other areas to this extent. The concept is privity. In most cases, you choose to do business with whom you choose to do business by going and making a contract with an agreement to do something. In the construction industry, you have subcontractors and suppliers who are dealing with an owner and dealing with the property and who don't have that choice of whom they're doing business with because there's a separation. Those subcontractors and suppliers don't have any contract with the owner at all. If the contractor doesn't pay them, they have their only recourse without the lien laws is to the contractor, who is and often is bankrupt. That's the reason not paying you. So here's the thing though. The owner of the property gets the benefit of the work or the materials that are supplied. And that's the issue. There needs to be some way for those folks to be compensated and be whole for work they've done. The property, all of our property law goes back again to olden times, if you will, and that is we actually look at the dirt as the valuable thing. Nowadays, the dirt may be only a minor part of the value. It's the improvement that's built on. So we have that issue and it does need to be taken care of. There are a number of players in the construction industry and all of them need to be treated fairly. That's what I'm talking about as a perspective regarding this. You have contractors, subcontractors, suppliers, you have owners, you have lenders, and you have construction lenders. Those are two different things. The industry, frankly, the construction industry can't exist without lenders and construction lenders because that's who finances these projects. So all of these players are important. All of them need to be treated fairly, if you will. The thesis of the paper seems to be that a BFP and a lender are at a substantial disadvantage. I don't know that that's the case. In Arkansas, lenders have a substantial leg up. I know we're not doing statutory sections much, but in our 1844-110, they basically get the whole ball of wax. They even go over that first in time. That's recently been changed because the Arkansas Supreme Court has put into effect something from the original statute that had been overlooked for many years, and they've given contractors a priority in the improvement, but not in the dirt. And that's an interesting topic. But I don't see that the one of the parties ought to be given priority or an express, a more fair battleground, if you will, than all the rest. The other thing that occurs here is that you're almost always able, if it's a substantial improvement, to be able to see that it's being taken, it's being executed on the property. Now, one of the issues you talked about, and it's a practical one, I've seen lots of construction loans closed out at a closing for permanent financing, in which they've just finished a project and everybody involved signs a paper saying there's been no construction done in the last 120 days. So there is a risk in this gap. It does occur. It can be serious. I've had it actually work out over several $1 million. But the question comes up, everybody has to be treated fairly. And I think if you look at balance all the equities back and forth, because your BFP or your lender, if they do get caught with that, actually keep in mind, they always do get the benefit of the improvement that's been made to that real property. So the gap is there and it's real, but it's a risk. Subcontractors, contractors, and everybody else has risks on these with these liens. These deadlines we have are easy to miss. Arkansas has some peculiar and odd notice provisions about when they have to be given and the timing, but mostly in residential, it has to be done ahead of time, although there are circumstances when subcontractors or suppliers can do those notices. So again, there is a gap, but keep in mind, that's just one more risk that party has to take, that everybody else also assumes lots of risk. We've talked about that a lot. That's sort of my 2 cents, but thanks.
It's open panel now, so fair game.
Shoot away.
Let me just pick up a second on liquidated damage. It's something that the university has not done traditionally, at least for the whole time I've been here. We did them pretty universally in the military, on the federal side, even though we were changing that when I retired. But the last few years, we've been looking at more incentives, especially in design bid build, on timely completion and putting it up front in the contract. And it's produced some interesting results on timely completion, as you would imagine. I'm trying to determine what's significant on some of those contracts. For us, between $750,000 and $5 million, our only tool is design bid build. Below 750, we can use job order contracts and other things to also competitively carry that out in addition to design bid build. Above 5 million, we introduced CM at risk guaranteed maximum price. We've been toying with liquidated damages. Now we've also been toying with sharing savings that the design team or construction team come up with during the process. 100% currently, 100% goes to the owner in the construction side in our documents. And we've been looking at hopefully incentivizing a little different behavior, a little more energy and enthusiasm to dive deeper by sharing maybe 1/3, 2/3, 50-50, something like that with the construction team and or design team. And I think that has a lot of potential as well.
Can I respond to that one? So I think it's kind of ironic. An incentive for in a design bid build, right? Because the schedule and the completion date that you put in the contract is sort of the it's supposed to be done then. Two things. One is, I'll just comment, consequential damages are such a hot button issue for contractors. Is the Perini arbitration case in which a gambling casino did not open in time, and the contract was upheld that the contractor was responsible for the lost profits for a gambling casino. And you might imagine that a contractor will go out of business pretty fast if it's going to be responsible for lost gambling profits for an owner. So after that, everybody started doing consequential damage waivers, but the carve out is liquidated damages, which often cover damages that are consequential in nature, like a delayed opening and lost profits. Liquidated damages are not enforceable if they're a penalty. They're supposed to be a rough approximation at the time of contract signing of what the parties would assume the damages would be. Now, all of that aside, most people, so between consequential damages, which a lot of people think architects and contractors can agree on this, like they don't want to agree to it. Liquidated damages is a risk that you can mitigate, and it should be reasonable. But even if it's not reasonable, I guess in theory it's transparent, and you price that into, everybody price that into their price. Of course, you can always get somebody to sign something. Now, what I love about what you said is incentives for performance. I mean, my philosophy is you sign a contract and you say you're going to deliver on this date, you better deliver on this date. So to have an incentive to meet an obligation that seems very nice. But I do think that it's this mindset of having incentives using construction management at risk. I think you mentioned before about IPD. I've talked to contractors who say, if you can give us CM at risk, and if you can give us early involvement through design assist, and if you can give us some skin in the game for success, then we can get some great results on projects that are comparable to integrated project delivery without the trust and the fuzziness that people have trouble signing on to. Owners in particular may have trouble going away from the traditional process. But I do overall think that one, liquidated damages are a penalty or a punishment. I think it's great to have incentives for superior performance, and that mind shift of shared gain, shared pain is a good concept.
I misspoke. We do use liquidated damages in one case. That's for dorms. 700 beds where you can't occupy the beds is pretty significant. So that's the one area that we made well known to our contracting teams as they head into that. Other than that, we have not gone to liquidated damage.
So one more thing I didn't mean to mention, shared savings is a great concept, and it works well for construction management at risk. If there's no shared savings, then it's not a shared, like if it's 100% to the owner, then that's not shared savings. But actually on our website, on our consensus docs guidebook, we have, it's not in our standard language, but we have some models shared savings clauses. And what the concept is, maybe for the first, $1 million, the owner gives back, say, 5 or 10% of that money. And then as the savings get bigger, they give more of that money to the contractor because they really they benefited even more. And then there might be a floor to, you don't want to have a windfall. Maybe you guys just didn't evaluate what the incentives were. So maybe there's a ceiling on the amount of shared savings. But the concept for shared savings is it actually goes up as there's more savings, and then maybe they're capped. And that's on our website, the Consensus Docs Guidebook. If you went to the Consensus Docs 500, that's our standard construction management at risk agreement. And then we have an incentive clause based upon that. But you could plug and play that into any cost of the work with the GMP document.
I'm going to jump in. I've got a question that I hope Ashley on Zoom will respond to, and I'd like also to hear from Micah Hale. Micah, I said I would force you to comment, so this is your first shot. And here's my question. There's a lot of talk in the construction industry about more highly collaborative arrangements. such as partnering and integrated project delivery. I guess I'm a skeptic. Is the industry really moving in that direction?
This is Ashley. Good morning. I haven't seen that it's actually moving in that direction, but I will say that I think everyone is striving for a more collaborative approach. And I agree with all of the panelists who have said that, the contract is the first, that's the first step in your relationship. And with respect to LDs that we were talking about, that can an LD discussion or a large LD number on the front end can kind of start the project out on the wrong foot, because we're starting it off. Okay, we're presuming that you're not going to complete the project on time. And then throughout the project, the contractor feels like it has to be meticulous in communicating and recording every delay. And so it just seems like there's more tension there at the beginning of the project, when it really needs to be more collaborative approach. Like, hey, we are going to get this done on time, unless there is some, actual reason that it cannot be done on time. So those are my 2 cents.
Thanks, Carl, for asking. So I'm the department head of civil engineering, and kind of my role here. We graduated about 70 students or so a year in civil engineering. And as far as collaborative, kind of our responses, we're trying to teach our students to be more informed when they get out into the workforce. So, for us as an engineer, we have some of our curriculum is centered towards construction management. And in part of that course, Carl has spoken to our undergraduate students. And I think the majority of our students get out and don't have a clue about, we know acronyms, but not a lot of these acronyms. So we are pretty ignorant on some of the topics. So we're trying to inform our students about some of the contracts. A lot of our interactions with lawyers as an engineer are not necessarily good. We're either an expert witness, or something's gone bad, or we're getting sued. So we're trying to introduce our students to some of the legal aspects, and we recently began a construction management online program at the U of A, and we surveyed all the top programs, and the courses that always pop up as legal aspects of construction is what Carl talks to our teachers in our program. So as far as the collaborative, we're working on just informing our students first, and then hopefully they become more collaborative.
Carl, if I might, I think that Brian talked a little bit about cheering on dispute resolution, and I think that's critical. If it can be done at the lowest level on the project site in the project trailer, that's where it needs to be done. As it rises, it becomes a higher risk level of heading into litigation or something like that. In a previous job, I had the 10 Western states out of San Diego, and we had probably 30 locations that had their own offices that did their construction to support the Navy and the Marines. One thing I started doing, even though they didn't directly work for me, we housed about 25 Navy attorneys from the Secretary of the Navy's JAG office, and they supported us in those 10 states. I started putting a couple of those attorneys, kind of the circuit rider. They would visit the individual project sites and the individual offices, and we started to be ferreting out more problems and solving them there with other solutions by having them kind of forward deploy. And they didn't mind it at all, actually getting out and getting their hands dirty and being able to talk to the folks, talk to the contractors, see what's going on. And it turned out to be another great communication.
I wouldn't mind jumping in. To answer your question, partnering as a concept, as a written contract, is probably dead. It was something that was a precursor to that I think has led to integrated project delivery or integrated project lien delivery. That is partnering on steroids, and it has it's in the contract and it has financial incentives. I do think that while IPD is not going to be your most common project delivery method, it will continue to grow. And I think I just wanted to highlight design assist. I think everybody knows design build and CM at risk have grown as alternative project delivery methods, that they're not so alternative anymore. And we probably shouldn't call them those. And then I think it's a continuum, collaboration in your contracts. You can incorporate lien principles into your CM at risk document. And design assist, I think, has exploded in usage. And I think it gets us all almost there by getting, you can't do some of the sophisticated exterior buildings that we're doing with trade contractors without getting their expertise early in the process. Think about this. How do you usually select a design professional? Their qualifications alone and not their price. How do you select builders? Usually their price alone and just the bare minimum of their qualifications. However, in this sophisticated day and age, their trades are the ones who have the knowledge. They know how to do the design and build, that you have to get them involved earlier. And you should get them based upon a selection of their qualifications and price. And design assist and CM at risk gets you there.
Thanks, Brian. And I do want to shift momentarily to the academic side of this discussion and ask something of Dale and JB. But before we do that, we have tremendous experience out in our speakers group who are sitting out in the audience. What I'm hearing about integrated project delivery is you can't really convince significant owners, large owners, to share profit. Does integrated project delivery or share savings? Can integrated project delivery work if the owners won't really open up to that concept? Or am I incorrect that we are seeing owners share?
Two issues. True IPD is hard. Cost savings, I think, in CM at risk is fairly well established. Maybe what those terms are, but I don't think cost savings per se are such a big deal. I mean, they're a deal. Integrated project delivery with a risk pool plan. So Consensus Docs is the first to publish standard integrated project deliveries, Consensus Docs 300. We've since published a transitional document with a lien addendum for both CM at risk and then a different one for design build. Risk pool plans are hard, and you move money around from the design professional and the constructor and the trades who are in the risk pool plan. The results are great. The Lien Construction Industry Institute has blown up. Their conventions are 2,000 people. The answer is, it is hard. There's not a lot of owners who want to go to something that's fuzzy like that, and but they're getting there. General Motors has $2 billion with a B in integrated project delivery construction currently under contract.
Okay, thanks. So before I do ask my more academic question on the lien issue, we do have time. We're back on schedule, right, Justin? Which means back on schedule means you will take your lunch break a little later, all right? But you'll still have plenty of time for lunch. So we've got this wealth of expertise in our audience, and open questions are fine. The mic system actually is I think excellent out in the audience for purposes of the folks on Zoom hearing. So do we have any comments?
Gentleman in the red jacket here had a question earlier that I didn't give him a chance to ask.
No, thank you. I was just asking in terms of if you do away with the relate back on the lien, do you also then expand the deadline for filing the lien? It occurs to me that it's, pretty draconian 120 days afterward, right? But the purpose of that is because it relates back. So is that something politically that you see that might make it more palatable? Or is 120 days from the day you finished your work, just kind of, de rigueur, and no one's ever going to work away from that?
Well, I looked at, as I said, the other 8 states that abut Arkansas. And 120 days is pretty typical. Usually it counts from the date of completion of the project. And some of the states are as long as 6 months after, and some of them are as short as 60 days. So Arkansas is probably pretty much in the middle on that. And I think the point is you want to give the contractors and suppliers a reasonable time after the project's completed to see if they're going to get paid and to file if they don't. So 120 days is probably a reasonable time to do that. The relation back time is, I think, the relation back concept, I think is a reasonable concept if you're going to also require that they file at an early date something that shows they are a contractor or a supplier and therefore are going to need to get, we're going to need to get a lien waiver from. So that we have a sort of standard list of people from whom we need to get lien waivers. To me, that's the sort of reasonable compromise here. But only Kentucky, of all the states that I looked at, requires that. There are a few other states around the country that I happen to know do that as well, but not very many. And so the problem is, if you're buying a building or taking a mortgage loan on the building after construction is completed, how do you know who you need to have lien waivers from? And in a state like Arkansas, there's just no definitive way to answer that question. In Kentucky, there is, because you can look at the public record and compile a list. The title company will, in effect, give you a list. If you got lien waivers for those people, you're safe. But in Arkansas, you can't do it. So to me, that's really a reason to keep. Assuming, of course, that you endorse, as my friend over here says, endorse the concept of mechanics liens to start with. And he makes, I think, a pretty plausible argument that the mechanics lien is a reasonable way of protecting people who invest in a building that somebody else is then going to buy or take a mortgage from. Carl may argue.
I think I'm going to invite argument on that one. I think I saw Harper have his hand up.
Yeah, just I wanted to follow up on a point that Brian Perlman made about who's using IPD these days. And of course, one of the knocks on the integrated project delivery method is there's no cap on cost for an owner. You know, they're going to ultimately pay the ultimate cost of construction, which I think concerns some owners. But what I'm seeing where IPD really has established a foothold is in the healthcare sector. Hospital systems starting in California have been using it, and it's now, I mean, but even in North Carolina, I have a healthcare client that uses it often, and I asked him about it because I'm concerned they're not getting the most competitive price potentially. And what they say is, price is important, but what's more important is saving lives and quality of health, and it kind of underscores the point that owners don't simply build as cheaply as they can. There's some ulterior purpose behind a lot of construction. Another group that uses IPD often is Disney, and they also probably price is important, but the experience and what they get out of it, the quality of construction, I guess, is more important. So I think that's the hallmark of IPD, perhaps. I'd be interested in what people think about that.
So one minor point. When we did a revision, we came out with our first Consensus Docs 300 IPD agreement with Consensus Docs in 2007. And we really revamped it in 2016, and we created a concept of EMP, estimated maximum price. And we did that because lenders want a GMP to give a loan to, and that is the outward limit of an IPD project in our concept. So I just push back in that there is an EMP, there is a way for some price certainty, but your overall concept is the goal of construction should be to satisfy the client in their project and maximize value, not price. And we should be looking at life cycle. And I'd even throw in there that P3s is even another dimension where you look at the life cycle of the entire cost, where the builders and the designers might have financial incentives in that and start selecting materials based upon the full life cycle. People get creative in creating quality. But I agree with your concept. I don't think it's going to take off to be, 50% of the marketplace anytime soon, but it seems like the studies, and University of Minnesota tracked some of these, Renee Chang, I think it is. She has some good studies, and most of the people using IPD with IPD contracts, not just culture, are surprisingly doing well.
I don't want to cut off discussion on that topic. I do want to point out that, as I said early on, each panel involves an academic and scholarly perspective on some issues, and then a legal practitioner's perspective. I see the 5 minute remaining, but we are going to steal a little more time because the law review luncheon that was going to take up required a big lunch break is not occurring because it was canceled off of weather. So we will be able to talk a little more with this panel, and then still resume on time, have lunch and still resume right on time and finish on time. So before I try to cause a dispute between Dale and JD, any other law practice issues that we want to hear from? Yes, there's Patrick.
I have a question about your lien suggestions and notification and stuff like that. Some of these other people that are more experienced may be able to correct me, but I think in Arkansas, there's a statute that allows the owner or representative of the owner to demand a list of all of the contractors and amounts owed at that period of time. Am I stating that correctly?
Yes.
And so rather than requiring the contractors to post some type of notice in the deed records, could you basically, as counsel for the lender or the VFP, require that the current owner demand who has done work on this project and what amounts are owed, and then basically create a fabric of different documents where from the top down, the owner represents that these are people that worked on this project. The GC represents that these were the subs. These are the amounts. And then you have indemnifications in there as well, where they would step in, or even personal guarantees. And then maybe you could get someone to come along and purchase this project after it was done.
What do you think about that? Probably, I will answer that. Arkansas Stats Annotated 44108 is the statute you're talking about.
Yes, sir.
And it allows an owner, a lender, or anyone else substantially interested in the project to go to the contractor and say, I want a list of your subcontractors, what they've been paid and how much they're owed.
Yes, sir.
And they have 5 days to produce it.
Yes, sir.
Now, and that sounds great. The problem is that the contractor, if the project's in trouble, has a huge incentive only to tell you about the people he's paying. And so it's a good thing, and a proactive owner can protect themselves by doing it. The problem is, and this actually kind of speaks to another point that we have, the least experienced person in most construction projects is the owner who doesn't know about those things. But Arkansas has that statute, and when you have experienced counsel, we make heavy use of it, and lenders do have the ability to make that request.
JB, I was going to ask you, do you think it's fair to make the owner pay twice if it's already paid the contractor?
Interesting question, because that's I've gone to the legislature 2 or 3 times to amend that the lien laws here, trying to, in my opinion, level the playing field. And the thing that scares most legislators the most is that idea that the owner might actually have to pay twice. And theoretically, it's a possibility. In practicality, it almost never happens that way, that the owner has to pay completely twice. They might have to pay for some components twice. And keep in mind, in order for them to do that, the contractor has to commit a felony, because it is a felony in Arkansas not to use construction proceeds as they are directed out. They're supposed to pay everyone else first before paying other folks. But no, that's a risk.
Now, particularly if it's a consumer.
But and that's the hitch here with these liens. in most commercial projects, the financing is not going to be through the lien. It's going to be through bonds or other things. This almost exclusively applies to residential, which is your lowest experience level contractor. It's one of the things, it's your lowest experience level owner, because you have a consumer. They are going to have almost zero sophistication with these things. Probably the worst instance I had was a contractor with 5 or 6 houses under construction. The way a contractor goes out of business is it's not the job that they actually misbid. It's the last job, because they've been job borrowing to make up the funds, and they die at the end. So it left 6 consumers with one just a few percentage points, and the last one with a lot. This was in a bankruptcy court with lots of evil gets done. But yes, that's a risk. But there's risk that goes around to all the parties, and it needs to be spread fairly. But no, that's a substantial. And there's bound to be a way to avoid it. I haven't thought of it yet.
So let me return to this idea that maybe some scholars in the legal academy might have some ideas that the construction bar should pay attention to. And I'm going to tee up a question that I hope JB and Dale may disagree on. Ashley may also strongly disagree. I'm going to misstate something that Oliver Wendell Holmes said as an introduction. He said something like, there is no worse justification for a rule of law than it was so in the reign of Henry IV. I want to ask, is it time to rethink the whole policy behind the idea of construction liens?
Well, they can get along without them fine in England. Politically, Carl, it just isn't the least bit probable that any state in the United States is going to do.
You're supposed to be policy oriented, not. We have plenty of practitioners here to tell us what's practical. I want to know what's good policy.
There is a pretty good rationale for saying that somebody who puts their labor and materials into a product is entitled to a charge against that product to recover the money that's owed to them.
Isn't that why we have a law of contract? If they want some special treatment, they should negotiate. They choose to do work for this general contractor or this owner. Nobody made them. Why are they doing business with somebody who won't pay them? And to the detriment then of some BFP.
But after all, in the case of tradespeople who do work on real estate, they really don't have any choice. That's the only kind of work they can do. And that's so that they really have no alternative except to work for the sorts of people we're talking about. And the nature of those businesses is that they are often unstable and often end up in bankruptcy. It's a familiar story. I'm sorry, I'm singing your song.
I don't know that you got us at disagreement, but the concept, and it's the first thing I talked about. I had some notes and I sort of elevated that. It seemed to me that's the way to go. The basic problem in the construction industry is that the person supplying the work and the labor is to a person, the contractor, who is not ultimately the party that's going to enjoy the benefit of that work and labor. Because the contractor is only involved in it as to construct it, except for some of these new and really interesting means of construction. Once it's done, the contractor walks off and it's finished. And the two people left, it's going to be the owner there. So it's a way to adjust that. One of the things in general business we have is the idea of a quasi-contract, where you take someone who doesn't have a formal contract, but in fairness, there ought to be one, and you jump that gap. But you can't do that in this construction thing because there's no way that subcontractor ever thought or could think that they had an obligation from the owner, a party with whom they did not travel. So it's a way of jumping over that. They're very old. Arkansas is one of our oldest statutory schemes. The whole thing, about once a century, the Supreme Court in Arkansas throws out the entire concept. They did so in the late 19th century because someone filed a lien on a church, which they ruled was unconstitutional, so the whole thing went out. So they came back, and what they added was an immunity for religious and charitable organizations. And then in 1995, we have this curious diversion in Arkansas. We have a residential world and a commercial world. And the Supreme Court said, oh no, you can't separate them that way. And they didn't throw out the lien laws, but essentially made just about every lien in Arkansas unconstitutional, unless it had been filed after that 1995 deadline. So the courts have been fairly hostile to the idea of these liens over the years. And so, and then to your point, the owner is not always an innocent party. Often inexperienced, I will say. But an owner like our BFP, you don't get to be a BFP unless you have done your diligence to check things out, check your property rights. The owner always has the right, particularly since the 1995 amendments, to make that list, that demand for a list of people who are unpaid.
I see a sparkle in the eyes of Vivian, I believe. Are you going to get involved in this?
Well, I thought I would be, because the English have been blamed for having liens in the first place. And sitting in most countries or parts of North America, I think as a construction lawyer, I am salivating with the prospect of having lien disputes which don't form part of our makeup at all. And it's quite interesting because liens do apply, but they are negotiated contractual liens. So no overriding statutes or anything like that. But we found the solution, as I will say this afternoon, is actually to make sure people pay contractors, subcontractors, and suppliers, so that in the end, you don't need a lien in order to protect people who won't be paid. And I think that has been, if I can put the focus of the way we proceeded, is to make sure that people in the contractual chain pay, and therefore you don't need a lien in order to secure your payment elsewhere. And that, therefore, has been the focus.
Well, that's actually ultimately the purpose of the liens, is to make sure people are compensated down the line for their work.
But
it's
why
a
do you
different
need
way
that
of doing it.
security if in fact you have a good process of getting quick payment on your contracts, supply contracts, subcontracts?
To JB's point about the owner being the innocent party, often they are, but often they aren't too. Should there be more responsibility placed on the owner? I mean, they are, voluntarily participating, in the construction process. They don't have to build a house. They could buy one that's, and I'm also playing devil's advocate here, but if they don't have to build a house, they don't have to build a building. They're choosing to do that. So I'm just throwing that out there for discussion.
Definitely appreciate all the input on this. I think I saw that Phil Bruner was thinking of joining in this. So now you'll get a chance to meet both of our keynote speakers before lunch. Phil?
I was going to ask how far payment bonds are used on private construction, because every state, and I believe Arkansas is one of them, the federal government have statutes that require the posting of payment bonds on public projects. And that, of course, is carried over into a lot of private projects, where if owners want protection, they ask the contractor to put up a payment bond. Also, many states have what are called prompt payment acts that have been enacted now to give direct recourse on unpaid subcontractors to funds that may be in the hands of the owner, but really will be paid out to the contract. And so there's a lot of different statutes that have been enacted in the last few years. Some of them are called trust fund statutes.
To your point, because I also do quite a bit of surety type work. In the residential area where this would be most helpful, surety bonds are virtually non-existent. We have recently amended to David Gray sitting back here, the surety law. And one of the provisions is that if an owner gets a surety bond, the owner is now protected from any liens at all. So you get there. In some states, they have a concept, this trust fund thing, which is where, and keep in mind, virtually all construction is financed. Disney maybe pays it out of their pocket, but most of the time it's financed. And the idea with these construction trust fund notion is that it puts the bank in charge of making sure that the construction money mortgage goes out to be paid. That's an interesting concept. In Arkansas, at least, the bank, once it satisfies the very minimal criteria for having a construction loan, actually has a disincentive to involve itself to make sure the funds go where they're supposed to go. Because once they have that construction status, if they interfere, because one of the ways you become a construction lender is you agree to disperse all the funds. So I think a middle ground might be for Arkansas to go to some sort of trust fund idea to give the lender an opportunity, an incentive to go ahead and do that. The problem is the most powerful legislative force in Arkansas are the lenders. And so that is just never going to happen at all. But no, that's an interesting concept. A number of states have it. Arkansas has rejected it at each attempt. There's a good argument for it, but it's been rejected.
Problem with this, many small contractors is that couldn't possibly qualify for a payment.
That's another issue. In order to get in Arkansas previously, to get a contractor's license, you had to show some net worth. That's all been watered down quite a bit here lately. And that's the thing, that's the difference between your residential builders and your commercial builders. Many residential builders, they don't even have a financial statement. I mean, their version of accounting is what's left in the checking account. And so they can't qualify for those bonds. One of the protections I guess you get if you get a contractor who can produce a construction payment and performance bond is, you know that contractor has a financial statement on which that bonding company is willing to extend credit, because that's what that decision is. It's a credit decision that we will finance you to the extent of the penal sum of the bond. So, and that's a problem.
And some of the smaller commercial builders
can't do
it.
I think we are getting a note that it is time for lunch. So Justin is coming up, I think, to make a couple of remarks real quick before we close out. Again, for our folks on Zoom, code word is diamonds, capital D. All right, thank you.
All right, thank you so much to this panel. Let's give them a round of applause real quick. So far, we are going to break for lunch. If you got that red ticket earlier, I think probably the easiest way is to go this way, because you'll give that ticket to the registration table just so we have a good head count. If you did get the red ticket, you can just tell them that you're here, and so they set another ticket aside so they know how many people actually came. The lunches are on this table right out here, so you can just hit the registration table and then hit that table. You are welcome to eat here in the courtroom. The furniture downstairs in the atrium is set up again, so you can all sit down there as well. Razorback game, you can do whatever you need to do for the next hour, but we will try to resume at 1:10 for our keynote speakers. So please be back shortly before 1:10. Oh yes, and the speakers' lunches are already upstairs on the 3rd floor in the faculty lounge. All right, thank you. I think we're going to go ahead and get started now with our afternoon keynote addresses, but Professor Sargo will do those introductions. But before we begin, if you have a CLE form, just be sure to drop that off with us before you leave today. There should be either a table out there or you can just see a stack of yellow pages accumulating out there. We've already had a few people drop some off. So just be sure to drop those off with us today and your evaluation forms if you picked up one of those when you checked in. Right.
And Bob, can I just shut this down now? This, all right, and there's Arlen Lewis is in the back. I'm glad you made it, Arlen. We're just starting, so you're not late. Arlen will be joining our final panel. And I see some of our other speakers are rejoining us now. So welcome back. And we begin the afternoon session with the first of our two keynote speakers. And our first speaker is Phil Bruner. Many of you in the room know Phil. He's a full-time arbitrator and mediator of engineering, construction, energy, and infrastructure disputes, and is the director of JAM's Global Engineering and Construction Panel of Neutrals. Before he joined JAMS, he served as lead counsel in over 100 construction arbitrations and litigated cases in more than 30 U.S. states. He is a founding fellow and past president of the American College of Construction Lawyers, honorary fellow of the Canadian College of Construction Lawyers, a fellow of the International Academy of Construction Lawyers, chartered arbitrator and fellow of the Chartered Institute of Arbitrators in London, fellow of the College of Commercial Arbitrators, fellow of the American College of Civil Trial Mediators, overseas members of Britain's Society of Construction Arbitrators. He's a certified mediator of the International Mediation Institute. I guess you get the idea of the kind of work that Phil is doing right now, involved in arbitration and mediation at a very high level. He's a life fellow of the American Bar Foundation and a recipient of the 2011 Norman Royce Prize of Britain's Society of Construction Arbitrators and the 2005 Cornerstone Award of the American Bar Association's Forum on Construction Law. Now, Phil has authored or co-authored over 50 published articles, and he is also co-authored with Patrick J. O'Connor of the famous Bruner and O'Connor and Construction Law, a 12-volume, 11,000-page legal treatise. If you don't use it, if you do construction law work and you don't use it, you need to start using it. It's available on Westlaw, among other things. We have one of the volumes on display down here. And that's been cited by over 500 judicial opinions rendered by U.S. federal, state, commonwealth, and territorial courts. Phil's address is titled Construction Law, Its Historical Origins and 20th Century Emergence as a Major Field of Modern American and International Legal Practice. So please join me in welcoming Phil Bruner to our panel.
Thank you, Carl, and thank you for all those on the law review for organizing this fine symposium. We appreciate the opportunity to be with you. As Carl has indicated, what the subject of the talk in the next hour is going to be quite wide-ranging, covering a whole host of subjects. But to give you a broad explanation of why it is that you're probably going to want to become construction lawyers, and let you know what a construction lawyer is, what construction law is. To begin with, I'd like to look to the future. Just the next 8 to 10 years here, and then we're going to go way back into the past. But just within the last month, the Oxford Economics of London, a group of specialists with regard to where the economy is going, has come in with a report saying that since 2020, the global construction activity in the world has exceeded 13% of the total GDP of the global economy. 13%. That's like US $10.7 trillion. They go on to say that in the by 2030, that is expected to grow by 42%. Specifically, they say, quote, a cumulative total of US $135 trillion in construction output is forecast globally in the decade of 2030. And the US then would be expected to contribute about 11.1% or 14.9 trillion. Here we are in Congress talking about a 1.25 trillion infrastructure bill, which has passed, but they're talking about a lot more trillions of dollars that the US may be involved with. And of course, what does that suggest? Well, first of all, we know the construction is complex. Second of all, we know that there are a lot of parties in it. Third of all, we know that it's rather litigious. And that means that there are likely to be disputes. The contractors coming in asking you students just what your advice might be with regard to a particular problem and how you're going to resolve it. So we'll be talking about some of these types of problems. I did enjoy this morning presentations talking about housing. And it made it look as though housing is a pretty simple and placid subject, and that it all works together. But I thought I would just let you know about the complexity of housing as described by none other than the Supreme Court of California just 20 years ago. This was a case involving construction activities of a home that ended up in significant litigation. And the Supreme Court said the owners may have hoped to build their dream home and live happily ever after. But there is a reason that tagline belongs only in fairy tales. Building a home may turn out to be a stress-free project, but is much more likely to be the stuff of urban legends. The cause of bankruptcy, marital dissolution, hypertension, and fleeting fantasies ranging from homicide to suicide. And Justice Kagan noted below, quote, no reasonable homeowner can embark on a building project with certainty that the project will be completed to perfection. Indeed, errors are so likely to occur that few, if any, homeowners would be justified in resting their peace of mind on its timely or correct completion. The connection between the service sought and the aggravation of distress resulting from incompetence may be somewhat less tenuous than in a malpractice case, but the emotional suffering still derives from an inherently economic concern. So there you have it, the Supreme Court of California telling you that even construction of a simple home is very complex and may cause problems. And of course, then you go on to the $100 million bridge or the 100-story tower, commercial tower, and all of the other types of very significant projects we have in this world. You know just how complex things are. Well, let me turn back now to roughly 5,000 years. Talk a little about the origins of construction and in construction law. Excuse me 1 minute. I think it's fair to say that construction encouraged human socialization, getting humans to work together to build things was very important from what was said to be the tribal hunter-gatherers of earlier periods. And going back to mankind's oldest surviving epic poem called Gilgamesh, it speaks of the hallmarks of Uruk's civilizing construction advancements around 2750 BC. Uruk, by the way, all that's left of it is now in some ruins in south of Mosul in Iraq. But at the time, back 5,000 years ago, here's what the poem said. It was written on some cuneiform script on clay tablets by an unknown author. But it says, this is the wall of Uruk, which no city on earth can equal. See how its ramparts gleam like copper in the sun. Climb the stone staircase more ancient than the mind can imagine. Approach the Ina temple, sacred to Ishtar, a temple that no king has equaled in size or beauty. Walk on the wall of Uruk, follow the course around the city, inspect its mighty foundations, examine its brickwork, how masterfully it is built. Observe the land it encloses, the palm trees, the gardens, the orchards, the glorious palaces, the temples, the shops, the marketplaces, the houses, the public squares. Everybody sounds like a tourist brochure. But if archaeologists have confirmed that where it was built, starting at about 7,000 BC, and at its peak in about 5,000 years ago. It in fact had a population of 50,000 people crowded into about a 2.5 square mile area. And at that time, it was regarded as the largest city in the world. And so there you have it, 5,000 years of building construction. And of course, you can imagine about that time that with these kinds of construction activities, with all the things being built, why there began to be some thoughts about laws that might be applicable in the construction process. The very oldest laws known to mankind having to do with the construction process is the Code of Hammurabi. He was a Babylonian sixth king of the first empire of Babylon. And he came out with basically what you might expect, an eye for an eye code, which said if a builder build a house for someone who does not construct it properly and the house which he built fall in and kill the owner, then the builder will be put to death. Of course, you don't see anything about, well, are they building on a seismic area? Are the soils sufficiently firm that the building will stand? You don't ask any of those questions. It's just the building comes down, that's it. Of course, they go on to say that a number of other people, if a son is killed, then the contractor's son is going to be killed, and if a slave is killed, then the contractor's slave is going to be killed. And they go on to say that if a builder build a house for someone, well, he has not yet completed it, and if the walls seem tippling, the builder will make the walls solid from its own means. So you go on another couple of 3 centuries roughly, and or 3 millennia, I should say. And you get to the time of Rome's Caesar Augustus. And it was very clear that the risks building on unsuitable soils were well understood. Take, for example, Sunday is tomorrow, so we permit you to read the scripture from them. It happens to be Matthew 7:24, the final paragraph of Jesus' Sermon on the Mount. Jesus, by the way, was educated as a young man as a carpenter. And he goes on to say, everyone then who hears these words of mine and acts on them will be like the wise man who built his house on a rock. The rain fell, the floods came, the winds blew and beat on the house, but it did not fall because it had been founded on a rock. And everyone who hears these words of mine and does not act on them will be like a foolish man who built his house on sand. And the rain fell, the floods came, and the winds blew and beat against the house, and it fell, and great was the fall. So certainly, just 2,000 years ago, everybody clearly understood about the importance of foundational stability in any structure that we built. Furthermore, they learned by that time the importance of project management and the cost of incompetent management, cost control. Caesar Augustus's chief engineer was a fellow named Marcus Vitruvius Polium, known the history of Vitruvius, or as in effect chief engineer of the civilized world. And his great contribution to civilization was that he wrote a 10-volume treatise on engineering practices in the Roman Empire. And he talked about how concrete was being made out of ash from Mount Vesuvius mixed with lime and other sand and other ingredients to create concrete. We talked about a variety of things. One of the things that caught my eye was this whole subject of cost control. He goes on to tell Caesar Augustus in the famous and important Greek city of Ephesus. That's right across the Aegean Sea from Italy, in Greece. There is said to be an ancient ancestral law, the terms of which are severe, but its justice not inequitable. When an architect accepts the charge of a public work, he has to promise what the cost of it will be. His estimate is handed to the magistrate, and his property is pledged as security until the work is done. And when it is finished, if the outlay agrees with his statement, that is his cost estimate, he is complimented by decrees and honor. If no more than a fourth has been added to his estimate, it is furnished by the treasury and no penalty inflicted. But when more than 1/4 has been spent in addition to the work, the money required to finish is taken from his property. That is, his estimate is off a little bit by more than a fourth, the architect will pay for it. Vitruvius goes on to say, would to God this were also the law of the Roman people, not merely for public, but also private buildings, for the ignorant would no longer run riot with impunity. That is running around saying that they build things on the cheap, and then when the building would be 2/3 up, it was found to cost more than the budget. And of course, we worry about this with every bid project. Did the low bidder make a mistake, or did the low bidder really estimate the job properly, and what's going to happen in the end? Well, today, of course, when we have surety bonds that guarantee that if the contractor defaults, why the surety will come in and take over. That's certainly on public projects, but it shows you how a lot of the problems in construction that we face today were faced 2,000 years ago, and that over time, like things have been continued on. In the Roman legal doctrine, that is Roman law, when they had a doctrine called pactus sunt servanda, that contracts must be honored. That imposed strict contractual liability unless non-performance was excused by one other doctrine, which is called rebus sic stantibus, provided circumstances remain unchanged. And for those of you who read Restatement Second of Contracts recently, when you will see that in chapter 11, introduction, it says, quote, contract liability is strict liability. It is an accepted maxim that pactus sunt servanda, contracts are to be kept. So here we are talking about some legal principles that came out of Rome 2,000 years ago. So things are around, then around, and here we look today at what's happened from a technical point just within the last century and a half. All of the massive projects, everything, railroad, electricity, elevators, escalators, fire retardation, building controls, everything that you can possibly think of that today is, from a technical point of view, it's really generated in this 150 years. And there was about that time that the complexity of construction increased significantly. In the old days, they used to have master builders who would be in charge of the construction, the design, and the construction process. And then things changed rapidly in the last half of the 19th century when architects, first of all, they became registered under registration laws. All the engineers, different types of engineers had their own certifications and tests. Contractors had their tests too, but the whole process broke down to where everybody on a construction project had separate contracts. There weren't too many contracts with what we call today design build, where you have one party in charge of both design and construction and everything else. We're getting back to that. At any rate, you can ask the question, a construction law, what is it? Now, one of the reasons that maybe some of you have heard about construction law is that your professor, Carl Serco, actually teaches a course here. But he is one of only 3 full-time faculty that I know of who teach a course on construction law. There are another 23 or 4 law schools that teach a course on construction law, but they are taught by adjunct professors. People like Richard Smith, we see later this afternoon, teaches a course in construction law at the University of Virginia Law School. It's very interesting that academics had not been willing to come forward, teach this kind of course, except for people like Professor Serpent. We'll be touching a little more on that a little further on in the lecture. At any rate, what's happened in the last 150 years to make the law change, and make construction law really a separate entity, known as the law, is something apart from contracts, something apart from any other subject, has been what I call the doctrine of contextual contract. And that is a legal doctrine that the courts picked up about 120 years ago to, in effect, say that even if there are matters not covered by the contract, the courts may imply terms and conditions into the contract that would be consistent with the customs and practices of the profession, as well as the intentions of the parties, just based on the fact that no contract on a major complex project ever seems to be complete. Nobody ever puts in that, the last word to make sure everything works. And of course, in construction, as we know, with all the different parties you have in it, you've got a lot of communication problems with large sets of plans and specifications and other issues. Go on. So, in effect, courts have begun what I call a journey along the road leading from text to context, which means today courts will look. And here's what back in 1955, the Second Circuit Court of Appeals ruled. It said, quote, even if a word in a written agreement is not ambiguous on its face, the better authorities hold that its context, its environment, must be taken into account in deciding what the parties mutually had in mind when they used the verbal. And so you look at these, all of the special implied terms and conditions that are recognized in the law today. You have the implied duty of good faith and fair dealing right in every contract as a matter of law. You have the parties' mutual implied duty of cooperation and non-hindrance. The employer's implied duties of detailed design document adequacy, what's called the Spearman doctrine. You have the contractor's implied warranties of workmanship, product suitability. And you have a whole host of implied terms and conditions that are read in the contracts as a matter of law, whether they are physically appropriate. And you have Oliver Wendell Holmes, who you may recall was one of America's great justices on the U.S. Supreme Court, who back in, he wrote a book called Common Law in 1881 and started out with the life of the law has not been logic, it's been experience. That is, you don't simply grab words and say, well, this is what they mean, and that's it. You look at what the experience is. He wrote another law review article in the Harvard Law Review that said you can always imply a condition in the contract. Why do you imply it? It is because of some belief as to the practice of the community or a class or some opinion or policy, but because of some attitude of yours, the matter is not capable of exact quantity and measure. You've got this has been going on for a while, and in construction today, you have a lot of these implied terms and conditions. Construction law today is what I call a primordial soup in the melting pot of the law. It is a thick broth consisting of centuries-old legal theories, fortified by statutory law and seasoned by contextual legal innovations, reflecting the broad factual realities of the modern construction process. Jurisdictions have begun to recognize construction law as sufficiently unique to require certification. So if you want to go to Florida, Texas, Arizona, or even the province of Ontario in Canada, you may become a certified construction law practitioner. And why is it? Well, it's because our associations recognize construction law as being sufficiently unique. And so, in terms of the uniqueness of construction law, it is important to recognize that it is not simply advance contract law. Yes, there are a lot of contracts involved with a lot of different parties, but it's much more than that because of all of these applied terms and conditions, because the originality of every project, because of novelty of construction risk, because of rapid technological advances, mandatory mandates, the use of many different kinds of project delivery methods. We heard today about the design build, bid build, design build, construction management of risk. There's a lot of different types of project delivery systems, each with its own special wrinkles. I can go on and on. I'm going to get into delay issues, the critical path concepts, things that are unique to construction, not to any other field. You have unique construction damage measurement issues about substantial performance, betterment, economic waste, extended home office overhead recovery, extended equipment usage, unsegregated damage approaches. Again, you can go on and on. These are all things that are unique to quantifying construction damages. Now, let me go on and talk about one other thing that makes construction somewhat complex, and that's what I call the multiple human mindsets that add to construction's complexity and really increase its litigiousness. This comes out of a lecture given by a fellow named a lawyer in New York, Max Greenberg, who was one of the mid-20th century deans of the American construction bar. And he gave this lecture to the municipal engineers of the city of New York in 1954. And he started out by talking about how all the parties to the construction process have really different mindsets. He said contractors are hard-headed personalities, enjoy getting their hands dirty. That architects are ethereal, right-brain visionaries in search of aesthetic beauty in architectural design, but uncomfortable in the hurly-burly of the construction process. Engineers, on the other hand, typically are perceived as viewing the world from the left brain. That's right, they view the left brain. And they think problem solving is a mathematical exercise and have a perceived literal outlook. And of course, then you have owners who are inexperienced generally in construction. And they're thinking of things only from the point of view of how do we get this project completed quickly at the least cost and so on. Then you got lawyers and judges. And what do we think? Well, Max Greenberg said that, and I agree with him, that rarely are disputes all black or all white. And we inevitably identify different shades of gray in our search for equity and fairness. And he went on there to talk about a specific example. He said there's a basic difference in training and thinking of lawyers and engineers. There's a difference that you must understand if you want to comprehend how and why lawyers, which include judges, arrive at conclusions and they appear to you to be entirely contrary to clearly expressed provisions of the contract. So he goes on and uses as an example the no damage for delay clause. You know what this is? This is a clause where an owner puts in the contract and says, I may cause you not to be able to complete on time, but even though I'm the one to cause you that, but you can't sue me for any damage. All you get is an extension of time and no money. And so he went on. When you as engineers read a contract with a plain, understandable English statement that the owner shall not be liable for damages for delays resulting from any cause whatsoever, and that the sole remedy of the contractor shall be an extension of time, that you, with your type of background and training as engineers, regard that as a fact. He said it means what it says. To us lawyers, quote, it ain't necessarily so. Our sense of fairness may impose limitations on the effectiveness of that clearly expressed provision. Of course, he points out that engineers in particular are taught to treat everything. It's either right or it's wrong. He talked about, he said you're taught to look a fact in the face and accept it without equivocation. Steel has certain qualities and is certain defined stresses and strains You accept for what it is. It's a fact. And so here you have people who he's suggesting have these different mindsets, and some people can look literally at the contract and say, well, this is it. This is what the contract says. Lawyers are going to say it ain't necessarily so. So you can understand how we have so many different issues that come into play. Now, over the course of the last 2,000 years, disputes have been resolved pretty much by arbitration. If you go back in the ancient Roman history, but the first judges really weren't judges, they were arbitrators who were picked by the parties to decide their disputes. In the Middle Ages, at the European fairs, they had to sell goods. They had people who were selected by disputants to decide their issues. In 1622, you had a merchant who wrote a treatise on the England's law merchant. This was for the benefit of all judges, lawyers, merchants, and all others who negotiate in all parts of the world. And what he said was the ordinary course to end questions and controversies arising between merchants is by way of arbitrum. When both parties can make choice of honest men and their causes, which is voluntary and on their kingdom power. Therefore, it's called arbitrum or free will. They say that the arbitrator is to make awards according to equity of conscience, observing the custom of merchants. Not necessarily the law, the custom of merchants. What's right, what's fair. And ought to avoid all partiality. And so they go on to point out the wide use of arbitration. In this country, early on, we got into arbitration in construction disputes. There was a point back in 1876, 1874, in the case of Home Insurance Company versus Morris, where a U.S. Supreme Court said that in effect arbitration agreements in advance to oust courts of jurisdiction conferred by law are illegal or void. And so for a long time, for almost 100 years, there was this issue of whether arbitration in the construction industry could be enforced because of this Supreme Court dictum that arbitration divested the courts of what clearly the law gave them, and that parties couldn't do it on their own. At any rate, arbitration did survive. In 1888, the Associated General Contractors of America and the American Institute of Architects adopted a uniform contract called, the uniform contract, which they both endorsed, and it became the first national contract for building to be used around the country. In that contract, they provided that the Board of Arbitration will consist of one person appointed by the owner, one person appointed by selected by the contractor, and two to select the third. The decision of any two of the board shall be finally binding. So that started in 1888. It's been going on ever since until 2007, when the American Institute of Architects did change its contract to allow parties to decide if they could actually go into court instead of do arbitration if they wish. But the important point is disputes have been resolved privately for a long time. And I think many of us here, I know Vivian will be here in a moment, Smith and others have been doing arbitration for quite a while. At any rate, I'd like to get on and talk about quickly the issue of academia. And where is academia in all of this? As I mentioned, there are only 3 schools that I know of that have full-time faculty, tenured faculty who teach construction law. That's this school, I think, Berkeley and University of Detroit. Are the three, there may be others, but all the rest of the courses are all taught by adjunct faculty. And yet, ever since 1931, there have been cries that academia needs to spend more time really focusing on the subject of construction law because there are so many new unique issues that we can address. Most recently, there was a case study published in the Berkeley Business Law Review back 2004 that said legal and economic scholars have devoted little attention to an industry, construction. It seems to offer valuable lessons about the organization of economic activity. Major construction projects are generally initiated and proceed without governmental central planning, without organized formal markets for the exchange of services, and without hierarchical top-down control within a single firm. Many of the characteristics long been associated with the construction industry and are now increasingly observed in outsourcing by traditional firms. We go on and on. This is just one of a number of articles that say, hey, what's going on? Why aren't people spending more time talking about the construction industry, about construction law because of the weakness of it? Why academic scholars have been played an insignificant role is open to question, but one scholar, Thomas Stepanovich, who was actually the dean of the dispute resolution section of Pepperdine's law school now, but he was trained as an architect. He was a construction lawyer in his early days. But he said in the law review article, University of Wisconsin, back some years ago, scholarly and pedagogical obliviousness of academia, while not confined to construction contracts, cannot be explained on the basis that such transactions are unimportant. The construction industry has for some time been the largest single production activity in the United States, nor less academically rich than other commercial fields. Unless the explanation is a perverse form of intellectual snobbery, it must be a pervading ignorance of the practical significance of an academic challenge presented by the field of construction law. And Tom has written a lot of other articles in the meantime, further supporting his opinions on it. Now, it is interesting that when Justice Elena Kagan, now an Associate Justice of the Supreme Court, became Dean of the Harvard Law School in 2003, what did she advise? Well, she said in the State of the School speech, the world is changing, and in response to these changes, the law is changing and becoming ever more specialized and complex. We need to expand the faculty because the world of law is expanding, and we need to cover everything important that is happening in it. Harvard still doesn't have a construction law course. Now, as far as the profession, construction law is being taught today basically by clients who hire lawyers to teach them about their problems. And to date, there are probably 35,000 lawyers in the United States who hold themselves out as construction lawyers. Notwithstanding that, it was not until 1976 when the American Bar Association formed the Forum on Construction Law. Before then, when there was a construction litigation committee in the public contract law section, there was a litigation committee, construction litigation committee in the litigation section. But on the whole, the American Bar Association paid very little attention. All of a sudden, by a number of people in these various minor ABA committees who came together and said that we need to have a forum on construction. And the ABA was set up in 1976. It was something like 136 lawyers who were the first members there. And in 1989, the American College of Construction Lawyers was founded by 56 lawyers with experience. In today where there are litigation for construction law sections in most states, over half of the states, in red on those, various county and local bar associations. And that's where you come up with what appears to be about 35,000 lawyers. Now, in 2014, the International Academy of Construction Lawyers was founded. And Vivian Ramsey, who you will hear next, was the first president of that group. There is the Canadian College of Construction Lawyers, the Society of Construction Law of the United Kingdom, all over the world. Construction law associations are blossoming. And let me take you back very briefly to what our Supreme Court Justice, Chief Justice Warren E. Burger said back in 1985. When the question was presented to him about arbitration, and dispute resolution. He said to fulfill the obligation of the legal profession is or has long been thought to be to serve as healers of human conflicts. To fulfill that traditional obligation means that there should be mechanisms that can produce an acceptable result in the shortest possible time with the least possible expense and with a minimum of stress on the participants. That is what justice is all about. That's absolutely true. Lincoln, of course, was telling people 150 years ago that tell your clients not to go to court. It's a waste of time. Go settle. You're better off. At any rate, Berger goes on. My overview of the work of the courts from a dozen years on the DC Court of Appeals. He was an federal appellate judge for 16 years. And now 16 in my present position as Chief Justice. Added to 20 years of private practice. He practiced at a kitty corner from the firm that I first joined when I got out of law school. This has given me some new perspectives on the problems of arbitration. One thing an appellate judge learns very quickly is that a large part of all litigation in the courts is an exercise in futility and frustration. A large proportion of civil disputes in the courts could be disposed of more satisfactorily in some other way. My own experience persuades me that in terms of cost, time, and human wear and care, arbitration is vastly better than conventional litigation for many kinds of cases. How do you like that? Our own Chief Justice of the United States Supreme Court saying for certain kinds of cases, and I think he was looking at construction as perhaps one of those, arbitration is vastly better. A lot of people have taken him up on that, and of course, arbitration continues to be used considerably throughout the construction industry. I will say that I don't know how many of you have been into a courtroom where the judge comes out of a public prosecutor's office or a defense lawyer office and is cast into the place where here he's got a great big construction case. Does he know anything about construction? No. Well, there was a case here in Arkansas in front of a federal judge where the judge had the guts to say this. He called the parties in the pretrial conference. He says, being trained in this field of construction, you are in a far better position to adjust your differences than those untrained in its related fields. As an illustration, I, who have no training whatsoever in engineering, have to determine whether or not the emergency generator system proposed to be furnished met the specifications. When experts couldn't agree, here are the parties, both hired experts, the experts can't agree, and they're coming to a judge who knows absolutely nothing about engineering the generators to decide who's right. He goes on to say, this is a strange bit of logic. The object of litigation is to do substantial justice between the parties litigant, but the parties litigant should realize that in most situations, they are by their particular training better able to accomplish this among themselves. And for those of you who think when you get out, well, you know, we just won't worry about judges, we'll take a case to the jury. Anybody in this room ever tried a case to a jury? Oh, we've got one person, we got two, we got three. Okay, well, let me tell you about the advice that was given to a group of senior American and Canadian lawyers by a judge who was on the 11th Circuit Court of Appeals. Before then, when she was federal judge in Georgia for 20 years. And she said this: I have a favorite quote about a juror who talked about what a jury tried to do on the case. Quote, "Judge, we really couldn't make heads or tails of the case. We really couldn't follow all the objections of lawyers. None of us believed a lot of the witnesses. So we made up our minds to disregard the evidence and decide the case on its merits." So if you decide you want to take a construction case to a jury, well, make sure you've got a pretty high quality jury. Otherwise, you're far better off taking it to arbitration where you can pick your own arbitrators or something about construction and take it from there. Let me conclude by pointing out that there are today treatises in construction law. And we can go to those. I will say that if you go back early in Britain, where you will find that about 1250 AD, where there's an individual named Henry of Brack, who's a 900-page book on the tract and laws of customs, tract on the laws of customs of England. That became sort of the first treatise. And after that, of course, why you had Cook and Blackstone and many other luminaries who wrote treatises over the years. Interestingly, none of those treatises talked about a subject called construction law. They talked about contracts, they talked about real estate things, but not specific problems of building. And that was really unique in Blackstone's case because he was trained as an architect before going to law school and used architectural metaphors in a lot of his writings. Now, over the centuries, particularly with arbitration being involved, the arbitrators would really decide the cases by what would be called the law of the shop, rather than the law of the courts. And so the issue then came up about how can we keep preserving whatever these laws and customs are. Well, in the United States, the very first treatise that was written having anything to do with construction was the 1888 publication by Augustus Parley Lloyd, who published a 480-page book devoted to building contracts. And it was covered about half of what we call construction law today. But interestingly enough, in his introduction, he makes this observation. Possibly the most remarkable omission in the literature of law in this country is the absence of any work upon buildings, building contracts, and leases. Subject is one of great importance, not only to the legal profession, but to fully 3/4 of the general population who are interested in building operations, where there's purchasers, architects, contractors. Numerous books have appeared from time to time containing theoretical or historical and artistic views of architecture and the art of building, but no American writer has yet compiled the building laws of our country to any practical extent. Now think of that as our first treatise, if you will, on construction law, 1888. In 1894, another treatise, this one only 400 pages, was published by an individual who was both an architect and had a law degree. His name was T.M. Clark, and his book was called The Architect, Owner, and Builder Before the Law. And what did he say is in his introduction? It seems to be agreed among lawyers that no controversies as a rule are tried before courts with so little satisfaction to the litigants and their counsel as building cases. The lawyer finds them usually so technical as to require an amount of special study on his part quite disproportionate to their importance. While parties to the controversy often suffer or think they suffer as much through what they regard as their counsel's inability to understand building matters as through what their counsel with more reason considers their own inexcusable ignorance and neglect of the legal principles relating to their business. These difficulties are obviously such as can be relieved to a considerable extent by treatise, by writing, by scholarship. In England, 1891, there was published Hudson's Building and Engineering Contracts, 800 pages. And that's now in its, I think it's 12th edition. But even then, when it was reviewed for the first time in London's Quarterly Review by Sir Frederick Pollock, who was Oxford's professor of jurisprudence and distinguished author of Principles of Contract, published in 1876. All Pollock could say was the subject of this portly volume is too technical to admit of more than summary notes. Well, there's been other wonderful treatises published since. Keating on Construction Contracts, 11th edition, 2020. Our next speaker, Vivian Ramsey, is one of the co-authors of that. And he's put his heart and soul into it, along with his members of this. Barrister group. And there is also another English treatise. I have not seen it, but by Julian Dale, called Construction Law. In the United States here in 1992, Professor Justin Sweet, who is known to Mark, wrote an article in which he talked about what an American treatise might be. A treatise that systematically collected the leading cases, stated the holdings accurately, summarized case law correctly, and evaluated basic principles and so forth. It took until 2002 for a treatise to be published. This one initially was 7 volumes. It's now 12 volumes, 11,000 pages. It is called Gunnerman Construction Law. It has been cited 500 times by federal and state courts. And it has been an effort has been made to try to be as comprehensive as possible. So let me conclude by saying this: the construction law is a great field. It's something that cries for additional lawyers to learn the nuances of it and become knowledgeable, not only about surety bonds or particular types of buildings, but the entire field. One thing that Vitruvius, our friend Vitruvius, the chief engineer of the civilized world, said 2,000 years ago, something that was equally applicable to all of us today. In conclusion, well, let me read what he said 2,000 years ago. It was a wise and useful provision of the ancients to transmit their thoughts to posterity by recording them so that they should not be lost, but being developed in succeeding generations through publications and books, should gradually attain in later times to the highest refinement of learning. And so the ancients deserve no ordinary but unending thanks, because they did not pass on in envious silence, but took care that their ideas of every kind should be transmitted to the future in may all of you do so that this great field of construction law can continue to have building blocks for which to go. I would now like to introduce the next speaker.
If I could interrupt, first of all, could we have questions and discussion until after Vivian speaks? I wanted to point out that we do have a code word for those who are getting CLE credit through Zoom. And could I see that code word again so I don't mess it up? The code word is mockingbird. Again, the code word, if you're claiming CLE credit on Zoom, is mockingbird. So now I'll turn it back to you, Phil, for the introduction of Sir Vivian.
I hope that was intended as a reflection of the past speaker. The next speaker is someone who I have had the privilege to know for some 35 years. We were appointed years and years ago when he was a young barrister and I was a relatively young lawyer to serve as arbitrators on a case on the island of Nassau. We worked at two brothers on both islands. We sent down to Nassau to arbitrate a case. And we got down there, and of course, the parties were still in negotiation. They called us, but we ended up settling the case after we spent a few days down there. So during that time, we got to know each other, and known each other, and been friends ever since. It's a great privilege that I introduced you to Sir Vivian Ramsey. He graduated from Oxford in engineering and spent 8 years in the fields of Libya, practicing his engineering expertise. And then decided in 1978 to get a law degree, which he did from City University in London. And he, of course, was called the Middle Temple. The bar, he joined Keating Chambers, called Keating on Construction Contracts, is the name of this treatise. But in Keating Chambers, that was in 1980, and he became a junior counsel in 81. He became quickly a Queen's Counsel by 1992, 10 years. He went to that high level. And what Queen's Counsel means is that you're viewed as being in the top 5% of England's barristers. It's quite an honor. And of course, his qualities were recognized even after that, where in 2005, he was appointed to the High Court, Queen's Bench Division. And I have, of course, confirmed that he used to be called Sir Vivian Ramsey, although he doesn't necessarily demand it. But we used the Sir, but he was knighted by Queen Elizabeth when he named upon his appointment to Queen's Bench. Once on the court, by the time he went on a few years, he was put in charge of the Technology and Construction Court in the Royal Courts of Justice. He will be telling you about this Technology and Construction Court, whereas on the one hand, in this country, arbitration still prevails, although some construction cases do go to court. In England, why most of the construction cases go to the Technology and Construction Court. So there are reported decisions on them, but Vivian was the chief judge until 2010, and he continued on the court until 2014 when he retired, so to speak, and is now an international judge on the Singapore International Commercial Court on 2015 to date. That means that he's called over frequently. He's traveling all over the world to hear cases coming out of that court or out of the Singapore International Arbitration Center or other places. But he is a fine person. I want to acknowledge also his wife, Barbara, Lady Barbara. And we're delighted to have you here with us. Vivian.
I hope you can hear me somewhere. at the back. First of all, can I thank very much Carl Serco and the Arkansas Law Review for inviting me here today to see all of you in person and all those people I can't see who are watching us by Zoom. I'm delighted to be here and to follow the cerebral paper which Phil Bruner has presented. My topic today is construction law, unsurprisingly. Over dinner last night, I suggested I might have an alternative talk, which was my journey from New York to California in a 1957 Chevy a few years ago. Some people thought that might be more interesting than my talk on construction law, but I'll take a vote at the end to see whether you'd have preferred that to what I'm going to do. So construction law. Construction law is, of course, not in itself a body of law. It derives and applies other forms of law. So that particularly it draws from the general law of contracts and of torts. And its importance from everybody's point of view is that most of the modern developments in contract and tort law, certainly so far as the English courts are concerned, have come through construction cases. And the reason they've come through construction cases is that, of course, the most complex points that can arise, do arise, and are thought of by construction laws. They seem to have a predisposition to find within the expertise of construction ways of teasing out the most difficult points of law. But construction law covers all sorts of other areas. We've heard of liens, we've heard of bonds today, insurance law, land law, landlord and tenant law, employment law, intellectual property law, public procurement law, as well as many regulatory fields such as building regulations, environmental, health and safety law. So it contributes greatly to the field of all of these parts of law. Now in this talk, what I'd like to do is first of all to look at the way in which construction law has developed in the English common law world from its roots in England and Wales. And of course, the word common law arose because it was a law which was applied and was common to all of the king's courts across England. And when I refer to England and Wales, that is because in our jurisdiction of the United Kingdom, we also have Scotland. But having some Scottish blood in me, I can say this, the Scots are somewhat awkward. They would not have just the common law, but indeed they have part of the civil law system built within their jurisdiction. And my other ancestry is Northern Ireland, and Northern Ireland has a separate law as well, but that is much more developed from the common law. So whilst the common law applies in many, many jurisdictions around the world, and the English derivation of that law means that although English precedents of the court are no longer binding, but only persuasive in most of those courts, they are persuasive. And so very often it's the decisions, particularly in the field of construction law, which will be applied by courts all over the world. And that, I think, has two derivations. First of all, as Phil Bruner was saying, in England, we have a specialist court, and we've had it for 150 years. I say we've had it for 150 years. It's only recently been called the Technology and Construction Court, and it had rather darker ways of coming into fruition in the first place, because High Court judges, when they had a construction case, would try the easy points in it, and then there was a system by which the difficult points were referred out to an official referee. And the official referee then ended up with all the difficult points, so that, for instance, what is the price of an additional door hinge was not something a High Court judge thought they should really determine. And so they sent these out originally by way of reference out to an official referee. And those official referees, because they had to deal with the real meat and bones of construction cases, then became construction law judges. But it was only within the past 15 years that the court has been called the Technology and Construction Court and has come of age. Partially, I think, now we look back because everybody has to have a celebration. And in 1873, the official referee's business started, and that just happens next year to be 150 years ago. So we can say that the Technology and Construction Court is 150 years old. But that court has made decisions on many standard forms of contract, which are now used throughout the world. And the particular one, there used to be something called the Institution of Civil Engineers, Conditions of Contract. And that was one which, if you actually looked at where it derived from, it was about the 1860s that it started. And the language had been tinkered with, but substantially was the same as it was in those days, with some modern takes being added. That form of contract was then adopted as the international form of contract by the Federation of International Consulting Engineers, FIDIC. And now, wherever you go around the world, from Africa to the Middle East, to India, to the Far East, you will find the FIDIC form of contract is used. And the law, which has been created by considering the various conditions of the original English form, now apply to the FIDIC forms. And that means that if you are dealing with an arbitration in Dubai, or you're dealing with one in Oman, or you're dealing with one in Japan, it is very likely that one of the cases cited that arbitration will be a decision of the English construction courts on that particular form of contract. The other advantage is it's in English, and interpreting wheretofores and how to ofters and so on in terms of a standard form of contract is slightly easier for English-speaking people, although it's not even then very easy. So then I will look at some of the construction law concepts which have grown up over the years. I think when you look back at the development of construction law, one finds that in the Victorian era, where construction law started out, the perception and the feeling of what was important and who was important probably differed from what we consider today. And so what I'll be looking at is some risks and liabilities which were established in the 1800s, and also the way in which in those days one looked at the professional engineer and the professional architect compared to the way in which we consider them today. And then by way of conclusion, I will look to see how now the English courts have developed a new practice of dealing with payment claims extremely rapidly, which has, to the perception at least of the construction bar, done away with the need for a whole load of other remedies which have been developed to try and ensure that people are paid within the construction industry. So let me turn first of all to the English courts. And I'm afraid I haven't got anything which can quite compete with Phil Brunner and the Wall of a Rock, or Plutarch, or Hammurabi's code. But I can say we have had some notable successes in some of our prehistoric buildings which have been built in the UK. The one which comes to mind is Stonehenge, which some of you may have seen, which you may think is just a hopeless circle of standing stones with arches above them. But I have to say, the reason I think it's standing is that if you go there on the summer solstice, you will find that the major stone is aligned with the sunrise on that day. And I think one can understand that that was probably one of the few projects which was actually fit for purpose when it was constructed. And if you go there today, you will also see at the summer solstice, the sun rising precisely where it should do compared to the standing stones. And so for 3,100 years BC construction, I think one would call that a success. Little remains, as you'd expect, of the history of construction of that. The other great period of early construction was, of course, when the Romans decided to invade in 55 and 54 BC and lived with us, or perhaps I am one of them, until 409 AD. And they developed some of the most wonderful civil engineering structures, such as Hadrian's Wall, which goes across the North Country and was to separate Britannicus from some people north of the border who we now know as the Scots. There is also the best known set of baths, the spa baths at Bath, which was a shrine to the Celtic god Sulis, and they are the only working baths which are still working now and using the same systems which were built by the Romans. And so the two examples I can give you are of things which were created a good number of years ago and are still being used. How many buildings we are now constructing will be talked about by somebody standing here in 3,000 years, I do not know. Now, the interesting thing about disputes is, of course, we know very little about disputes. But every so often, some archaeologist does discover something. And the earliest arbitration award, which has been found, dates from AD 114. It's an interesting dispute between two people who seem to have Roman names, and they were disputing about the ownership of a wood in Kent. The only problem is they've only got the first page of the arbitration award, so one doesn't know the name of the arbitrator, you don't know the resolution of it, but at least we know that arbitration was up and running in 114 AD. Now, how were disputes resolved in those days? Well, most of them, as we've heard, were dealt with by merchants. They were disputes by merchants, either with clients or people they supply. And still today in the City of London, there are the livery companies, which were the trade groups, which were established, the earliest one dating from about 1155 AD. And 2 years ago, I was master of a city livery company, which was called the Constructors. I have to say, it's a more modern livery company than 1155. But the trades in the livery companies included the earliest one were the carpenters in 1271, then the painters, stainers, the masons, the plumbers, the tilers and bricklayers, joiners and sealers, plasterers and glaziers. And all of those had trade organizations where if there was a dispute between a merchant, that livery company or guild would come involved, and there would be a solution found between the two companies. And they would have a justice system. The modern English justice system came about in the reign of King Henry II, who established a jury of 12 local knights to settle disputes. And most of the disputes were, of course, in those days, over the ownership of land. Gradually, the court system developed, but as one will find out, the courts were castigated for being inefficient, for being bureaucratic, for taking a long time to resolve matters. And still, therefore, people went to arbitration because that was thought to be a more satisfactory way of dealing with it. Then came the Court of Chancery, and that was to unleash equity, the ability of the courts to do right as between the people, rather than being bogged down in a certain amount of bureaucracy and form over substance. And therefore, we developed the Chancery practice. Then the major law reform was 1873, when the modern court system was set up. Now, within that history, we have managed to produce some pretty good specialist courts. And I'll mention two particularly. In 1665, there was the plague, which occurred in London. And in 1665, a baker decided to overcook the bread and burn down most of the city of London in the course of it. What happened then was, of course, a lot of buildings had been destroyed, which had been let on leases by landlords to tenants under a variety of repairing clauses, some of which had a form of insurance on it. And the question was, it's likely a COVID-19 question, after this disaster, how do we get everything back on track as quickly as we can? And what they did was to bring in a statute which created something called the fire courts. And the fire courts had a jurisdiction which allowed them to set aside what the agreements were and come up with an agreement which was fair in all the circumstances. And that would include, for instance, granting a slightly longer lease if the tenant would put some money into repairing it, sometimes giving the landlord the benefit of having the property free for 2 years until the tenant moved in, and adjusting rent and adjusting all the obligations under the agreements. And this was done, and it was said that after 2 years, they now had a complete body of law of how they would deal with these, and it brought the City of London back within about 2 years after the Great Fire. The other court, of course, is the Official Referees Business Court, which became the Technology and Construction Court. And I have to say that what it has done is really to step in and deal with aspects of construction law where we have specialist judges. When I joined, there were 8 specialist judges in the court, and they had dealt with construction claims, they had dealt with unforeseen conditions, They dealt with variations, that is change orders. They dealt with every sort of case during their experience. They had dealt with delay claims. They had had programming experts in front of them. They had quantum experts. And they had built up a degree of expertise. And this had allowed them, therefore, to deal with some of the most complex cases and establish the law which applies. In addition to sitting as judges, they can sit as arbitrators. There's a special provision which allows them to sit as arbitrators, but it is only in exceptional circumstances where the Lord Chief Justice says they can. And I'm afraid the number of times the Lord Chief Justice thinks there's no work there and can do that is very limited. Now, in terms of the TCC, Technology and Construction Court, what they managed to do was to create most of the modern procedure which we have in the English courts. Part of the modern procedure, I have to say, is sitting in court in a suit with a jacket and tie and not wearing robes except on ceremonial occasions. Although in my wardrobe, I still have a suit of robes and 3 sets of wigs, all of which can be worn on ceremonial occasions if required, or indeed to dress up like Father Christmas at Christmas. But the other side of it is that we sit in those courts without a jury. In England, there are no jury trials, civil jury trials, except you can elect to have one for a libel trial if you wish one. And obviously, if you deal in libel cases, one knows the sorts of cases where you might want a jury and the sort of cases you wouldn't want a jury. But otherwise, the judge is the finder of fact and also directs, obviously, the law. And so that is, I think, a particular advantage. Not only do you get the specialist fact-finding of a specialist judge, but you also get the application of the specialist law by that same specialist judge. We've introduced originally witness statements in place of evidence in chief. Lists of issues are commonplace. Monthly case management conferences with the judge to make sure that the case is proceeding in the way it should do. Most of which are vacated because the day before the case management conference, the parties write in to say they have now done everything they should have done in the previous month. But it means that what you do right at the first case management conference is to set the whole trial procedure up to and including the length of trial plus closing submissions. And so the parties then know the complete timetable up to the end of it. And if a trial is set down for 10 days, it's a 10-day trial. There is no chance of going over it. We lock people down to each party having 50% of the time. If they can't present their case in 50% of the time, bad luck. What they've got to do is to choose their best points during the 50% of the trial. And it works, I have to say, amazingly well in making sure the cases are brought to a conclusion. The other matter I will deal with in the context of dispute resolution is the application of something called adjudication, which came in as a dispute resolution method effectively in 1998. Now, construction law really only took off in the 1800s. The earliest case, it's got to be an earliest case in everything, dealing with construction law was actually 1611, which was the case of proclamations, where James I decided to prevent the construction of new buildings, and his proclamation was then overturned by the court, saying he didn't have the power to do it. In those days, there wasn't a TCC, so it had to go to the standard court. Starting though with a case in 1872, for instance, which was a case of a bridge contractor building a railway in Brazil. And one of the questions which arose was they had a lump sum price. Now, we all know about lump sum prices and how difficult they are for contractors. And in this case, it was a lump sum price, and the engineer had drawn up all of the bills of quantity for this lump sum price. And so I think you can see the way a construction lawyer would think, well, it's a lump sum price, but the client's engineer has drawn up the bill of quantities, which lo and behold, were not accurate. And so you can see immediately, I think in one's modern feeling, the construction lawyers, I can see them smiling around the room, would see an immediate case of some sort of misrepresentation underlying the lump sum, which may allow you to recover more. Well, I'm afraid the courts in 1872 were not terribly happy with this because, of course, the contract set out that the contractors were to execute and provide not only all the works and materials mentioned in the specification and in the bill of quantities, but all such other works and material as in the judgment of the company's engineer are necessary and reasonably implied in, or as we saw, or inferred from the specification or the bills of quantities or the plans or sections, it being the true intent and meaning of the contract that the works and materials to be executed and provided by the contractors under this contract must be everything for the perfect execution and completion of the railway. And so you can see the way in which things were going, despite the fact that the engineer had produced a detailed statement of the quantities and had got it wrong, the contractor had to foot the bill. And it was said that there had been some supplementary agreements. The engineer had had some words with them while they're on site and encouraged them to do some extra works, which they hadn't really got to do. And the court said, bad luck, whatever the engineer said did not affect your ability to recover anything but the contract sum. Another case which showed the way in which things developed was Ranger and the Great Western Railway, which was the railway from London to Bristol. And there the engineer, as it turned out, again had drawn up a schedule of rates and the contractor alleged there had been a fraudulent misrepresentation by the engineer as to the nature of the soil. In other words, he had described it as one thing and it was something else. Again, that didn't cut much ice with the court. Therefore, the final thing they thought was, well, wait a minute, we suddenly have realized that the engineer is also a major shareholder in the client company building the railway. So isn't this a conflict of interest? That he is the engineer certifying for all of this and at the same time is profiting from the railway company. Surely you can see the lawyer saying, at last I found a way of getting around this lump sum under this contract. In dismissing this ground, the court stated, "It is not necessary to state the duties of the engineer in detail. He was in truth made the absolute judge during the progress of the works of the mode in which the appellant was discharging his duty. He was to decide everything, and from his decision, there was no appeal." After all, they could have gone to arbitration. And it said that everybody, the duties thus confided to the principal engineer were of a judicial nature. But Mr. Brunel, and this is someone called Isambard Kingdom Brunel, who was one of the great engineers of the era, was the principal engineer. It was known by them. He was the principal engineer by whom those duties were to be performed on behalf of the company. And that he was himself a shareholder in the company made no difference to his position, because he was acting on behalf of the company, and therefore he could be a shareholder in that company, and they didn't see any problem. Several other cases showed that the Victorian attitude towards the engineer and the contractor was generally that the engineer was a professional man and the contractor was a tradesman, and the tradesman, by and large, in the way in which society acted in those days, was the person who took the risk. And in the construction of Blackfriars Bridge, although the whole design had been provided by the employer and proved to be ineffective, the decision was that the employer did not warrant the possibility of constructing the works in accordance with the plans, and the contractor took the risk. Now, I think one can say that construction law, luckily, has developed beyond that. And the question, a more recent question arose as to whether or not, if you had a certificate and you went to court, could the court open up, review and revise that certificate, or could that only be done if you went to arbitration? And there was a Court of Appeal judgment saying only the court would do it. The House of Lords in a later case threw out that proposition, and they said this: in this case it was the architect, but it said the architect is the agent of the employer. He is a professional man in this case, but can hardly be called independent. One would readily assume that the contractor would submit himself to be bound by his decisions, subject only to a challenge on the grounds of bad faith or excess of power. It must be said there are instances in the 19th century and the early part of this one, that's last century, in which contracts were construed as doing precisely this. There are also contracts which provided that in case of dispute, the architect was the arbitrator. But the notion of what amounted to a conflict of interest was not then as well understood as it is now. And of course, the inclusion of such clauses was a matter for negotiation between the parties at a time when there weren't standard forms balancing the interests of the two sides of the industry. So I think one can see that the development through construction law has changed emphasis. And I think that's one of the great advantages of having a common law, is that the courts can develop the law as time goes on, and perceptions of how liabilities and risks should be allocated can be better allocated. The second issue which caused some difficulty over the years is the question of liquidated damages. It caused difficulty, as we shall see, in a case in 1838, and as we heard from our panel today, still in 2022, liquidated damages cause difficulties. One of the problems which arose is, of course, a liquidated damages clause says that if you don't complete by that date and you're 2 weeks late and it's £100 in the early cases per day, it's an automatic £200. There's no argument. That is the way liquidated damages apply. And the courts in 1838 were not terribly happy that if the employer, that is the owner, delayed the project by 2 days, then the owner was still claiming liquidated damages. They said, you've delayed, we may have delayed you, but you've delayed, and in those circumstances, we want our 2 weeks of liquidated damages. Luckily, there was a thing called the Commons Digest, which was produced in 1720 and set out the various principles of English law. And one of those was that a party who disables the other party from performing cannot, that same party, pursue an action against that party for the failure to perform. So in other words, if you prevent a party from performing, you cannot in the same breath then blame the other party for not performing. And that principle, which comes from Common Digest and is still applied today in the English common law, was applied in the case of Home and Guppy. And it was said in those circumstances, the position is left at large. And there was then a heated debate, and I have to say it still goes on today, as to what that means. Does it just mean at large that you can't recover liquidated damages, but you can establish your proved damages, unliquidated damages, for any period of delay you can say has been caused by the contractor? That's one possible. Or does it mean that the whole of the contractual scheme of liquidated damages and a date for completion goes? The way in which English law has gone is in favor of the second of those. So that, for instance, if you have a contract and there isn't an extension of time clause, I should say, is an underlying premise here, no extension of time for the reason that has caused delay by the owner, then in those circumstances, the time obligation goes. You have no obligation to complete within the original time. We call it in English law, time goes at large, and the contractor then has a reasonable time to complete. Now, if you actually look back to the premise of Home and Guppy, and you trace, as when you see my paper, I have traced the law on this, you will find that, in fact, although in the past 10 years, that has been stated in high courts as being the authoritative statement, time goes at large and the time obligation goes. In fact, the law has not established that, and the law has established the contrary, which is if an owner if a contractor delays the project because of the owner's default, no extension of time clause, all that happens in those circumstances is the original time for completion remains, but the owner can only claim damages, not liquidated damages, but unliquidated damages for any period of delay they can prove. And that appears to be the state of the law, although the English common law has not quite reached that conclusion for reasons which are explained in more detail when you read the article which comes out of this talk. Now, in terms of the final topic, which I'll go to, that's the question of how we resolve disputes over payment. I think one will know from experience that construction payment claims, I think, are probably the key to most of the difficulties which have arisen within the construction industry, either because it's a variation which hasn't been paid, or there hasn't been payment of the work which has been carried out because there's been under certification, or even sometimes there's been overpayment. But payment disputes cause the problem. Now, in the UK, the government set up a review of payment practices in the construction industry. And out of that review came a principle of adjudication. And I will explain it simply. What it is that under a construction contract as defined, any party to that construction contract has a right to refer a dispute to an adjudicator. That adjudicator has, as a matter of statute, to be appointed within 7 days, and has, as a matter of statute, to make their decision within 28 days, or with the permission of the party referring the dispute, 42 days, or any other period if both parties agree to it in the course of the adjudication. That decision is a temporally binding decision on the parties. It isn't final and binding, it is a temporally binding decision until a court or an arbitration finally decides that question. The procedure, and this is where having a technology and construction court is absolutely essential, is that in those circumstances, the party who hasn't been paid, I have to say, in the majority of cases, payment follows from the adjudicator's decision. If it's not paid, you go to the court. Within a week of you going to the court, you've got a hearing fixed and a procedure which takes normally about 2 to 3 weeks to get to the hearing, with all time when it's bridged. And there is then a hearing and a decision on that challenge to the adjudicator's decision, and it leads in about 70% of the cases to the enforcement as a judgment of the court of that adjudicator's decision. Now, what has been interesting in that process is that thousands of cases now go to adjudication under that principle. And so a subcontractor, a contractor who has not been paid, or a supplier who has not been paid, provided it's a construction contract, and there is obviously a definitional question of that, but they are defined within the Act. Provided that occurs, that person can get a decision enforced by the courts, generally within 2 months of the dispute arising. And that means 2 things. First of all, the knowledge that you have that ability means that people now pay up. I should say it is also combined with various statutory provisions in construction contracts. You can't have pay when paid clauses or conditional payment clauses of that sort. There's a strict routine for payment. And if you don't have that strict routine for payment in your contract, there is a statutory scheme which brings it in. So first of all, it has led to people now realizing they can't not pay up, because within a short period, they will be forced to pay up, and they'll have to pay interest, often at a commercial debts rate of something like 12%, which means that they, in those circumstances, don't really like it. 2 things come out of it. One is something like 97% of the cases are resolved on the basis of the adjudicator's decision. Although it's temporally binding, either the parties pay up on the basis of that decision and that dispute is disposed of, or if they don't pay up on it, they negotiate their way out of it with the other party in order to bypass it. So what it shows is a lot of the perception of solving construction disputes is we have to have an interminable process to get to the absolute fairest position on it. And what it's shown is that what is a very brief period to come to a decision gives you a decision which the parties will live with. There are grounds to challenge the adjudicator's decision. If, for instance, the adjudicator, he or she did not have jurisdiction, or if they failed to apply the rules of natural justice, although the courts have said what is natural justice has to be tapered to what you can do in a month's time. So that what I think one shows is people will accept that there is no cost recovery, and so both parties pay their own costs, which is another perception. People didn't think people would be interested in going to adjudication if they couldn't recover the costs. And so what one's found is from one provision of the statute in section 108 of the Housing Grants, Construction and Regeneration Act, a form of adjudication has come out of it, applied in all construction contracts in the UK. It's now spread like wildfire, so it's applied in, for instance, Australia, Malaysia, Singapore, Ireland. Ontario has just introduced it. Various jurisdictions are bringing it into construction contracts. But not only that, standard forms of contract, even in those jurisdictions, and Hong Kong and South Africa are behind the curve in bringing in the legislation, they've now introduced it as an express term of the contract in those countries as well. And the way in which, the rather cunning way in which it's imposed is if you don't have an express adjudication provision in your contract, one is brought in by a statutory implied term. And there's a statutory scheme which brings in that implied term into your contract, which ensures that every contract, therefore, has adjudication and you can't contract out of it. So I think one can see that two things, I would say, come out of this, what I've indicated. First of all, I think the importance of having a robust way of dealing with disputes at the time is of great importance. And secondly, the need to have a specialist court with specialist judges who are behind the construction industry in making sure that these particular adjudicators' decisions are properly enforced. And that has been the lesson of all the jurisdictions where that has happened. So on that note, I will conclude. Thank you very much for listening to me. And I think, subject to anything else, we will now have the Phil and Vivian show when you can ask us questions and we'll decide who answers. Thank you very much.
We have a code word. Again, the audience here doesn't care about code words, but our Zoom friends do if they want continuing legal education credit. And I have forgotten the Zoom link. You held it up, and I have forgotten it already because of my advanced age. Pecan, P-E-C-A-N is our code word for our Zoom attendees. So now we have questions, answers, debates, whatever you choose, Vivian and Bill. Anyone like to ask a question? One of the two of us. Yes.
For Phil, this is a devil's advocate question. I like this phrase from text to context. how does that jive with the Federal Circuit and its plain meaning rule for contract interpretation?
I think that,
I don't know if people heard.
People need to repeat the question.
Repeat it for people on Zoom.
the question was in the comment that I made about the courts being on this journey from text to context. How does that fit with the courts? I would say other courts' statements that they just look at the four corners of the document.
What's the plain meaning?
Well, I think what you're seeing overall in the United States is that courts really are going to context. There are very few cases now that I see where courts simply say, well, the four corners of the document say this, so this is what we're going to do. I mean, let me just give you a couple of examples of how these implied terms and conditions began, and it was in the early 20th century. Back in 1854, I think it was, just before the Civil War, around there. There was a case called Dermott versus Jones, I believe it was. It was a dispute between a contractor and an owner. The owner had given a contractor a contract saying, and you agree that the building will be constructed in a suitable and usable condition on completion. Well, the only problem was that the owner's architect hadn't done a proper soils analysis. So after the building was up 3 stories, it started settling. And the whole case went to court on the question of whose responsibility was it. Was the obligation of the contractor to tear it all down, put in a different foundation, and build it up again? And lo and behold, the US Supreme Court, after it gets all the way up there, says, well, the contract said that the contractor would build a building that would be suitable for use upon completion. And he didn't do it. And the fact that it was the architect that didn't do a proper soils analysis, that didn't make a difference. I mean, the contractor built in accordance with the architect's plans, put it up just the way the architect showed, but yet the building settled. The court said, well, that is the sanctity of contract. We are upholding the sanctity of contract, and that became known as the sanctity of contract. Here, back in the Spirit case, which was 1917, facts of the case were a little different, where the contractor was to dredge out the Brooklyn Navy Yard and to make it deeper. And in order to do that, they had to reroute a sewer that had gone through a part of the Navy Yard. And so they rebuilt the sewer just to show it in the plans and specifications. Well, it turned out that sewer at the time drained out into the ocean. And there was some big tidal surges out there that pushed water back up the sewer. And lo and behold, the sewer broke right about where it had been replaced and flooded this huge excavation. And so the contractor said, well, I did it just the way you show your plan showed, but I shouldn't have to be responsible for pumping out and draining all of this huge excavation area and having to redo it. Well, the Navy said, too bad, sanctity of contract. You took a contract and you didn't provide a finished product suitable for use. I mean, there's some similar kind of language in that. Well, the US Supreme Court said, contractor having been represented by Charles Evans Hughes, who later became a US Supreme Court justice, that under the circumstances, contractor had done what the contractor was supposed to do in building that sewer exactly in accordance with the designer's plans and specifications. And the fact that the sewer broke was not the responsibility of the contractor. The court said that there was an implied warranty that if the an owner provides a detailed set of plans to the contractor, and the contractor has agreed to follow and did build in accordance with those plans, risk of anything coming out of the deficiencies in those plans belong to the owner, notwithstanding general language saying that the contractor's got to complete the project in accordance with so it's suitable for use and so forth. I mean, that really is kind of design performance spec. But I don't know, did I answer your question?
Sure.
So we have applied duties, and it's from that point on where it's just Katie Barley, they all started coming in. There was 4 or 5 U.S. Supreme Court cases in that period of time leading to the construction.
Yeah, I mean, in the English courts, the four corners rule dominated practice probably until about 1960. So in other words, one looked only at four corners. And then we had the addition of context, in other words, factual background matrix, allowing you to interpret it, being introduced on the basis that that gave you knowledge of the two people who entered into the contract and what objectively they meant by the terms of the contract. And we've had, I think, something like 8 Supreme Court decisions since then, either putting up the level to which you can use some sort of extrinsic evidence to construe a contract, or putting it down, or putting up the commercial purposive construction of the contract, or putting it down. And the current view is we're down closer to the four corners of the contract now than we probably were in, say, 1950, 1960. But we treat implication as somewhat different, that one goes for the true construction or by necessary implication X, Y, Z is the way in which we think in our cases.
Other questions from the audience?
Any observation?
As always, of course, I'll have a question. Other questions from the audience? So and this is for both of you, but I've been dying to ask Phil this question for a long time, because Phil, you have written a number of times about transformative events in the history of construction law. Do you project a new transformative event for our current era?
Right. Needless to say, that's a broad question, but transformative events, at this point, it's probably going to be technology is occurring. For example, there are new ways of measuring time and delay. Different, we're seeing it, for example, with drones. We're seeing that a lot of different devices are out on the construction site now. But basically, are providing technology that aid in collecting data, which then go into helping resolve disputes down the road. But as far as the law itself is concerned, I think we're going to continue seeing more of this development. And I quoted this 1955 case of the Second Circuit Court of Appeals, where a judge just said that even though the language is ambiguous, it's a better approach is for the court to take a look at whether it really express the intent of the parties. That gets back to the whole question about, well, Judge Learned Hand used to say you can't make a fortress out of a dictionary. I think we're going to continue to see the issues of interpretation and implied conditions being brought in. And these implied conditions are very interesting. I remember another case quickly involved the issue of owner disclosure of information required by the contractor to really perform the contract. And the contractor had a dredging contract to dredge a reservoir in Indiana. And contractor got out there, the contractor bid the job using suction equipment, which is what dredging contractors usually use. When he got out in the middle of this reservoir, where he's running into all kinds of concrete and steel members, all kinds of stuff at the bottom of the reservoir. And he had big trouble with it. He brought a claim. And a couple of days before, and the owner said, no, contract said you're going to complete the dredging, you're going to take out so much material, and you didn't do it. A couple of weeks before trial, the contractor found an old retired employee of the Public Works Department of the city of Indianapolis, and asked the guy, well, do you know anything about all this concrete stuff out of this reservoir? And I said, oh yeah, we ripped up a streetcar line. We took all the stuff out there and just dropped it. Well, the court ruled that there was an implied obligation on the part of the city to have informed the contractor of what to expect, because there were old records way back. They could have found the information. The city didn't do it. The court held it was a breach of contract. The board of the contractors. So there is going to be more like this, all dependent on the particular facts. The courts are looking for fairness. They're not anymore simply going to say, well, as this old Dermot Jones case said, you said you were going to complete this building in accordance with, so it'd be suitable for use at the end of it. The court's not going to look at that anymore.
All right, this was a spectacular. Did you have something to add, Ricky?
No, nothing.
I think we're back on time. Justin will tell us when we resume.
So we are going to take a little break real quick, get everyone a chance to stretch their legs. We do have some snacks that have been provided out there if you want to grab something small real quick, but we're going to try and get on track again at 3:20, so about 7 or 8 minutes.
So,
PR final. Okay, so. That's.
No. Otherwise.
Yes. This is like.
Specific terms, grandiose intent of the contract. Yeah, we had a matter.
He's on your panel.
That's good.
These cheers, Atlas,
So guys. One of my first observations.
Jessica. Good to meet you. Yes, glad you got here, glad everything worked out.
It did. Thank you so much for your help.
Good. Glad you got it here.
Unless on logistics. About 20.
Well, we have to take it.
For you guys, we got I'm also.
Richard Harlan, it's good to see you.
Well, I think it's that weekend, it's all the. All right. All right, good. That'll be right. Let's try. Yeah, where do you care what we do? I'm gonna get you 3 more, which I just texted.
Do you think Zoom will affect you?
In my world, since I'm, other people think talk about construction.
That was my experience. US.
Exactly right.
So I give me a second. Let me make sure it's. It's probably not highlighted. That's right. She's obviously going first. And we're gonna get queued up on the.
You have a time.
I'm doing something now.
Well, I think we are.
Oh, I am.
Started, and I think, yesterday, it looks like we need a couple more seconds.
Well, that's another issue. We're gonna generally take up to this topic.
Well, I mean, sometimes.
That's the same as your life. You know, you get your life child.
I did not think so.
Is it all with the red light?
Yeah.
I told somebody, see each other again, so that people kind of like hug each other.
Did we start, Justin?
All right. Hello, welcome back to our last panel. All right, for this theme, so by the way, I'm the moderator for this panel. I'm Bill Foster. I teach here, I teach business and tax law classes. So I am not a construction law expert, but I can introduce construction law experts and try to keep them to the agreed upon time schedule. So I will introduce our panelists and then get out of the way. For this theme, the third and final panel, teaching construction law topics and techniques. For this theme, the panel reflects on construction law teaching and scholarship matters at the heart of this symposium. We begin with a topic that merits greater attention within the academic community, and then we reflect on learning objectives and teaching techniques characteristic of construction law courses. For this distinguished panel, we are going to first hear from Andrea Boyer, who is the Norman R. Poses Chair in Business and Transactional Law at Washburn University School. She has an extensive background in practicing, teaching, and writing about legal topics at the nexus of contract and property. She's written and presented on issues relating to the housing crisis, the secondary mortgage market, common interest community governance, and bankruptcy, and she's currently working on projects exploring transactional freedom and individual liberties in the context of real property development and control. Professor Boyak's presentation takes us into the rarely examined relationship between condominium ownership structure and the objectives of assuring well-constructed and well-maintained buildings, a timely topic for sure. Next, we'll hear from Carl Serko, the Ben J. Altheimer Professor of Legal Advocacy at the University of Arkansas, and he spoke with us at the beginning of the day. Carl will draw on his symposium paper, Construction Law Apologetics, as well as his recent book, Contract Law in the Construction Industry Context. That will be the platform for assessing the rightful place of construction law in the legal academy, which is, of course, the topic that our next two panelists will discuss. We'll hear from Richard Smith, who is counsel with Smith, Pachter, and Porter in Tysons Corner, Virginia. He teaches construction law at the University of Virginia School of Law. And for approximately 50 years, Mr. Smith has been primarily engaged in matters relating to construction and contract disputes resolution. As a founder of Smith, Pachter, and Porter, his practice currently involves dispute resolution as a mediator, arbitrator, project neutral, and disputes review board member. Mr. Smith is a recipient of the Cornerstone Award by the ABA Forum on Construction Industry and is a fellow in the American College of Construction Lawyers. He was named as Arbitration Lawyer of the Year in Washington, D.C. by Best Lawyers 2020 and a Construction Thought Leader by Who's Who Legal in 2020. We'll next hear from Parker Heckman, who is a member of Nexon Pruitt, the firm in Greensboro, North Carolina. He is the former chair of the firm's construction law practice group. He teaches construction law at the University of North Carolina School of Law. And Parker has extensive experience counseling clients in a number of sectors across a wide range of concerns. He is one of only 3 North Carolina lawyers inducted into the American College of Construction Lawyers. This is one of only 5 to receive the Band 1 ranking in construction law from Chambers USA. He was named Greensboro's 2013 and 2018 Lawyer of the Year for construction litigation and Greensboro's 2017 Lawyer of the Year for construction law by Best Lawyers in America. In 2015, he was elected chair of the ABA Forum on Construction. We will then hear from Arlen Lewis, a partner with Blueprint Construction Counsel LLP in Birmingham, Alabama. For 20 years, his practice is focused on representation of owners, contractors, subcontractors, developers, and other construction industry participants on a wide variety of issues arising out of complex commercial construction projects in the private and public sectors. Arlen frequently speaks on legal issues in the construction industry and conducts client training sessions specifically tailored for the needs of the client team. He's held numerous leadership positions within the ABA Forum on Construction Law, including serving on its 12-member governing committee, and he is currently the forum's chair. In addition to participating in the panel's ideas for collaborations between practicing bar and legal academy, Arlen will update us on several of the forum's current initiatives. Last but not least, we've got David Grace, who's joining us as a partner from Hardin Grace at PA, a law firm in North Little Rock, Arkansas. His practice emphasis is construction and commercial litigation, surety representation, and bankruptcy. David graduated from Hendrix College and obtained his JD with honors from the University of Arkansas at Fayetteville, where he was an associate editor of the world-renowned Arkansas Law Review. He is a contributing author to the American Bar Association's Performance Bond Manual and the Arkansas Construction Law Manual, and he's recognized in the construction and bankruptcy sections of the Best Lawyers in America. David will offer an Arkansas practitioner's perspective on construction law and on training future construction lawyers. All right, and with that, I will kick it over to our first presenter, Andrea Boyack.
Thank you, Will. My paper talks about structure, and it talks about structure, two different types of structure. One that we've talked about a lot throughout the day, the structure of actual buildings, but it's also going to talk about the structure of ownership, the legal structure. Early in the morning on June 24th, 2021, a disaster occurred in Surfside, Florida. Champlain Tower South, a condominium with 136 units and 12 stories. More than half of the building collapsed, killing 98 people. This was the deadliest multifamily building engineering failure in US history. After an arduous search and rescue, and after attempts to safely bring down the rest of the building and shore up the community that was mourning the loss of these lives, people started to look around and try to determine exactly why this tower collapsed. You know, what could have happened differently? Who was to blame? And how to prevent this from happening again? Because after all, the only thing worse than having a deadly collapse of a 40-year-old building in South Florida would be if it happens to other 40-year-old buildings in South Florida. Now, Surfside was a tragic example of a multifamily building. And there seemed to be multiple problems with its construction, but this building was also a condominium. And that's a legal ownership structure that enables individuals to hold title to apartments, to a box of space. And it's actually the only legal ownership structure in our legal system that permits someone to hold a box of three-dimensional space in fee simple title. You can, of course, be a joint member of a building with a co-op, but many people who own are owning through the ownership structure of a condominium. Otherwise, you are renting your space from the owner of the building. Now, theoretically, condominium governance ownership structure should align the incentives and empower residents to ensure that they are living in a building that is adequately structurally sound, that it's kept up to a good level. Unlike situations in other rental buildings where we've had a crash of fires in the past 6 months, for example, landlords are not disassociated with the people living in the building and owning the property. If you're spending money to keep up the building, that money actually goes to an asset you control. So when looking at what went wrong at the Champlain Tower South condominium, there's likely an engineering component, but there's also a legal component as well. One related to design of not only the building, but the design of the ownership. We've heard from lawyers and engineers and people who are experts today talking about construction law. I'm going to talk about an area of construction law that intersects with laws governing common interest community and pose the question of whether condominium governance design contributed to the Surfside disaster and ask how we could potentially improve the legal architecture of condominium law in order to lower the chances of something like this happening again. Now, when you look, no, it's not. Oh, there we go. When you look at the Champlain Tower South in the months since, there's been a lot of discussion about what went wrong. It seems like there were some problems with the design itself, certain walls weren't designed the right thickness, and some of the support columns weren't quite as plentiful or as wide as maybe they should have been. There's some questions about the quality of the materials used. Some of the concrete, when they were taking down the rest of the building, was surprisingly soft without granular parts in the middle that would shore up its strength. And then there's been problems about whether or not there was cost cutting in the construction. It seems like maybe some of the waterproofing design, for whatever reason, maybe to maximize short-term profits, were not done according to the best standards, even in 1981 when it was built. There was also a neighboring development that abutted it that came later, and it seems that maybe that neighboring development weakened one of the walls, the one that ended up giving way or pulling away from the building that caused it to collapse. And so there are many engineering issues here as well. But the interesting thing is that all of this was known. It was known 4 years, almost 4 years before the collapse of the building. Now, if this had happened in another part of Florida, perhaps the owners of the building would not have known that these issues were plaguing their building. But because Florida State doesn't even now require reinspection of multifamily buildings that are older, but the city of Miami does. Because in 2000, after the devastating Hurricane Andrew, they passed a law that required buildings get recertified with respect to their structural soundness, et cetera, every 40 years. And Champlain Towers was turning 40 in 2021. The board of directors was on the ball. They ordered a study done 2 or 3 years before this deadline. And that engineering study done by Morbido Consultants looked at the condominium units and roof and facade and parking garage and pool deck. And they determined what structural issues faced so that the board could assess it and plan for needed repairs. So far, so good. The engineering report identified a lot of necessary repairs. And then they warned, waterproofing is beyond its useful life and therefore must be completely removed and replaced. The failed waterproofing is causing major structural damage, and failure to replace the waterproofing in the near future will cause the extent of the concrete deterioration to expand exponentially. That was in 2008. The board of the association response looked into hiring someone to remediate. They got some bids, but 3+ years went by and they had not even started doing this remediation work by the time in 2022 when the towers collapsed. So the report identified these problems in 2018. It seems like these are many of the problems that caused the collapse. So what went wrong? Part of this has to do with the fact that the people making the decisions maybe didn't quite appreciate the extent to which this was causing a risk of their building. But also the owners likely, didn't read and understand the engineering report, but they did understand one thing, and that was this is going to cost $15 million to fix. And that's a pretty big chunk of change, and they didn't want to see their pro rata share of such a huge expense get assessed to them through the assessments. And so there's a lot of evidence that they delayed and they resisted, and many of some of the board of directors resigned in protest, and many of these people that resisted died when their building fell. And it's very easy to say, well, they should have known better, but how many of us do the same thing when we resist infrastructure improvements in our own country because we don't want our taxes to go up? And that's basically what was going on here. So that led me to this query. Could we better design condominium governance to prevent this tragedy? We've been talking about design of building. This is the ownership of the building, which governs how the building is kept up and how to make sure that it is well established to begin with. And I thought of sort of 3 main ways that theoretically condominium governance, if it works correctly, should ensure quality. The first one has to do with having some sort of construction quality from the beginning by having a designated entity, the board, who can seek some sort of claim against a construction party who has done something wrong. It's not like the person who constructs the building continues to own it. If they sell to the different owners. And it's not like those owners don't have a collective action problem and nobody can bring a suit. The association and the board is empowered to bring a suit on behalf of the whole owners. I also thought about whether or not there could be better upkeep to ensure structural integrity. A lot of discussion since Surfside has focused on that. And then also an important, but I think less discussed question of how we improve the financial reality so we can ensure that the money's there for needed repairs. There's been some discussion of that, but I think some of that might be a little bit wrong-headed. very quickly, because I wasn't sure how familiar everybody is here with respect to condominium governance. And when I teach, I don't teach construction law, but I do teach about common interest community law. Theoretically, condominiums are set up as a way to have there be a common resource or amenity that we can govern through joint governance in a way that doesn't cause tragedy of the commons. We'll talk about what that is in a minute if you don't know. Also, it solves collective action problems like bringing a lawsuit for a construction design problem, and it also internalizes the benefits of the maintenance cost by allowing owners to be the ones living there, not just tenants. Tragedy of the commons, I took this picture around the corner, my husband's here, he'll notice this path near our house. We were walking a day after a snow and we looked at this and it reminded me of this article that I read a few years ago in NBC.com that basically asked the question, when you have these snowy sidewalks where part of them aren't cleared, whose job is this, right? If we all do our part, then we can have the whole thing done correctly. And that's really the problem with tragedy of the commons. If you say everybody needs to contribute to maintain the building, some people might not do their part. They might leave their walk unshoveled, as it were. And the condominium structure is supposed to avoid that problem. Everybody in the condominium owns their own unit, and everyone is a tenant in common in the common areas. Anyone who's had a property law class hopefully knows what that means. It means that you have joint ownership over the common areas. But if you had a joint ownership with 136 owners, it would be pretty hard to reach consensus about what to do. And so we have an association set up to manage the condominium. Oftentimes they hire a professional manager to do a lot of that management, but they are the buck sort of stops with them. Every unit owner, by virtue of being an owner, is a member of the association. And the day-to-day operation of this whole thing is done through a board, which is elected. These are volunteers. They are not paid. They are unit owners. They are not professionals. And that's an important thing to remember, because the decision makers at Champlain Towers and other condominiums are not professional commercial real estate folk. They're just regular old people who happen to agree, usually kicking and screaming, to go work in the condominium board of their home. Assessments that individuals pay for all of this. And so there's a wonderful division of financial responsibility, but there's also a financial linkage. If one person doesn't pay, you don't have the money unless you can collect from that person or collect from other people. Technically, the condominium is established by filing in the land records something like a condominium declaration. You create governance basics and bylaws. Architecture and engineering info is in detailed plats and plans that explain exactly what's in the unit and what's not. And there are disclosures to would-be buyers. Now, condominiums are creatures of state statutes. There's the Uniform Condominium Act, there's the Uniform Common Interest Ownership Act, but every state has at least some statute that enables this to happen. It allows you to divide the property up in a three-dimensional way, and then the unit is owned in fee simple by owners. The condominium association itself owns nothing. This is something I find a lot of non-lawyers have no idea. They say, well, the association owns that. Well, no, the association is a manager. They just make sure things get done. They're governance only. So that's basically what's going on with condominiums. Just one more picture. Units are what is owned. The common element is what everybody owns. There's some limited common elements where individuals have particular rights. This gives a lot of flexibility, both with respect to development, but also with respect to how you divide up the responsibility financially and practically for maintenance. Compared with other types of ownership of a multifamily building, I think it's interesting. I like this little cartoon, I use it in my class, to explain how this works. In renting, just starting from the left, moving over to the right, in renting, the building owner owns the whole pie, and everybody just gets the crumbs that are handed to them in terms of the value. In a co-op, everybody is part, they all own it together, and everybody holds together the ownership of the pie. The management part works very similarly with a co-op and a condo, but in a condo, we slice up the pie and give everybody a piece. But the one thing that this doesn't really show is that you can't slice up everything in a condominium multifamily, right? You still have the roof, you still have the structural beams, you still have all of the common areas. So there still are common areas that are held in sort of a co-op way. Now, theoretically, if you are the owner and you also reside there or have this sort of direct interest as opposed to a renter, you should very much want to have the property kept up to a high level of quality. You can internalize those costs not only through your enjoyment, but through increasing your own equity. And so you would think that condo owners would want to invest, sort of the sweat equity kind of issue. Oops. There we go. So as mentioned, one of the ways that condominium ownership could help ensure quality construction would be having some sort of accountability to a condominium. The problem with that really is that there's a transparency and knowledge issue with individuals who are buying. We do get through the collective action issue and standing by having an association. But another issue is that a lot of developers are the ones who draft all of the documents that set up condominiums, and they might create some barriers to suing them, and there's some protections that make sure that they can't be held, put on the hook inordinately, maybe limiting their damages and limiting times to bring claims, et cetera, et cetera. I know I've talked to several people in condominiums over the years who've had trouble seeking recovery for bad construction. On the other hand, you don't want there to be scapegoating. You don't want it to be that the owners don't maintain and then they want to blame somebody else, like the developer. I like this little cartoon, if you build it, they will sue. So another thing is to make sure that we have adequate maintenance. And that seems to be one of the biggest problems in the particular problem of the Surfside condominium. Ideally, this shouldn't be as big of a problem when you divide up the cost. 15 million is a really big number. You divide it by 136 units and it's 110,000 per unit. But 110,000 per unit, if your unit's worth 700,000, is a pretty big chunk of change. There are some practical limitations on upkeep in that you have to have people want to do it. The board of directors may not understand what needs to be done, but even if they understand, you have to get enough of the populace to come along with you. And like I said, we don't want our taxes to go up to pay for infrastructure. It's exactly the same thing on a smaller scale here. As I mentioned before, the board members are not experts. These are volunteers, lay people. These are neighbors. They don't want to upset their neighbors. These are members of the community. And I think that a lot of times common interest community ownership leads to a governance that's supposed to be a little micro democracy, but like micro democracies, it's messy, right? Like Winston Churchill said, democracies are the worst form of government except for all the rest. And that's kind of what we see in microcosm and condominiums. You can have a lot of resistance, especially when we're talking about changes that require people to reach into their pocket. In addition, the board always has a temptation to delay to the extent they can sort of the bad messages, the things that are going to upset people, kicking that can down the road to the next board to deal with. All of these sorts of things about not wanting to pony up the money, not understanding that you have to pay money to maintain, that it's not just a question of an upfront cost. Questions of the board waiting for other boards to have to deal with the problem might lead to a temptation to delay necessary improvements and necessary remediation and repairs, and perhaps that's what happened in Surfside. But the other problem is that people might just not have $110,000 sitting around to pay their special assessment to maintain the building. We saw this problem when in the aftermath of the foreclosure crisis, when a significant number of units in South Florida in particular were not paying their assessments, and people had maybe decided to defer bankruptcy, or they just were not able to, they were not solvent, and they hadn't had a foreclosure yet, so there was not a solvent person who had taken control of the property. Who do you get those assessments from? If you have to have enough money to operate and to maintain the building, and half the people aren't paying their assessments, the only way to do it is increase the assessments on the remaining paying owners, which then drove them to default on the assessments. And there was this terrible domino effect. Some people said, why don't you just have them declare bankruptcy? But associations cannot declare bankruptcy. So there's this financial entanglement in the community, and there's some vulnerabilities. If you have people not paying assessments, you actually use your qualification to get loans from the FHA or things bought through Fannie and Freddie. The association also only can recover, but there's limited collection ability, and there are potentially lien priority issues, which we'll talk about if we had time, but don't. So I'll move on to my second query, which is, okay, even if we can identify exactly how to shore up the governance design of condominiums. How do we get there? Do we make changes to local law, to national law, to state law? How can we get these improvements in? There are several legal mandates that have happened that pertain already to construction, as we know, and these are being examined in the context of the Surfside disaster. Code requirements, reinspection mandates. This is a new hot button in South Florida. How frequently should there be reinspection? And then exactly just in sort of a transparency question, who gets to get the information from these new reports, prospective buyers, as well as local government inspectors. But there are also, and some oversight of the process. There are also some percolation discussion of some changes to the law pertaining to condominiums, particularly with respect to transparency, and not just transparency with respect to the structural integrity of the building, but also transparency with respect to the budget and the reserves and things of that nature. Repair and upkeep requirements being something that condominium leadership is required potentially to do and not just given the option to do, and similar with reserve requirements. We also have to talk about protecting those board members so they don't get sued by their neighbors if they make them pay more money. Since again, these are volunteers. And then maybe we should look at how to better streamline ability to collect the assessment, or maybe disclose to people that are prospectively buying that they'll have to pay. But another important thing is to consider whether we need to provide some backup funding for people, because a lot of times people are on fixed incomes and being told that they have to come up with $110,000 in cash at that moment is not even feasible, even if they wanted to contribute. I will go through this super quickly, but I'm happy to provide slides. We want them later, but let me just say there's been a report by the Florida's Condominium Law and Policy on Life Safety Issues Advisory Task Force, which was convened in the aftermath of the Surfside disaster. And they had basically, I divided it into sort of four main thrusts of the report. One is they think that there should be an additionally frequent and detailed reinspection of the building. So instead of it being 30, 40 years in Miami and none anywhere in Florida every 5 years. This is not law. This is just a proposal. They also expect there should be more transparency in terms of the quality and the maintenance issues, as I mentioned. A mandate of a larger reserve fund being held by the condominium to equal 50% of the cost of replacing all the components is the proposal. And accountability, help, oversight, maybe some education assistance for anyone involved in the ownership, and maybe some financial assistance. But this is not the law yet, by the way, and there's questions of whether any of this will ever get passed into law. But in some ways, it doesn't even matter all that much, because we've had a de facto change in what has to be done in condominiums due to the fact that Fannie Mae and Freddie Mac, who are huge players in this market, the biggest lenders with the biggest market share and thus wield the biggest stick, they changed temporarily what they are requiring for condominium types of projects that they will lend on, loans that they will buy. And they have said in their new temporary requirements that there must be a certain level of reserve funding, that if there's any deferred maintenance, they will not make any loans on those buildings at all. And so this cuts off a lot of buildings potentially from being funded, and really puts the stick there to make sure that people fund. What I think would be interesting to see if maybe they could also offer a carrot and maybe offer some financing to help the construction actually get done. Because just, punishing the condominiums for not getting the work done might not be enough to cause it to happen, because it's not just will, it's also way. The other thing that people have said is that this will drive down prices of condominiums, which I just want to put up a couple of charts in my last 30 seconds. That maybe is not the worst thing, because, spoiler alert, we might have a couple little bubbles going on right now in terms of housing prices in certain sectors of the economy. And I will say that it does make me worried when we have this kind of divergence between a lot of demand and not as much supply. And we've seen this before. We saw it right in the first 5 years of this century. There could be a rush to construction. We've seen some problems with that because of demand being so high. And if we have a down market again, like we saw in 2008, there will once again be the problem that we saw then, which is in these common interest community of like condominiums, they might not have the wherewithal to come up with the money to make the repairs that we need. And the last thing we need is to not have enough solid structural design in our ownership governance structure that we cause a problem in the physical structure and lead to a disaster like we saw in Cersei. Thank you.
Thank you, Andrea. I think Justin is going to move the slides, and I'm going to start in our next conversation. Andrea, do I have to ask you, is that a picture of the Dixon condominium here in Fayetteville?
I had one there, Fayetteville, yes. I put it in particularly so you would notice. Oh.
Well, I didn't notice it when I saw them before, but I did notice it now. That's where I live.
Professor Serka, before you begin, for our Zoom audience, we were told that during the fourth code word, there was kind of an audio issue. So just to repeat that code word for the fourth panel, or for the fourth segment, which was our second keynote, it was pecan or pecan for some people, but pecan, like the pie. So thank you.
Okay, so we're going to talk now about teaching construction. Finally getting down to the point, why would we teach construction? And I've written a paper, which I hope you will all read, but I'm not going to deliver the paper. The paper is called Construction Law Apologetics, and it's just that. It's a defense of teaching construction law and undertaking research and scholarship in construction law. Of course, as the first bullet says, a construction law course will expose law students to advanced torts, advanced contract, advanced lots of things, ADR. So it's good for that. But what about the more important point, at least from my perspective, which is that I think that a construction law course is one of the ideal vehicles for training law students for a highly complex commercial practice. If we get a chance, I'll defend that later, or maybe somebody will challenge that. But my main purpose here is just to pass over that point and to briefly say, if you read the paper, you'll see the segment on why I think that construction law is a wealth of topics for research and scholarship that we are overlooking. But you've heard some of that and you've seen some of that today. So I don't want to take much time to talk about teaching construction law because we have Richard Smith and Harper Heckman, teachers at Virginia and North Carolina, who are also well-recognized construction lawyers. So they bring the practitioner's perspective into the classroom. And I think Richard is going to start us. And you don't need to pay any attention to these points on the slide, Richard. They were just things that we had talked about. There are no more slides. So Richard and Howard, Richard and Harper, the show is yours to talk about why teach construction law.
Thank you so much. I am a lowly adjunct at the University of Virginia Law School. And so I teach a course in construction law. And when I started thinking about this, I really thought about how can I make this course interesting for students. Construction, the first thing I found out is that construction is a very, very broad area. It's not all litigation and muddy boots. It's just more than that. And I had to try to really stretch myself to figure out how to bring in all the aspects of construction law into the seminar. The second thing is I had to try to figure out how to develop opportunities for women and for people of color. Virginia Law School this year is 51% women. The undergraduate school at UVA is 56% women. And the number of people of color in the school is 36%. So I really had to think about how to broaden it. It's not all litigation and muddy boots. And so I had to think about how to broaden it and try to make it interesting to these folks. I'll talk about it a little bit later, but one of the things I decided to do was to bring practicing attorneys into the course as guest speakers. I thought when I was in law school, when I graduated from UVA in 1969, and the seminars were very interesting because they had actual people who were doing the work. And so I thought, well, I would try to do that. So I started teaching construction law at UVA in 2009. It took me about 2 years to make the right contacts to develop how to put together a syllabus for it. And so I really started off a lot earlier than that. Now, my background was basically in government contracts. I represented a bunch of construction contractors who did government contracts. And also I had a lot of experience in representing the metro contractors who were building the metro system in Washington, DC. So I think I knew a fair amount about construction, but it was mostly from a government side. I previously taught law school at University of Richmond and also William and Mary, seminars like this with some other attorneys, practicing attorneys. So I was somewhat familiar with doing that. But mostly my experience was in government contracts. I was a law clerk at the Armed Services Board of Contract Appeals when I was in the Air Force JAG Corps. So that gave me a lot of background in government contracts. So I had to expand that. And so when I proposed my syllabus, I contacted the construction law section about a book. And here's something you've probably never seen. This is the softback copy of the construction law book, published in 2009. So I got them to send me one so I could prepare for this course. So we had 13 sessions, and we all started off with Phil's introduction to the law of construction, chapter 1, and worked our way to spearing. I always told the class that once you really understood spearing, you could claim to be a construction lawyer. So that was what I tried to do, to start with spearing and work from there. So another thing I did when I considered a construction course was I wanted to make it relevant to the students at UVA. So I went over and talked with the facilities managers at UVA and asked them, can I get copies of contracts for the buildings that you have at UVA? I really wanted to start off the school with John Paul Jones Arena, because that's the big basketball stadium at UVA. And so I talked to them about that, and that was a CM agency contract, construction management agency. And they just said that was just too difficult for me to pull out that. And then I went over and said, well, what about, I guess you didn't know, but they put the Darden Business School and the law school, they combined them together. And Darden built the Taj Mahal just a little bit away from the law school. So the law school took over the Darden Business School. And I talked about that, and they said, well, you know, we better not do that. They said, what about one of the buildings that's going up right now? And I said, well, that's a possibility. And so I ultimately got all the contract documents for a building at the School of Education. It was going up right when I was teaching the course. And that was very interesting because, you know, I could get all the copies of the documents for construction and I could go through them, and I began to meet some of the persons in facilities, which was very important because I met a young lady, Kit Smith, who was a project manager in the facilities area. And we developed a relationship. And so later on, I'll talk to you about what I did about site visits, because as part of the course, I would take the students out and we would see an actual project that was being built at UVA. So basically, I thought one of the interesting things I asked the facilities manager at UVA, I asked him, well, what's a dispute provision in the contracts at UVA? And he really looked at me sort of shocked and said, disputes? He said, we don't have any disputes. He said, we are partners. I'm a partner with the construction contractors. I thought that was very interesting. And I have some thoughts about that, about the partners. I think they have some fairly subjective criteria for choosing the contractors. And I think that plays a role in if you make some disputes. So the first year I taught the course, I think I made about $10 an hour because I taught all 13 of the classes. I had to read this book and develop a course outline. I think I made about $10 an hour. Also, I gave a test, and I found out that it was very boring for me to look at a paper, which basically regurgitated what I said in class. But that's not going to work. So the next year, the second year, I decided that I would say, I'll teach the course since I've done it, prepared it, but I'm going to ask people to either take write a paper or to take a test. And it went about 50-50, writing a paper and taking a test, which I thought was very interesting. Another thing I have to mention is I found out that very, very few people that took the course actually practiced law in Virginia in the future. They didn't go to, they went to, some went to Richmond, but most of them went to DC or New York City or the South. Now they go to the South. They go to Charlotte, Atlanta, Houston, Dallas, Miami. So I don't have many students that stay in Virginia. So I had to change the course because of that. I couldn't teach Virginia law. I had to go much broader than that. The third year, I decided that we're all going to write papers. And so what I would do is I would work with the students and we would pick a topic that I thought was interesting, that they liked, and that they could research. Interesting enough, when someone would propose a topic to me, the first thing I would say, go look at Phil Bruner's treatise and see what they say about this topic to see if there's enough information about it. So I tried to get them all basically knowledgeable about Phil's treatise. So anyhow, that's what we did. We write papers. Now, the good thing about that is that I learned something from the papers, right, because I grade them. And they really become an authority or have a lot of knowledge of a very narrow part of the construction. And I tell them, you need to do that because you need to know something. If you go into a law school, a law firm, you need to be the go-to person for that particular area. You can develop that right in this course. Now, I also tell the students to submit their papers to the construction law writing contest. Now, we have won about 5 or 6 of the writing contests. I just bought a couple of them. They're published, by the way, in the Construction Lawyer after student Wednesday. And so I just brought a couple of examples. And also then I started to have guest speakers. And I also found out that a lot of foreign students were coming into my class for reasons that I didn't quite understand. So I started to talk to them. But I've had students from Mexico, Colombia, Japan, Switzerland, Qatar. Why were these people in my construction class? So I started talking to them. And so I talked to the young man from Qatar who, I said, why are you taking my class? And he said, well, I want to get involved in the construction project for the World Cup, which is coming up in Qatar. And so I thought to myself, I said, that's pretty arrogant. Don't you think a third-year student or LLM student coming to me and saying, I want to get involved in the World Cup? So I thought about that. And so I started looking up the guy's name and to see if he's part of the royal family. I don't know if he is or not, but I thought that was really interesting. The young lady from Japan, I asked her, why is she in my course? And she said, well, she was in-house counsel for Toshiba. And so she said, Toshiba just bought Westinghouse. I'm going to go to Pittsburgh to work for Westinghouse, and then I'm going to go and work on the nuclear power plants in Georgia. I thought, well, that's really interesting too. And you know, the nuclear power plants have had tremendous problems. And whether she's there or not now, I don't know. So I went and had 5 guest speakers. And just for your information, the guest speakers were project delivery systems, you know, talking about design, bid, build, then to P3, and then to CM and the integrated project delivery systems. I had somebody representing architects. Now, that's really an interesting topic because then you move from Spirin to basically a standard of care. So you introduce tort in representing architects. So I had people, that's their business. That's all they did was represent architects. I had a government contractor attorney, Joe West, many of you may know him. But he basically talked about the fraud, representing government contracts, fraud, waste, and abuse. That's a big thing now, fraud, waste, and abuse. And it also is in a lot of state laws. Virginia has a law that basically parallels the federal area of fraud, waste, and abuse. I had somebody talk about construction insurance. Now that's really a specialized area, construction insurance. And then I had a friend of mine who was a testifying expert who came in and gave a class on a CPM schedule. Now, every big construction claim has a part of CPM schedule. So I had him do that. You know, my time is getting short, but I want to cover, if you don't mind, a couple of other areas. Another thing that we did is we went, as I mentioned earlier, a site visit every year. So that allowed them to put on their hard hats, put on their gloves, put on their, their yellow vests and everything, and go out and visit a construction site. So we've looked at a chemistry building, a couple of renovations of dormitories, a new dorm. But the most interesting project that the kids really, sorry, all kids, but they really liked was the renovation of the rotunda at UVA. So for 2 years, we looked at the rotunda. I don't know how many of you know about the rotunda, but if you go to the University of Virginia, you will see the rotunda. And what they really enjoyed was having the architect of UVA talk about what they found when they basically took the walls down and to their level, to the original things, and what they found underground around the rotunda. And they tried to analyze what was Jefferson's original plan for the rotunda as to how it would be used. And that was really something. I mean, they talked about that a lot. One of the most interesting things was the renovation of the capitals at the top of the pillars. Evidently, the capitals were coming apart, and so parts of the marble would fall down. And that was a record. People would take those and use them as paperweights. So all the faculty would try to get these pieces off the capitals and use them as paperweights. So what they did was they called all of these pieces back in to try to determine exactly what these capitals looked like. And so the renovation, they went to the original quarry in Italy where these capitals were made and had them redone, brought some artisans over and finished them right in front of the rotunda, and then put them up on the columns, which everybody, the students loved to watch how they did it and to think about, renovating a building like this. So to sort of close this down, my goal was to broaden and make this an exciting experience for the kids. To try to really have some practical instruction for people actually in the business and really talk about a broad party for this. Prior to COVID, my wife and I would always have a dinner party for the students at our house. And that way we would get to know the students and we get to know something about them and try to talk about, my career, talk about how you can really do a lot of things in construction law. And it's really an opportunity. Finally, I've developed now a co-teacher who's going to take over when I finally decide not to do this anymore. So we have co-taught for the last couple. Oh, one more thing. I got the school to basically bind up the AIA documents. You can call the AIA and get copies of documents. So in the book, they often refer to the AIA documents. So this is a takeaway the kids can take with them when they go into practice. So it's been a really exciting time for me to teach this. I've tried to broaden my experience, try to broaden what we cover in this class to make it relevant and for people to understand that there are opportunities for women and people of color in this operation. The lady who is the project manager who takes us on all these site visits, she talks about opportunities for women in construction. I encourage her to do so. And I think that it's an evolving part to teach construction law. And I'm sorry about it. Thank you very much.
So we'll just take Harky's time away.
So, Richard's clients have been accelerating mine for years, so. So I'm Harper Heckman, about 3 hours south of Charlottesville in Chapel Hill, North Carolina. I teach construction law and have for about the past 16 or 17 years. And I'm going to start by just telling you why I think construction is worth knowing something about. This is from my lecture to my kids on the first night of class, and then what I particularly enjoy and how my class is set up. As Phil Brenner said, construction is a huge driver of the U.S. economy, the international economy. And for years, at least 5% of the U.S.'s GDP has been focused on the construction sector. I suspect with the infrastructure bill, that will increase further. 1 out of every 20 Americans works in a construction-related job. It's a growing field. 1 out of every 10 new jobs is a construction related job. It's one of the top 10 sectors in our economy, even with all the onset of technology. Contractors and construction professionals and workers are in high demand. The real reason I think construction is worth knowing something about in construction law, something I enjoy teaching, is because, and with due respect to Sir Vivian, this construction sector is where I think a lot of folks can really realize the American dream. Contrary to what many of you may believe, construction isn't built by these behemoth general contractors or construction management companies. 2 out of every 3 construction jobs is found at the subcontractor and supplier level. 4 out of every 5 construction workers work for a company that has less than 10 employees. So it is really a spot where there aren't many barriers to entry. You can literally hang out a shingle or get a pickup truck, or licensing laws are set up to encourage folks to start small, and we grow the business, and the law grows with them as their business grows. I think construction professionals and construction workers of all stripes are down to earth, earnest people. They tend to, by all measurable data, work harder and earn more than their counterparts that are not in the construction sector. And because the construction industry is so pervasive and doesn't have those barriers to entry, our government has used it as a place to give folks that have been underrepresented in the construction sector, which typically looks a lot like middle-aged white guys, a toehold in that American dream. And I think that is really pretty cool. Why I teach construction law. 16 years ago, I wrote the Dean of Academic Affairs at Carolina, Gail Agrawal. She went on to be the Dean of Kansas Law School, and told her there were 6,000, Arlen may update this, folks that at least care enough to pay $100 and call themselves a member of a national ABA construction section, which is approximately the same number of lawyers that are members of the bankruptcy and the healthcare and the IP and the employment, the environmental and the tax sections, all of which have multiple classes, upper level classes at most law schools. And yet construction law wasn't taught there. So I said, we're underrepresented, and she agreed and said, why don't you teach it? And the rest is history. My class is very industry focused. Arlen can tell you, the construction section of the ABA isn't really a section at all. It's a forum. That means it's industry focused rather than subject matter focused. And I think that you will find that's how many law firms are organizing themselves these days. They want to meet their clients where they are. And so they really organize themselves not so much around disciplines as much as it is industries. And that's really what construction law is. I was on our specialization committee where we studied whether to do a specialty designation for construction law. And we decided not to because it was hard to know what to test on, because some people only file liens and call themselves construction lawyers. Some deal with design defects and that's all they do. Some are transactional lawyers that have never been in court or in arbitration. Some are red meat litigators. So construction really fits all stripes. It's not, I wouldn't say it's necessarily a litigation type practice. My practice tends to be as much transactional as claims oriented these days. And it's certainly the part I find most satisfying. Frankly, what I find most satisfying is the counsel role of what I do with my clients. The truth about teaching construction law is the same as the truth about teaching really any subject matter at law school. Most of the students who are in your class aren't going to go on to be construction lawyers. I teach a class of about 30 students every year, and maybe 1 or 2 end up as construction lawyers. I joke that I'm always educating my competition because I always see them around when they beat me, 5 years down the road. But it does bring me some satisfaction to know, particularly for somebody who started off somewhere else and migrate, they always send me an email and say, hey, I raised my hand when they said, the way I became a construction lawyer, so is my first day of work at my firm, which is got a couple hundred lawyers in the Carolinas. And they said, we need a construction lawyer who's got construction experience. And I said, well, I sold hardware in Nantucket last summer. And they were like, you'll have to do, and that's how I became a construction lawyer. So I try to teach the class in a way that even non-construction folks will get something out of it. And I think construction is perfect for that. Stresses contracts, the things you learned in your first year contracts class about liquidated damages or consideration or warranties and things like that have a particular place in the construction industry. Statutory construction, lien law or the Uniform Commercial Code, damages, ADR, tort law, and economic loss doctrine, and things like that, all are things that I can introduce in a class that has practical skills or practical application of those concepts that you might have learned as a first-year law student and really haven't approached since then. I teach. I have 3 assignments. Typically, I have the students do a contract drafting assignment where I give them we represent one party to an owner-contractor relationship or an owner-design-builder relationship, and I give them a contract that I've made onerous as heck, and I let them try to wade through that and best protect our client's interest. I do a lien drafting assignment where I don't tell them anything. I define what a lien is. That's the only prep I give them. My partner teaches at Wake Forest University Law School, also a good law school, and he lectures on it and then he tells them their assignment. I give it to them cold because I found once I lecture on it, they get 100 papers that are all correct, right? So, I make them kind of walk through the wilderness on their own. And then I write a paper, I have them write a paper. And the paper is such a neat thing, as Richard said, it's where I really stay abreast on the cutting edge topics in construction. I let them write about anything they want. And students push the envelope, and it's not just on, kind of progressive causes like green construction, but really kind of, I remember 5 or 10 years ago now, I had a student write about the use of drones in construction. And I remember thinking at the time, this is some lazy student who's recycled an aviation law paper or something. And sure enough, 10 years later, in Arlen's talking about it at the forum meetings, or 3D printing of construction materials or homes in general. The use of technology, of Bitcoin and smart contracts and things like that. Really, y'all may remember there was a show called Cheers, and they had a character on Cheers named Cliff Cleveland who was a mail carrier, right? And there was an episode where I don't remember if it was a dream sequence or what, but he got on Jeopardy, right? And to his great amusement, every one of the topics was a postal service related topic. And I sometimes think that if I was lucky enough to get on Jeopardy and I was lucky enough to get construction topics, that's kind of what construction lawyers think about as we fall asleep. And I picture, liquidated damages for 500 or CPM scheduling for 1,000 or, differing site conditions for 1,000. And I think I would be pretty good at it unless I was playing someone like Phil. But it's because these students write these papers that I get a chance to read and stay abreast of the things that are cutting edge to students. So I really like it. I do agree with Richard that a rewarding aspect of the job and something that is a work still in process is translating the diversity, which is the current U.S. law school. Which is certainly my classes are probably for the last 8 or 10 years have been female dominated, to getting more diversity in our profession. And it's tough, but we're making progress, I think, slowly and surely. Arlen will tell you, we had a meeting a month ago, and we've always had a women in construction cocktail party. The forum thinks it's important, and we put money towards it, and they get a nice swanky event that men are not allowed to come to. And I've always told our administrator, Tamara Harrington, that as soon as we get to the 51% attendance of women at these programs, we're gonna have a men in construction, program. And we were close this year. I looked around and it was as diverse as I've seen and as young as I've ever seen it as well. So we're doing something right. Thank you.
Well, thanks. And
oh, I do want to mention one other thing. Like Richard, I what the hallmark of my class, or the high point, I guess, of my class is a class tour that I take. We don't have the rotunda like UVA does. We're just our Governor Vance said North Carolina is the valley of humility between two mountains of conceit. So we're just little old North Carolinians. We do have a thing called Carmichael Auditorium, which was built in the 60s, and it's where Dean Smith and Michael Jordan, you may have heard of, learned their skill. And I took my class on a tour a few years ago. They were in the process of converting it after they built the Dean Dome to a more Olympic sports venue. And we had gotten there right after they had pulled an originally installed mirror off of the bathroom wall. And Richard and I are both fellow, we're aligned to the enemy of our enemy, Duke, is our friend. So I got there right as they pulled the mirror off the wall and spray painted on this wall by some construction worker right before they put this mirror up that stayed for 50 years was a big sign that said, Duke #1, UNC stinks, although they didn't say stinks. And they said, well, may the Tar Heels be forever cursed. And I spray painted on this wall and covered up all these years. So I felt like we had just broken into King Tut's tomb and found this. The curse did not work, I would add. Anyway, I've enjoyed it.
Thank you very much. And just before Arlen takes over and updates us on a number of things, I want to go back to a slide that I glossed over because it relates to some things that were just said. And also, I'm going to call later on, if we have time, I'm going to call on the true academics here who have a lot of involvement with the American Association of American Law Schools and ask on the fourth bullet, which one of these things is not like the other? Agricultural law, financial institutions law, law and anthropology, construction law, sports law, law and humanities, art law, animal law. The answer is construction law is not like the others because all of the others have a devoted section in the AALS, the Law School Association, for experts in that field. And of course, the reason is we only have 3 schools where we have full-time faculty. So with that, Arlen, that's me whining about construction law not getting its proper standing in the legal community. You want to read more about that, of course, it's in my paper. But Arlen, tell us what's on your mind.
All right, well, thank you, Carl. I appreciate being invited to speak on this panel. And I just realized after sitting here today exactly why Carl invited me to speak on this panel. Perhaps he's clairvoyant, or perhaps it just worked out that way. But my story of how I became a construction lawyer and how I developed the career that I had is really exhibit A for what we've been hearing all along today about the importance of construction law, about the wonderful opportunities in construction law. I come from a small town in Alabama. I am the first lawyer in my family and still the only lawyer in my family. So apparently I've done a terrible job of selling the profession. And I was interested in architecture. No construction background in my family. I was completely flying blind, as one would say. And so I've got my undergraduate degree in architecture. Perhaps had I known about the Hammurabi Code, I might not have taken that path, but be that as it may, I went to architecture school, enjoyed architecture. What I enjoyed about it was the problem-solving aspect. I also was a fairly decent writer. And so when I was introduced to a class on contracts in my architecture school, that kind of piqued my interest. And I like the business aspect of understanding architecture. And so 3 years into a 5-year program, I started thinking maybe I might be interested in doing something either on the business side of architecture or maybe giving this law thing a try. And so as it turns out, I did decide to go to law school, went to Vanderbilt Law School, where they did not, and to this day, still do not have a construction law course. Now, I joked with my architecture classmates that I'll represent you guys when you screw things up. And I said that purely joking, not knowing that there was a niche for construction law. Went to Vanderbilt thinking, well, maybe I'll do corporate law. The only way that I came to know that construction law was a niche, and perhaps this will age me a little bit, but back in the day, they had something called Martindale-Hubbell books that, you open them up and they had the bios of all of these lawyers. Like I said, I'm from Alabama. And so Alabama schools recruit heavily Alabama firms recruit heavily at Vanderbilt. So as a young, hungry first-year law student needing to find something to do in the summer, I open up Martindale-Hubbell. I start scrolling through the firms in Alabama. I start with the largest, which was Bradley Arendt. And I ran across the bios of Nick Gady, of Mabry Rogers. And there was all this construction stuff in their bio. And so I said, well, look, I've got an architecture degree, I'm from Alabama, maybe I'll give these guys a shot, or maybe they'll give me a shot. Well, they didn't, so I didn't get on their interview list. So I camped outside of their interview room one day, and after they finished their last interview before lunch, I walked in uninvited, handed them my resume and my, and my grades, and said, I'm Arlen Lewis, I've got an architecture degree, I see your firm does a lot of construction stuff. I'd be interested in getting a shot. And that was how I got into construction law. They called me back, and sort of the rest is history, as they would say. So I had the good fortune of being trained by some of the stalwarts in the field of construction law. And I was there for 22 and a half years before I left and started a firm with some other construction lawyers. But I say that to say, had I not stumbled into construction law, how would I have known that that was even an option? I would have missed out on what I think is probably one of the most intellectually stimulating and truly enjoyable practices in the field of law. You've heard many others talk about how many other aspects of the law, construction law, develops. And that is one of the things that keeps it fresh, that keeps it exciting for me. And I think for a lot of construction lawyers, I think they would tell you the same thing. The opportunity to do both the transactional and the litigation and lots of other things in between and the counseling. It's just really something that keeps me going. And so I say that to say that, had there been a class for construction law, perhaps if I'd had a bad professor, maybe it would have turned me off from it. But I really do think that that would have at least opened my eyes and would have opened the eyes of so many other law students who, like me, were wandering in a wilderness, not knowing where to specialize. There's been comments made about, getting more people to get into construction law. And there are a lot of factors that go into that. As Harper said, maybe 1 or 2 of his 30 students end up practicing construction law. Ultimately, once you get out of law school with that crushing debt, you're looking to get a job. And wherever the need is, that's where you're going, and that's what you're going to practice. You've heard several references to the Forum on Construction Law. And as Carl mentioned earlier, I'm the current chair of the Forum. And I'm honored to be in that position because, as Phil mentioned, it started in 1976 with 136 lawyers. And today, it has more than 6,000 members. It is the largest organization of construction lawyers in the world. But we're not limited to just construction law. We are a resource to the construction industry. And I say that most recently, it was evidenced during COVID. When COVID happened, obviously the construction industry, which is an essential industry, but we don't teach about that in law school. It was deemed an essential industry. And our clients, we as lawyers, the executives at our clients, we're all trying to figure out, okay, how do we handle this crisis that's been thrust upon us? Well, the Forum developed a construction COVID roundtable. And this was open to anyone in the construction industry that was interested in coming together and having a forum for a discussion of how do we get to the next step? How do we work through this? And more than 5,000 people participated in a series of construction roundtable discussions. Everyone from CEOs of major construction-related companies to construction lawyers to law students. It was really an industry participation. And in fact, one of our consultants who, whose idea this was recognized by ENR as one of the people of the year for this concept. And so I'm honored to be a part of the construction forum. And fortunately, when I started working at Bradley, they were very keen on, you need to get involved in the forum, because that is where you are going to get, bar none, the best education as a construction lawyer outside of the training that you'll provide here, anywhere in the world. And when I started going to learn how to be a construction lawyer, I checked not only the forum, but I went to various conferences from other organizations, and it very quickly became clear that the forum was where we needed to be, where I needed to be. And the forum does that through 3 things. publications, programs, and people. I won't go into a whole lot of detail, but in each one of those tenets, I'll relate it to how we deal with the law student, how we deal with growing the field of construction law. And so with publications, you've heard several references to a construction law book that is named very creatively Construction Law. And it is used as a textbook in many of the law schools where they do have construction law classes, whether it's being taught by an adjunct professor or a full-time professor. And so we're very proud of that. We also support something called the ACE Mentor Program. ACE stands for Architecture, Construction, and Engineering. This is a program that reaches out to primarily minority and lower income at-risk students to interest them in the fields of architecture, construction, and engineering. The forum has been a long time supporter of that, and we support not only with our financial resources, but our lawyers have developed a negotiation module that's being used at the national level for this industry. So we're all about getting exposure even before people become construction lawyers, if they ever do that. Also, I mentioned programs. Sticks and bricks. We do a lot of programs to assist in bridging the gap that I think a construction law course would certainly help. We do programs on fundamentals of construction law. We do Sticks and Bricks, which is helping lawyers understand the technical aspects of construction. You've heard lots of discussion about how judges and juries wrestle with the technical aspects. Well, the forum provides resources to help lawyers understand that. And we do those we do them every year through multiple cities simultaneously. And in fact, it's sort of become a training ground for many firms, and they send their young lawyers to these programs because it helps them ultimately get up to speed. Additionally, we do 3 national meetings a year. We just finished one in San Diego where uniquely, and I think Carl will enjoy the title that we had, Think More Like a CEO, Less Like a Lawyer. But we really wanted to connect people with understanding the business of construction. We'll be having our next one in New York in May. And in addition to celebrating the 45th anniversary of the forum, which was actually in 2021, we're going to focus on in-house counsel and how the forum can be of value to them. So as I mentioned, we're really a resource to the industry. I do not teach a class. The closest I've come to teaching construction law is where I substituted. I substitute taught for Wally Sears and Jim Archibald, who teach a course at the University of Alabama Law School on construction law. But I think a lot more can be done. And so I'm delighted that we are having this discussion now. Yesterday, I was with my team in New York working on this program. And one of my co-chairs for the program said, we just submitted a petition to the law school at LSU to have a construction law course. And we're not getting a lot of traction. And so I said, well, you know what? I will connect you with Carl Serco because I'm headed to a symposium where that is exactly what we're discussing. So the people in this room are not the only ones who recognize the need for it. So with that, thank you, Carl, for the invitation.
Well, thank you. And before we turn this to David Grace, who is our leader in reacting to all of this, from Andrea on through Arlen, I want to say first 2 things. First of all, and Arlen knows, I think Harper and Richard know as well, that there's a devious plan behind this entire conference, which is I want to encourage an ongoing dialogue between the practicing construction bar and legal educators and legal scholars. And I think that is not going to happen because legal educators make it happen. I think the practicing bar is going to make it happen. So this is not the last you'll hear from me. And Arlen, you have a standing invitation to be a guest teacher in my class anytime. So the other thing I did want to mention, well, I don't want to take extra time, but let's see if David can get it started on some reaction. Why do we teach construction law? And what about Andrea's conversation? What does that have to do with teaching law students about construction law? So how about that for David on the spot?
I think Carl wanted me to
be on this panel because he wanted me to stir up some sort of controversy. But, you know, one of the things that I learned being a lawyer that I didn't learn in law school was that you have to pick your spots, okay? And I'm gonna have to tell you that I'm not the guy that's gonna sit here and look at everybody in this room and say that I don't think it's a good idea to educate law students about construction. I actually think it's a pretty good idea. You know, when I was in law school, a long time ago in this building, before this part of it existed, they didn't teach anything about construction at all. They taught admiralty, and they still. But
Tell the audience who taught that.
as I remembered, it was Bill Clinton.
It was Bill Clinton.
Well, there's another story about that, but we won't do that. But no, admiralty was taught, construction law, not so much. I can tell a short story about how I got into this area of the law. I was hired by a small firm, 3 people. I was the 4th. After I'd been in the firm as an associate for a few months, one of the partners stumbled into an opportunity, that opportunity being a chance to represent a bonding company, a construction bond surety that wrote bonds through the SBA Surety Bond Guarantee Assistance Program. And those of us who are old enough to remember that program know that the companies that wrote bonds in that program were pretty much willing to write a bond for anybody with a pickup truck and a shelter. And so there were lots of bonds, and we had a chance to represent these companies. And because I was the low man in the firm and the other guys kind of had something to do and I had less, I was told that I was going to be a surety lawyer. Now, my preparation in law school for representing bonding companies was exactly nothing. The first payment and performance bond that I ever saw in my life was the one that came in the file when I was hired to represent the bonding company that executed and delivered that bond. That was it. That was my preparation. I went back and found my case book from contracts to see if there was even a mention of such a thing in that contracts case book. And I found a mention back in those days, the case books that we had that have a case that have this questions for extra, discussion or whatever. There were 1, 2, 3. The third one, after one of the cases, made a glancing reference to the existence of construction bond surety. That was, I didn't read that note. I didn't read the case that was referred to in that note when I was in law school. My fault. So I had what you might call on the job training. From the day that I saw that bond in December of 1977 until this day, I have done something in connection with construction bond surety every single day of my practice. Didn't have any idea what was going to happen. So I'm a big fan of getting education about this. I think, for what it's worth from the practitioner's standpoint, first, that any law student who thinks he's going to go through law school, develop a narrow specialization, and figure out a way to turn that into a meaningful job opportunity in Arkansas is kid loose. I mean, you've got to be able to have a broad enough perspective to practice law in this state and be able to do more than one thing. You may eventually get to a place where you can convince people that doing one thing is enough for them to pay you to do it. But when you come out, it's not going to happen. But construction law, as I understand Carl's paper that I actually did read, the idea is, number one, that a broad construction law course, like the one in the book, the construction law, the form of the construction industry book, it presents a broad perspective of all aspects of construction law. And it's the same kind of course that would be helpful, like a bankruptcy law course is. You learn a lot of stuff in the bankruptcy course, and it's a helpful education. Construction law is like advanced
contract and tort and remedies, civil procedure and evidence. Dispute resolution is advanced approaches to all of those topics. You learn more. You see how they connect. It helps you get a big perspective on how to be a lawyer, how to advise people about a whole lot of different things. Because when you're a lawyer in private practice, somebody comes to you and asks you a question, there's going to be a whole lot of answers to it. You have to be able to see past the question to the whole problem and understand and prepare for all of it, not just the question that was asked. You can't do that in learning about consideration for a contract. You have to see how contracts fit together. Construction law, we've talked about this all day. There's a whole lot of parts in any kind of construction problem. Basic construction law teaches that. This book, the construction law book, JB knows this. 10 years ago or so, the construction law section for the Arkansas Bar Association is very active. We teach a seminar every year. We've written a construction law manual. We're going to teach a seminar next month on all sorts of topics, trying to educate the bar about stuff like this. But 10 years ago or so, somebody, I don't know who, discovered this book. And we had the idea, the members of the construction law section in Pulaski County, which is not many. One thing about Arkansas, not a lot of people do a lot of this. So a lot of people do a little bit of it, but the ones that do a whole lot of it, I think I know every one of them. And there's probably not 20. So, and half of them at least are in Pulaski County. So we all got together and decided that we were going to teach ourselves this book. So we got a discount, bought a bunch of copies, and convened once a week, more or less, for several months. We assigned each chapter to a different person. We got in a room and we studied this book from the front to the back, every chapter. We learned something. We brought people in to explain stuff we didn't understand, like, CPM scheduling and that sort of thing, which nobody understands. So we brought in somebody who pretended to and got them to explain it to us. And it was a wonderfully helpful experience. And I've been doing this for 30 years at the time that we studied this book. But to get it all in one place, all at once, more or less, from all those different angles, it's a wonderfully helpful experience, which I would recommend to anyone. And, so to be a student and to get it on the front end has to be a good idea. And as Carl also said, and as I think is true, this is transferable information. I mean, you can learn a lot of stuff in that book that you can use in a lot of places. It's not exactly what you'd call construction. You represent a bank, there's a lot of stuff in there you want to know. It's obvious, I guess. So I'm a big fan of education. So I'm not sure that I'm going to be able to stir up much controversy.
I brought in the wrong guy.
I failed you and I know it. As I explained to Carl, we had a previous seminar where Carl and I were on a panel together, and it was my job to stir up trouble. And he said something that gave me a good chance to. And that goes back to that picking your spots thing. That's one of the things you learn in practical experience. It's hard to learn in the books.
So of course, I'm a housekeeping guy. Do we have a code word that I'm supposed to speak? This is, okay, the code word, oh, that's a great one. The code word is fiddle, Fiddle. So this is for those on Zoom who are claiming Arkansas CLE credit, fiddle, Fiddle. And I'm wondering, we hope we get some conversation because we can stay around a little longer. But are you going to make a tie in here?
I actually was trying to catch your eye to say, let me.
Because I couldn't do it.
No, I mean, at first you're like, what in the world is she's talking about condominium governance? And I have to say at first, when I talked to Carl about coming to do this, I thought, am I going to be like the one of these things is not like the other? What is she talking about? Because I've never considered myself a construction lawyer. I've never taught a construction law class, but I am a real estate lawyer. And I'll tell you that I had a similar experience that David described, and that, you know, I realized once I got into practice that everything I needed to know, I hadn't learned at all, and I had to teach myself. And one thing when I went back after 14 years of teaching is I started to do is I thought to myself, okay, what is it that I wish I had known day one? And that's been my sort of whole star in trying to figure out how to teach my classes. And I've taught other classes in real estate. I've taught a real estate transactions class that is very hands-on, like commercial leasing, housing. But you know, one thing I realized as throughout this conference is that I actually have been teaching some construction law, and I just never knew it because I had, for example, in my real estate transactions class, our last big project that we do this big tri-party negotiation between a construction lender, a permanent lender, and an owner. Gosh, that sounds like construction law, right? When I'm teaching contracts, I'm talking about subcontractor bids and how that works. That sounds like construction law. And I started realizing I teach property and I teach contracts and I teach real estate, and construction law is just applications of that, plus applications of tort and a bunch of other things too. And then there's this business of law issue. And so I do think that there's a lot to be said for reimagining the curriculum. And the one thing that my experience here has done is shown me how even in the places that aren't teaching construction law, there's already nexus. It's like we have they talk about the law being a seamless web, right? And I like to think that when we're talking about classes, we artificially cut the web up into little puzzle pieces. But my puzzle piece has little parts that stick out that connect into construction law. And many, many, many other people in the academy already have pieces that stick into it as well. So we need what you need to do, Carl, what we can do. And now that I've been converted, I feel like I've seen the light, I think it's to explain that this isn't some foreign thing. This isn't something that, okay, like you said, muddy boots. This is in the middle of what we're already teaching. This is just a missing piece in the puzzle, and it's going to neatly fit right there. And so when I'm talking about governance structures, that has something to do with it. When I'm talking about lending structures, when we're talking about liens or relation back, as Dale talked about, all of these things, we're talking about how we're going to litigate versus arbitrate. These are issues that we're already talking about in the academy, that we already have in other curriculum. And this is just another way to tie that together so we can actually complete the puzzle of the seamless web and not leave holes in the middle. That was mine.
Thank you. Harper, you have something?
Oh, I was just going to add one thing that I thought of as David was talking, that I probably have underestimated the number of my students that go into construction law. And in this regard, and this may not be true at every law school, but if you're at a flagship state university law school, take like North Carolina or I suspect Arkansas, for every 5 students that go to Charlotte or Raleigh or Greensboro, some larger municipality, 5 of them are going to go to Eastern North Carolina or to the mountains of Western North Carolina and practice in a small town where they're going to hang out their shingle. And every town has got speeders, so you better know how to handle a speeding ticket if you're going to hang out your own shingle. And if 1 out of every 10 or so new businesses is a construction-focused business, you're going to need to know how to file a lien. And I bet even when Arlen hung out his own office, even after 20 years of practice at a prestigious, elite firm, I bet, that is the one thing that's common to everybody is getting paid. And so I predict that these folks may not call themselves construction lawyers, they probably call themselves general practitioners, but I guarantee they interact with the construction sector.
Yes, Phil, please.
May I just add, when I started practicing, which was now 55 years ago, and got into construction actually through Air Force JAG, but the one thing that all of the young lawyers would say who were kind of practicing in this area is, well, construction law, what is it? It's everything except the practice of dentistry.
So how about others in the audience with questions or comments? I realize that Justin will tell me that our time is up, but we reserved 10 minutes, I think, for a closing remark. We don't really have any closing remarks. Turn your evaluations in and don't forget to get the credit. So how about from the audience? Anything else?
I want to commend you all for your presentation. It's just wonderful.
And I thank everybody. I think when I was creating my dream list of speakers, it never occurred to me that you would all say yes. So thank you very much, and thank you all. Let's give this panel a
Like Professor Sarko said, just be sure to turn in the CLE form, the evaluation form, and feel free to come down and take some of these flyers that are up here as well on construction law books and materials that the presenters have written throughout their careers. Thank you all.
Thank you, Justin.